Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please, verbal slap.
Literally not. Is that correct?
I didn't ask you to interrupt me. Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I'm the Recovery Addict. It is wonderful to have you all here this morning. Happy Thursday. We're on Podcast Thursday. We made it all the way to Podcast Thursday. I have to check in with the Weather Watch and make sure he's not under the weather to make sure everything's going forward. But hope he's feeling better. He has had a little spell of not feeling good. So as it seems like all of us have to some degree or another in the last 2 weeks. All right. Let's turn the music down. All right, it's still a little early, guys. No time to party yet. I have to say, would you look at this? Welcome to Kim Caltagirón. Is it Caltagirón? I probably butchered your name, Kim, and I apologize for that. Kim Caltagirón. Kim, it's awesome to have you here. You're the very first person in chat this morning, and you said good morning. So you're here first. You've got this bright-eyed, bushy-tailed, like chipper little good morning with an exclamation mark. Clearly, you have a lot of energy. You're ready for the day. You're up and about and accomplishing great things. And I figure who better to punish for being first in chat than you? Because clearly you have enough energy. You understand how the internet works by demonstrating your proper use of it. We're going to sentence you to internet ownership as a punishment for breaking the silence of chat this morning. You are responsible for everything worldwide that is IP related. If there's a problem with it, they will call you. You'll know it's a problem because your phone will be ringing, and that's your problem. So, congratulations, Kim. I realize you're brand new to the channel, and I sort of feel bad, but at the same time, ignorance of the law is not an excuse. If that's one thing we learned from watching court, that's it. And let's see. You took it in stride. Thanks, everyone. I've been enjoying the stream and chat. It's time for me to step up and carry the load for a day. Kim, you're going to do great. Make sure you go over to the YouTube shopping page on our YouTube page and scroll around until you find the Internet Ownership Certificate. Because you can, in fact, now, legally, download your own copy of Internet Ownership for the low fine of just 50 cents. And you can download that certificate. It comes pre-signed by myself and my boss, Mrs. R.A., all you have to do is fill in the blank with your name, and then you will have your own Internet Ownership Certificate. How many people can claim that? I mean, a few now, but percentage-wise of the population, it's a small population. But it's suitable for framing and or use as a cover sheet for your CV. So, Kim, congratulations. You're going to do a great job. Welcome, everyone. A little bit late this morning. Got the kids running to the dentist, and that's always a fun day when you schedule all the dentist appointments on the same day. So, Mrs. R.A., you're my hero. Just know that. So, yes, good stuff. Good fun. All right. Connor, good to see you. I didn't actually see you. I just saw Amber saying hi to Connor. So, good morning, Connor. Great to have you here. Kimbers Ohio, a member for 22 months, says, thanks, RA, for all you do. Kimbers, 22 months, one of our OGs. Thank you very much. Appreciate it. We have a little bit of business to take care of before we jump right in with a little bit of court hopping to some of our old favorite courts. I guess Judge Simpson is on one this morning. He's in a good mood, but he's got a lot of work to do. And if anyone gets in his way, steamroller mode's going to come out. So we might want to be there for that. Josh says we have D Nice and Precious Freckles celebrating their birthday today, which
Happy
means
birthday.
Thank you.
You look good.
Mm-hmm. Judge Fleischer just weighed in. How many people get that on their birthday? So what we're going to do is we're all, like all of us, I don't care where you are. I don't care if you've never sung before. Today is the day to sing. We're all going to sing together to D-Nice and Precious Freckles. You do this by first standing up, taking a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me, if you will. La 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 la. There we go. We're all ready. Dancers at the ready. We're going to sing to D-Nice and Precious Freckles. And Kimar. No. Happy birthday to you. Happy birthday to you. Happy birthday, D-Nice, Precious Freckles. Happy birthday to you. Kimar, congratulations on 24 months with your hubby. Kim, thank you very much. Great supporter of the channel as well. To all those who are celebrating their birthday today, I realize there are many special days throughout the year, but this is your special day. The privilege, the pleasure, the honor is all ours that you chose. Of all the people to celebrate with, of all the places to be, you chose to be here with us. Hopefully we can turn that pleasure to you a little bit and make your day a little more special. Wasn't a good mood. Okay, we're gonna have to check in the judge in just a minute. Help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Bob Evans, Tammy Dunlap's house, and Andy's Grill. Yes. Happy birthday. Precious Freckles, thank you so much. Thank you for sharing your birthday with us so we can celebrate with you. It's wonderful. Kimar, congratulations to your hubby as well. Both of you. You both deserve congratulations. That's really cool. I've been hearing all the info coming out about the Idaho 4 case. Oh, about the DNA under the fingertips and how the defense wants it thrown out. That's a bad sign. It's a bad sign for the defense. It's a good sign for us because it means there's some juicy info there. Yes, we've been hearing that also, that he wants to have the death penalty thrown out because he wants to use the autistic exception. Is that a thing? Says on the autism spectrum, so that makes him ineligible for the death penalty. We'll see if that works. Obviously, if that is a thing, I think they might have a legitimate claim there. Kimar, member for 21 months. Oh, drum solo's coming up. Everyone grab your air drum stick. Sit down to your air drum set. Help me finish off the song in style by hitting around the toms and then bang the cymbals at the end. Just follow along. You'll know what to do. Here we go. Beautiful. Beautiful. Thank you very much. Happy birthday to all those who are celebrating. Happy podcast birthday. Kimar, member for 21 months, says, OMG? Or is that OMG? I'm not sure what you meant there. OMG. Today is my RA day too. 21 months here and 24 days with my 24 years with my hubby. Yay me. Thanks, RA. Love it here. Kim, congratulations. You've got 2 anniversaries on the same day. That is great. DNA under the fingertips. Yeah, this is what we heard is that there's mixed DNA, like 3 people under the fingertips of one of the victims. I can't remember which victim it was. This is in the Brian Koberger case up in Idaho, where the 4 college students were stabbed to death. Mixed DNA. Why would there be 3 people's DNA? Especially, this is going to be the interesting part, if it turns out that some of that DNA does not belong to anyone in the house. Makes you think. How long has it been since you had a day without any birthdays? We've always found one to celebrate. Even if we had to stall for a little bit and search the internet and celebrate a famous person's birthday or somebody who is from history, we've always sung to somebody. Statistically, we've got enough people. There's someone to have a birthday every day. She could have given someone a back scratcher at the bar earlier. It'll be interesting to see who it is and if people come forward. And yeah, that DNA is going to be an interesting. If the defense is able to exclude it, it's not going to be interesting at all. But I don't think. First of all, why in the world would you be able to exclude DNA from under the fingernails of the victim? Honestly, unless there was something so egregious in the way it was collected, in the way it was stored, the way it was transferred, documented, you would have to need something worse than red Solo cups in the chain of evidence to get the DNA from under the fingertips thrown out from a murder scene on the victim. I don't think defense is going to win on that one. You should do a birthday calendar. We have a birthday calendar. It's just kept on our side. You can put stuff on, I think, ahead of time. And the links are about. Our mods will periodically put them, especially on the Facebook page. Am I right that we won't hear more of the Karen Reed case until the end of the year? No. Nope. The 18th is the next hearing for Karen Reed. Corey Richens, the end of the month. They're both coming up. Amanda H. Today is my daddy's birthday. Happy birthday to Amanda H.'s daddy. Thank you for sharing that as well. All right, we have a little court we want to jump into, and I don't know what's happening exactly right now, but Judge Cedric Simpson has said he has 140 some odd cases to do today, and he's in all business mode. So if somebody causes him a problem, we're gonna hear about it. So let's jump there right now. See what case.
Court calls the case of the people versus Tyve Mills.
Andrew Childers preparing on behalf of the
Good morning, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Mr. Tyve Mills. Mr. Mills, please state your name for the record.
Tyve Mills.
Thank you. And Judge, just for the record, Your Honor, I did substitute in on all three of these matters very recently, Judge. I would just ask I be assigned to each case, Your Honor.
Well, you're retained.
Retained counsel, Judge.
Do I have the orders?
Well,
okay. All right, you're in.
Thank you, Judge.
You're in.
So you're requesting an adjournment?
I am, Judge. Today's date and time scheduled for PCC. I need discovery in all three cases, Judge, so we're asking for a new probable cause conference.
You want 2 or 3 weeks?
Judge, can we get 3 weeks, Your Honor?
Probable cause conference will be March 27th, 2025, 9 a.m. Bond continued.
So, may I very briefly address bond?
Briefly.
Judge, just very briefly, Your Honor. My client, he's 20 years old, Your Honor. He did have a prior case, but that was under Hyder. He successfully completed that. Judge, I understand these are very serious charges. The bond is $250,000 cash surety.
Whoa!
I would ask the court to consider, at the very least, Your Honor, a 10% condition with a tether, Your Honor. His family is in court. He was working prior to being arrested in this particular case, Your Honor. He would have no contact with the law, and with the tether, he can be monitored and tracked, Your Honor. So we're just asking for a 10% provision with a tether.
Response from the people.
Your Honor, the defendant was charged in, I believe it's 25 Act 10203. Among other things, possession with intent to deliver meth, felony firearm. The defendant was producing Glock switches using a 3D printer as well as ghost guns. When the police went to arrest him on that warrant last week, he attempted to flee, crashed into an MSP trooper, was involved in a chase with Pittsfield police. When they eventually apprehended him, he was again found in possession of a firearm. During that chase, subsequently searched his home and found more with, I guess you would call, molds in producing these ghost guns, as well as suspected controlled substances. So obviously, he's not only a danger to the community, but also a flight risk. I'd ask that bond remain as currently set.
Or raise it.
Anything further, Coach?
Nothing from the defense counsel.
Motion for bond reduction is denied. The court does consider the defendant a danger to the community and certainly a flight risk also. Bond will continue in each of these cases.
Distributing
Thank you very much, John.
Manufacturing and selling ghost guns. Got in a police chase, slammed into a cruiser, and you have the nerve to stand up there and say he's a good kid.
Court does call the cases of the people versus Samantha Warren.
Andrew Childers preparing on behalf.
Edward Drucasumpi, Samantha Warren.
Oh, she's got an owie on
Private
her arm.
First Class Samantha Warren.
Thank you.
Yeah, no, there's some negotiations that are still going on. I'm asking for an adjournment in this case. In all 4 cases.
Hey, Ann, good morning.
How much time did you need?
At least 2 weeks, whatever the court's preference is.
March 27th, 2025, 9 a.m. Bond continued.
Your Honor,
Thank you, Your Honor.
my client is an entrepreneur. He can't run his business from inside jail. The 3D printers don't run themselves. I mean, you have to load those things with filament. Who's going to deliver all the ghost guns if he's?
Court does call the cases of the people versus Jeffrey Stoops.
Alexander on behalf of the people.
And Edward Drucas on behalf of Jeffrey Stoops in the 1740 matter.
And good morning, Your Honor. Assistant Public Defender Chinaze Kariak and Rui on behalf of Jeffrey Stoops on the 1740 matter.
Good morning. My name is Jeffrey Allen Stoops.
In the 1740 matter, I'm looking to obtain video in the situation, so I'm asking for an adjournment.
Yeah, 3D printer. The
And
world
Your
is
Honor,
your
in my
oyster.
matter, we would be requesting an adjournment. We want to see if he would be eligible for recovery court.
Ooh. I like
Probable cause conference in these matters, March 27th, 2025, 9 a.m. Bond continued.
Good morning, Indiana Auditor. Good to have you here.
Thank you.
Had a dream last night, says Culperistic, where you were doing a live stream in a car by yourself and you were driven off the road into a large ditch by a big truck.
Court does call the case of the people versus
It's really
Elizabeth
close to
Black.
reality. And thank you for the super sticker.
And good morning, Your Honor. For the record, Brendan Dvorsky appearing on behalf of Elizabeth Black, who's standing at the podium to my right. Ms. Black, please state your name for the record.
Elizabeth Black.
Hands out of pockets.
Your Honor, today's date and time set for a probable cause conference. I was just retained on this matter this week. I filed this substitution of counsel yesterday. Spoke to the prosecutor today. We're just asking for an adjourned probable cause conference. I've explained to my client the 14-day rule, and she is voluntarily waiving that. Is that correct, ma'am?
Yes.
March 27th, 2025, 9 a.m.
Your Honor, I'm going to be out of town that day. Is it unless it's possible I can do it via Zoom, but if not, can we have the 3rd? Is that available?
Judge doesn't like him requesting dates.
April 3rd, 2025, 9 a.m. Bond continued.
Now you've got a grumpy judge. Now can we address Bond? Just kidding. No, she's already out.
Court calls the case of the people versus Shane Young.
And then on behalf of the people.
Morning again, Your Honor. May it please the Honorable Court. David Burgess on behalf of Shane Young, who's approaching via wheelchair.
Little slurp for the judge there. Sorry, Judge, that was me. See, he's clearly not a flight risk.
Let's freak him out. He's already in the chair. Just state your name, Shane.
Shane Allen Young, 3183.
And I guess your birthday.
Discovery is complete in the matter requesting exam date, Your Honor.
People have their witnesses available the 18th.
We'll do our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you.
This girl in the blue has been waiting all morning.
Court does call the case of the people versus Shayla Gilden.
And then on behalf of the people.
What are we doing with?
It's a crowded court this morning.
Yes.
She has a massive iPad too. Oh, she left.
Can't have these facilities waiting.
Where'd she go? Pass the matter.
What are we doing?
Good morning, Your Honor. Sydney Rushing appearing on behalf of Ms. Gilden, who's approaching to my right. Your Honor, I apologize. She was in the hall because the courtroom was full. Can you state your name for the record, please?
I'm Shayla Gilden.
Thank you.
You take your hands out of your pockets. What are we doing?
Your Honor, at this time, we'd like to schedule this matter for a preliminary examination.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 18th.
We'll do our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you so much, Your Honor.
Thank you. Court does call the cases of the people versus Rebecca Elledge.
Morning, Your Honor.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Ms. Elledge, who is approaching to my right. Ms. Elledge, can you state your name for the record? Loud and clear, please.
Thank you.
Your Honor, at this time, we'd like to set this matter for a preliminary examination.
Cases.
Yes, Your Honor, and discovery is complete.
People have their witnesses available the
cases here.
18th.
Yes, Your Honor.
This is oftentimes the first time we hear about an interesting case that we want to follow.
March 18th, 2025, 9 a.m. That is before Judge Barr. Bond will continue in this
address
case.
Bond.
Thank you so much, Your Honor.
Thank you.
Nope.
Court does call the case of the people versus DeRera Collier. You know who I'm talking about.
Yeah, she's been waiting
Andrew
all
Childers
morning.
appearing on behalf of the people.
Albert on behalf of Ms. Dea Collier. Good morning, Judge.
Thank you. Ma'am, state your name.
Dea Collier.
Thank you. She's waiving right to preliminary examination.
That's correct, Judge. We are, there should be a waiver form in your file.
I've got it in file. Ma'am, is that correct?
Yes.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was, or the offense is, well, the offense alleged was committed and that you committed it. You understand that?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
Michigan Department of Corrections. So
People also waive their right.
Yes, Your Honor.
Defendant's bound over to circuit court in this matter.
Thank you, Judge.
Camping sounds awesome, Allison.
Nothing.
I love
Your
it.
turn.
Sorry, Judge.
Do you waive formal reading?
Yes, Judge.
Does your client stand mute?
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for.
He said the part the lawyer was supposed to say.
Your
There.
Honor, my microphone turned on working.
Oh, now they're on now. Are you picking it up?
Is this?
What was that date, Your Honor? Sorry.
March 26th. And that's Conlon.
Yes.
All right. We'll repeat it on the record, but she doesn't have to wait. Ma'am, you can hear me?
Yes.
Okay. March 27th, 2025, 9 a.m. Where Judge Conlon found continued in this matter.
They were
Court
worried the
will
mics
stand
were
in
not picking up, so
recess
she would not
while we
hear
try
it.
to get this. So
She has the right to get those. She has the right to hear that. So, the funny part, he said right there. I talked over it. Maybe I can play it for you. The judge, like it's your turn. Let me bring it in real quick. Let me back up to it. Which one was it? It's going to be this one right here. Okay, here we go. We're going to play it right here. Oh, that's the wrong one. You need to be able to see what I'm seeing. Clean feed to HDMI. There we go. Bing. There you go.
Yeah. He really said it.
Wow, that was loud. And why did it jump all the way back to the beginning? We're supposed to be way up here. Okay, right here.
Thank you, Judge. Nothing.
Your turn.
Sorry, Judge.
Do you waive formal reading?
It's your turn.
Yes, Judge.
Does your client stand mute?
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for.
So what happened there was the lawyer is supposed to say my client waives formal reading, stands mute, and the judge is like, it's your turn. This is the part you say. It's like a. Sorry, that's the replay machine. We like to be able to rewind and see what just happened in court. And it's not the same. Just dragging the arrow back on YouTube. All right. It was extremely painful. Yes. It was. Got a hot mic in the jailhouse. All right. If they're going to take a while, they're trying to fix the microphone issue in the courtroom, which is why they're having just a little break. So tech is taking care of that. Give me a second. We may bail on Judge Simpson. We do have a case coming up today in Thurston County, Washington. No. Yeah, you can go. You're done, ma'am. You're all done. Thurston County, Washington's a fun one. Let's see if we can jump down to Judge Boyd, who is busy doing her thing today. Let's see. She just started. Let's see, that comes in on 7. Let's try that. Can you hear it? Oh, you can't.
Yeah.
Now we can.
All right. So here's the thing. When I call names, it's for people who are on the docket. So if you're here for a relative, no announcement is needed for you. From you.
Okay. Thank you.
All right. And sir, that mask doesn't work if your nose isn't covered. All right. So here are the rules, everyone.
Uh-oh.
We're going to start with a jury trial closing argument. So that's going to go first. So if you have someone who is in custody, they're not going to be brought out yet because we're going to do closing arguments. If you are here for a friend or relative or whoever it may be, do not speak to the inmates. If you speak to the inmates, what's going to end up happening, you're going to get tapped on your shoulder. No conversation is needed. When a deputy taps you on that shoulder, that means that you are to leave the courtroom.
You're it.
You will only be allowed back in this courtroom if you are called as a witness. Everyone, please confer.
So she started with a jury closing.
I'm going to call.
I don't know what case she's handling. Did anyone follow what case she was handling yesterday? She does handle some wild ones, but she's already in a little bit of a mood. Not putting up with any crap today, for sure. Silver Swag, good morning. Good to see you. The chin mask does not work. Oman Ra, probably not. Some Zoom courts, if I have to connect to the Zoom to live stream it, I need an order from the judge really to protect me there. Let's see. Let's listen to closings cold and solve the case based on the lawyer's story, says Red Ben. I'm up for that. Of course, she just took a little break, so we're gonna have to wait for a minute. Let's jump back to let's see, nothing's happening in either one. We'll keep an eye on Judge Boyd. Where's my controller? Oh, it's right here. I have all the power, but if I lose the remote, I have none of the power. Let's see, Judge Simpson, Judge Boyd. The Office reruns. I'm not sure why I get that one. Let's see. How about this guy right here?
Of bond, they got a calendar conference
Detroit,
scheduled.
36th District.
Today?
I'll keep an eye on Stephanie Boyd. We'll be back with her in a minute.
I'm going to set bond at 30,000 personal. Mr. Turner's going to have to straighten this out. He's got a bond, I think, right now before Judge Blount on a case that's supposed to be scheduled for today, and I'm going to call Judge Blount to let them know that he's in Wayne County. Everything that I've had indicates that, you know, especially around that time, late September, early October 2024, we did not have the best records with Wayne County Jail as far as who was in and where the folks were at. So my assumption at this point was that Capias was in error, only from the information that I have.
Sorry for the whiplash, but she just restarted her live stream. This is going to be the jury closings is what we're expecting here. And we're going to do what Red Pen suggested. We're going to listen to the jury closings cold, meaning we have not heard any of the evidence. All we hear is the stuff that is not evidence. And let's go ahead and determine. No, she didn't restart it. Bummer.
And that's why he's in custody right now.
I have a violation hearing on that already took place January 24th. And he was.
What am I looking at?
Yeah.
So interim bond granted, and now he's got a calendar conference because there's a violation of the bond was set, and then a calendar conference is scheduled today in circuit court. Today is the 6th.
Today is the 6th. I see the calendar conference. I see that on January 24th, he was given that 20,000 10% with the tether. But if you feel comfortable with that, I'm just seeing that there are multiple failures to appear in that particular case. There's failures to appear in the Romulus case. We have failures to appear in this case stemming back from May.
We'll skip that one then.
Recognizing that, but if the last case, the last failure to appear was because this person was in custody, then the KP shouldn't have been entered in the first place. That's why I'm setting the personal on this.
Yeah, you know what I think? Okay, this case doesn't show that he was in custody on 10/16 of 24 when he failed to appear. This particular case that you and I are both talking about, he was just on a personal bond at that point. He wasn't.
He didn't get a tether on the beginning of the September 30th date.
Nope. He ended up getting a 10,000. Oh, you know what? Strike that. It appears as though, he ended up. No, here's what happened, Judge. You can see this too. The April 22nd of 24, he was arraigned. He was given a 10,000 personal, but then he failed to appear. It appears as though at exam, he was issued a $10,000 cash assurity, and then he was arraigned on that. What you said, November 25th of 24. But all that means is at the time of our failure to appear 10/16/24, he was on warrant status because he was arraigned on the warrant in the circuit court case November 25th of 24, which means he got picked up after he ended up failing to appear in our case, October 16th. So he does have a lot going on. He's got a lot of failures to appear. I guess the only thing to expedite this, Judge, are we going to give him monitorization or are you just going to give him a personal bond?
I'm giving him personal because he's got monitorization from the circuit court on the January 27th date.
Okay. You know what?
In all likelihood, he's going to be in custody until the next hearing date because he's got a cash bond on that one.
It appears like it, or at the very least a tether. So, yeah, I agree.
All right, bond is set 30,000 personal. Mr. Turner, your next date is going to be
it's going to be what?
March 12th before Judge Giles on this case, but it sounds like you got to be over in circuit court today with Judge Blount.
Okay.
All right.
Judge,
that concludes the hearing. Good luck, sir.
Judge, hopefully we can get in contact with Romulus so then he's not going to get picked up on that warrant as well, because there's a warrant out for his arrest. If he does get let out, he's just going to get picked up again. I don't know if we can do anything about that, but.
Well, Romulus won't pick him up for a non-assaultive felony. It's just the way it is. But we'll definitely let him know. I'll send an email, and if you can send an email to Wayne County, let them know.
I will. I'll put something in the notes.
All right. That concludes the hearing. The gentleman. Oh, Mr. Byrd, do you have anything further?
Yes, Your Honor, please.
Go ahead, sir.
First of all, my client was just wondering, is there any possible way it could be transferred from one tether where he only has to wear one tether, or if he's going to have to wear two tethers? And also, he does suffer from multiple physical conditions, which, because we're on YouTube, I'm just not trying to state. But serious.
If you wanted to have a private conversation with me to fill me in on the medical conditions, I'm happy to do that with me and the prosecutor.
If I can, me, you, and the prosecutor, if I can, please.
All right, we're going to the breakout room.
Thank you.
They're going to run to the breakout room. Okay, Okay, so the case that Stephanie Boyd is doing apparently involves children victims, which we're going to skip that one because it's not going to be pretty. Double tethers balances the weight well, says Krista Johnson. That way you don't get like a strong leg and a weak leg from carrying around weight on one side. It is funny to go from one state to another and see the difference in how bonds are applied, how the fee schedule is set, just the standard. What's the standard operating procedure for various crimes, and even though it might be the same crime from one state to another, how it's handled is very, very different. So know which state you're in when you commit the crime, so you know what the penalty is. It's a brand new jail. People need to mute their mics. I don't fault the guy top right hand corner. He's got guards that are yelling and talking and stuff. It's not his fault. It's the guards that need to be quiet. What's the judge is just standing there? It's a standing Zoom? Apparently it is. Criminals have SOPs? Yeah. Rinse, wash, repeat. Yeah, county by county is different. Judge by judge is different. Good morning, Lynn Godwin. Welcome. Good to have you here. Tether for you, tether for me, tethers for everybody. It's like Oprah. You get a tether. You get a tether. I thought Boyd was just a robber. I'm hearing there were child victims. Is that not the case? Let me go back and look. Let's see. Judge Stephanie Boyd. She's not live currently. Like, she killed her live and has not come back. A lot of these are probably arraignments, first appearances type thing. Somebody who was just recently picked up. Unless, of course, we're in Georgia, and then, it could be a year or so before your first appearance. Sorry, Josh. Georgia, of all the states, takes longer to go through their acceptable waiting period before you get to see a judge or before you go to trial is incredible. I mean, if you get picked up on a charge and can't afford a high-priced lawyer to file whatever you need to do to get it moved along, you could sit there for a year. No indictment. So, you're tired, Northwest? We're waiting a little bit. It's going to take just a minute before Thurston County comes online. We've got a case. We could go back and watch the motions in limine for that case coming up, but it's a tenant-landlord issue gone bad that ended in a physical altercation, and it's all caught on video, which we probably won't see. Quite honestly, I'll spoil that for you here, so we'll get to hear the altercation. All right. Fourth-degree assault, malicious mischief are the charges. So we had jury selection yesterday.
Good morning, Judge. Good morning, Madam Clerk.
Josh, sorry, I misread this.
Hold tight, Mr. Nasir.
Did they already do opening statements?
Judge, how are you?
Because we'll go back and watch.
I'm good. This. Back on the record in the state of Michigan versus Sharp. I'm having discussions with the people in representation on behalf of Mr. Sharp. I will allow an exception for medical treatment, any medical treatment that the defendant is receiving or is to receive going forward.
Thank you, Jan.
All right, that concludes this hearing.
All right, So no two tethers for you.
All right. Mr. Nasir, can you hear me?
I can, Judge. Good morning. How are you?
I'm doing all right, sir. Which case is yours?
Ronald McRipley, please.
One more time.
McRipley, Judge.
Okay. Mr. McRipley, can you hear me?
Yes, sir.
Mr. Nasir, are you ready on that case?
I am, Judge.
All right. This is State of Michigan versus Ronald McRipley, case 25056-21901. Today is the date set for a bond redetermination hearing. Appearances, please.
We're going to bail on this part. It looks like we did get opening statements from yesterday. I thought it was today. I was not going to do jury selection, but we'll do this really quickly because it's a quick one. And it's always fun to see how this goes down. Sorry for the whiplash. We'll you get used to it is what's going to happen. We're going to be Thurston County Courts in District 4. Let's see, yesterday. And it's this one right here. Okay, we're going to skippity-doo ahead just a minute here. Can you see? You can see that? Okay. We're going to skip ahead to when the jury comes in and sits down. Now, you're asking now, you'll ask, is that the jury? Is this really the jury? Yes, it is. We get to see jury selection in this trial. I'm going to speed it up a tiny bit because it's about an hour long. Playback 1.25. These are the jurors coming in. This is the panel that we're going to select the jury from. It's probably going to be a 6-person jury with an alternate or 2. And so we have about 20 seats spaced 6 feet apart because that's how the chairs have been for the last, 3 years in this courtroom, and just no one's bothered to move them. But everyone has a name tag or a number with a number on it. And there we go. Everybody's ready. Now we get to see who wants to sit on the jury and who does not. So judge will open up. He'll ask a couple questions, give a little instruction, and then each side will get a little bit of time to question potential jurors, which we hope to be able to hear all of. And you will get to choose and see who gets to sit on the jury and who does not. It doesn't look like a courtroom. That's because we're in the Holiday Inn Express Conference Center. I don't know. It does look like a hotel lobby a little bit. Converted courtroom, but it's this is one of the more exciting, fun courtrooms we visit in Thurston, Washington. They have some great cases.
Seated in the courtroom.
Judge is here. If you've never been selected to sit on a jury or to show up for jury duty, this is what happens. This is the process. Although the questions you get asked specifically are different, it gives you a good idea for what you can expect. This is an assault and criminal mischief, I believe, case. Landlord-tenant issue gone bad, which means the defendant is probably seated in the middle on the left-hand side of the screen, right above my head. Last time we were in this courtroom, the jury returned a non-unanimous verdict. It was... Wait, unanimous means we all have to agree? Oh, wait, send us back, Judge. We'll try again. Crazy things happen up here. When do they start the musical chairs game? It's already done. This is their final position. They all each have a number.
Okay.
Starting in the front
first
left.
of all, good afternoon,
from
everybody. I want to thank you all for appearing for jury duty here this afternoon. Now, it's probably inconvenient for all of you to be here today. But Thurston County has one of the highest rates of juror attendance in the state. We're all proud of that. You should be too for appearing here for jury duty today. So the case you're going to hear about is a criminal case. And this is a criminal case brought by the state of Washington against the defendant, James Turner. The prosecuting attorney in this case is Mr. Andrew Holcomb. Mr. Holcomb, could you please stand and introduce yourself to the jury panel, please?
Hello, my name is Andrew Holcomb. I'm a deputy prosecuting attorney for Thurston County, and I will be representing the state in this case today. Thank you for being here.
The defense attorney is Mr. Andrew Stashevsky. Mr. Stashevsky, could you please stand and introduce yourself, your client, as well as the other individual seating with you at counsel table?
Good afternoon, everyone. My name is Andrew Stashevsky. I'm counsel for the defense. My client is Mr. James Turner, and seated to the left of James is Jasmine Clark, who will be assisting me this afternoon in terms of recording some information. Thank you.
In this particular case, the defendant, Mr. Turner, is charged with two separate crimes. He's charged with the crime of assault in the 4th degree, as well as malicious mischief in the 3rd degree. And more specifically, it's alleged that on or about June 30th, 2024, the defendant knowingly and maliciously caused damage to the property of another in an amount not exceeding $750.
Under $750.
It is also alleged that on or about June 30th, 2024, the defendant assaulted Calvin E. Malone, and this also occurred in Thurston County. I want you all to keep in mind as we proceed here this afternoon that a charge is only an accusation. The filing of a charge is not evidence that the charge is true, and your decisions as jurors, should you be selected, must be made solely upon the evidence presented during these proceedings. To both charges, the defendant has entered a plea of not guilty. Plea of not guilty means that you, the jury, must decide whether the state has proved each element of the crime charged. The state has the burden of proving every element beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists, and the defendant has no duty to call witnesses, produce evidence, or testify. The defendant is presumed to be innocent, and this presumption of innocence continues throughout the entire trial. The presumption means that you must find the defendant not guilty unless you conclude at the end of your deliberations that the evidence has established the defendant's guilt beyond a reasonable doubt. A reasonable doubt is one for which a reason exists. It may arise from the evidence or lack of evidence. A reasonable doubt is a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. And if from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. And in a few minutes, I'm going to ask you a series of questions, and I'm going to turn things over to the attorneys, and they're going to ask you more questions. But I want you all to keep in mind that the remarks I make, the questions I ask, the questions I permit the attorneys to ask, and the instructions I give are directed to the attention of every potential juror in the courtroom, and all of you are cautioned to pay close attention to these proceedings. In order that this case be tried before an impartial jury, the lawyers and I, we're going to ask you questions, and we're not trying to embarrass you. We're not trying to pry into your private affairs, but we're trying to determine if you are unbiased and without preconceived ideas which might affect the case. You should not withhold information in order to be seated on this jury. You should be truthful in your answers rather than answering in the way you feel the lawyers or the court expect you to answer. It is presumed that when a jury has been selected and accepted by both sides, each of you will keep an open mind until the case is finally submitted and will accept the instructions of the court and will base any decision upon the law and the facts uninfluenced by any other considerations. And the whole purpose of this process is to determine if you have that frame of mind. But before I start asking you all these questions, I could ask all potential jurors to please stand.
Raise your hand, get sworn in.
Raise your right hand. Do all of you solemnly swear and affirm that you will truthfully answer questions about your qualifications to act as jurors in this case? If so, please answer by saying, I will. You can put your hands down and you can sit down. Okay, was anybody unable or unwilling to answer affirmatively to that question? So you've met some folks at council table, Mr. Holcomb, Mr. Stashevsky, as well as those sitting with him. Are those familiar faces to anybody? Do any of you know any of those folks? I should have introduced myself at the outset. My name is Sam Meyer. I'll be the judge throughout these proceedings. Seated to my left is Ms. Amy Lopez. She'll be the clerk throughout these proceedings. I know at least one person I know. Juror number 4, you and I know each other, not really well, but well enough to know where it's nice to see you, first of all. And it's disclosed to all the attorneys that I do know you. And but I won't be giving evidence. You'll be asked to determine and assess evidence given by witnesses. Is anything about the fact that you and I are acquainted with each other, would that affect your ability to be a fair and impartial juror in this case? Anybody else other than juror number 4? Sometimes people recognize me. I don't recognize them right away. Anybody else familiar with either myself or Ms. Lopez seated to my left? Potential witnesses in this case include Jennifer Lanham, Nick Anderson, who's an employee of the Thurston County Sheriff's Office, as well as Calvin Malone. Are those familiar names to anyone here? Anybody know any of those folks?
No hands raised. How about the defense and the prosecutor? Do you guys know them? Or the defendant?
So you've heard Mr. Holcomb, who works at the Thurston County Prosecuting Attorney's Office. If any of you are familiar with any other employee, either as an attorney or as a staff person at the Thurston County Prosecuting Attorney's Office?
No hands.
Have any of you ever been associated or worked within a court system in any way? This is easy so far.
Number one.
There is one. I'm sorry. Yes, ma'am.
I'm an attorney. I haven't worked since I was a Rule 9 intern now.
Okay. And so, okay, anything about your work or opinion of attorneys, pro or con, affect your ability to be a fair and impartial juror in this case? Okay, and I'm sorry, I missed you. You must have been behind that. Yeah. Yeah, I will also say, this courtroom we're in is a little bit unusual, and I'm speaking to the back of the room, which is why I'm speaking a little bit louder, but this is, just as an aside, this is a holdover from COVID days. We used to have our court trials over in the main courthouse, but when COVID hit, we started having them here so everybody could space out and have social distancing. And so we've just continued to use this space, although it is somewhat of an unconventional courtroom, but that's why we're here today. One of the witnesses you've heard is a member of law enforcement. Are there any law enforcement officers with us here today?
Any family?
Anybody have any close friends or relatives who are law enforcement officers? Okay, and then I'm going to call your number. You can put your hand down, but I'm going to call each one of your numbers. So go ahead and put your hand up. So you have juror number 2.
Yeah.
3. Hang on just a second. I'm going to take numbers, and I'll come back and speak to you individually. 3, 4, and then again, it's hard. Again, another part of this courtroom is it's hard for me to read numbers. 12.
11. Well, 12.
13. You can put your hand down, and then you, ma'am, in the back. I can't see your numbers. Yes, you. That's 15, 16. And then 19, and then are you 20, sir? Okay.
20, you're not going to get picked. You
Okay.
never get picked.
So we come back to you, juror number 2. How close of a friend or relative?
Oh, I'm probably one of my best friends.
Okay. Does he work here in Thurston County or?
Still.
Okay, Stillicum. Any conversations you may have had with him or her about their job affect your ability to be a fair and impartial juror in this case? Okay, thank you. Juror number 3, how close of a friend or relative?
My father.
Does he work here locally? I'm sorry?
He's retired.
Okay. Did he used to be a state trooper?
No.
Oh, I see. Okay. So anything about conversations you may have had with your father about his job, stories he's told on the job, and affect your ability to be a fair and impartial juror in this case? Juror number 4, how close of a friend or relative?
Nephew.
Okay.
State trooper.
You're here in Washington?
Lewis County.
Okay. Anything about conversations you may have had with him about his job affect your ability to be a fair and impartial juror in this case? Juror number 12. Where you at? Right there. How close of a friend or relative? Okay. Is that here locally in Thurston County?
Yeah, retired.
Okay. Was that in the sheriff's office or what? Sure. Okay. How long have they been retired? Okay. So a while. Anything about that conversations you may have had with your stepfather affect your ability to be a fair and impartial juror in this case? Juror number 13. How close of a friend or relative?
My cousin, former, possibly current, chief of police involved.
Okay. And then anything, again, same, you've heard the series of questions by now. Anything about conversations you may have had with them about their job affect your ability to be a fair and impartial juror in this case? And then juror number 15, I think we're back over here. You, ma'am, how close of a friend or relative?
It's my husband's best friend's son, who we consider family to us.
I see. Does that here in Thurston County?
It's me.
Okay.
My
Anything
husband's
about
best friend's son.
that relationship, conversations you may have had with that individual about the job affect your ability to be a fair and impartial juror in this case? And then juror number 16. And then how close of a friend or relative?
Father, one of my best friends.
Okay, here in Thurston County?
No.
And then where?
Federally.
Any-
Alaska.
Okay. Anything about conversations you may have had with them about their job affect your ability to be a fair and impartial juror in this case?
No.
What questions
Juror number
do you have,
19.
Angela? I haven't seen any.
Currently?
Were you using any of our
The
banned
deputy at
words?
issue in this case, again, is someone named Nick Anderson. Have you ever met that individual? Do you know who that is? Okay, but you have a spouse who currently works with Thurston County Sheriff's Office.
She's out.
Okay, thank you, ma'am. And then juror number 20. Linwood, did you say? Yeah. Okay. Anything about conversations you may have had about with your friend affect your ability to be a fair and impartial juror in this case? Okay. And so you've heard the charges. There's malicious mischief in the 3rd degree, which is essentially property destruction. I gave somewhat of a technical definition, and then there's assault. Have any of you ever been convicted or been charged with a crime either similar to either one of those? Juror number 13, you've been charged with. Okay. How recently?
Been 12 years ago.
Was that here in Thurston County?
No, Baltimore.
Okay. And so anything about that experience affect your ability to be a fair and impartial juror in this case to both sides?
Yes.
Okay. Was that when your experience with what exactly? Who? Was that with law enforcement, prosecutor's office, a defense attorney? Or? Okay. And you're saying that would affect your ability to be a fair and impartial juror in this case?
Yes, Your Honor.
Okay. Thank you. Anyone else? Slightly different question. If any of you ever been either assaulted or have some of your property destroyed by someone's known or unknown. You can put your, okay, and again, this is another situation where I'm going to take numbers and then ask afterwards. Number 8, number 10, number 11, number 12, and then your number 13. Thank you. And then in the back row, we have your number, I'm sorry, that 14, which must make you number 15. And then over here, we have 18 and 20. Okay. Juror number 8. We'll start with you. How long ago did this happen? Okay, did the person, was this an assault or a malicious mischief?
Property that were vandalizing our house.
Okay. And then was that person ever prosecuted or ever have any accountability? Okay. That experience, would that affect your ability to be a fair and impartial juror in this case? This is okay. Juror number 10. There's you, ma'am. And then either or, in terms of malicious mischief, have property damaged or been assaulted or anything like that. Still what? Okay.
They've been watching us the police for about 2 weeks.
Were those people prosecuted or anything like that? Okay.
They did come back 2 weeks later though.
How long ago did this happen? 2012, so about 13 years or so. Anything about that experience? Again, this is a completely different experience, but oftentimes when folks go through these things, they leave emotional scars. And so, if not physical ones, but anything about that experience affect your ability to be a fair and impartial juror in this case? Thank you. Juror number 11. Is that you, ma'am?
Things taken. And
Okay.
also my car.
Your car was taken also?
No, my car was broken into.
I see.
Separate incident.
Okay. Anything about those experiences affect your ability to be a fair and impartial juror in this case?
No.
Okay. And then juror number 12.
What's with crime
Go
up
ahead,
there
sir.
in Tumwater?
Just car breaking.
Okay.
Just car breaking.
Anything about that experience affect your ability to be a fair and impartial juror in this case?
Being one of the guys who did.
Okay. All right. Well, that had a happy ending anyway. Juror number 13.
From 2022 to 2022, I lived in Tumwater. My house was broken into, my car was repeatedly broken into, my car was just vandalized and just other property.
Was there any anyone ever prosecuted for that you know of?
Why is everyone's
Okay.
car
Would
been
that
broken
affect your
into?
ability to be a fair and impartial juror in this case? And I've already asked you that question in a different context, but I'll ask you this question here too. Would that affect your? Go
I
ahead.
think so. Potentially.
Okay.
Hard for me to say.
And then we have juror number 14.
Yes.
So- Say that again, ma'am.
I was not home at the time with my daughter. They stole her wallet. They were able to steal her car. They were never caught. It was very disturbing.
How long ago did I can imagine? How long ago did this happen?
Just about a year and a half.
Okay. Anything
Everyone's had their car broken into or a
I should
home
say also, and
invasion.
I don't think that I've mentioned this before, but I will say this now. It's also alleged that the folks involved in this particular case all lived in the same home. So everyone knew each other. But having said that, ma'am, that experience was fairly recent, affect your ability to be a fair and impartial juror in this case.
I don't think so.
Thank you. Juror number 15.
Yeah, I had property damage and assault towards me from high school.
Okay. And so anything about that experience affect your ability to be a fair and impartial juror in this case? Okay. And then juror number 18.
Property damage.
And then how long ago did that happen?
It happened right last year, and I feel about here all the years. They would find me again.
Anything about that experience, the things that you've obviously carried with you, affect your ability to be a fair and impartial juror in this case? Or do you know? Okay. All right. So the attorneys may wish to follow up on that, ma'am. And then finally, juror number 20.
That's a little raw for her.
Pre-incident, 20, 30 years ago, I had a house broken into, property was destroyed, went stolen. About a year later, windows to a car was brought to it. And then the most recent, about 20 years ago, the car was stolen, driven around and trashed.
Okay.
We're all.
Pretty much everyone
Those
here is a victim of
experiences,
crime.
will that affect your ability to be a fair and impartial juror in this case?
No.
Thank you. So I anticipate we're here today. You've heard there's going to be 3 witnesses. What's going to happen this afternoon is we'll have jury selection. Attorneys will give opening statements following jury selection, and then we'll break for the day, come back tomorrow. I fully expect, given the number of witnesses and what we can get done here today, we'll be done tomorrow. So it'll be 2 days at most. I just want to let everyone know what the schedule is, and before I turn things over to the attorneys. So with that, I'd have you give your attention to Mr. Holcomb for the next 15 minutes for his question and answers, or voir dire. It's a French term. Never quite fully understood what that means, but that's or his question and answer period for the next 15 minutes. Mr. Holcomb, you may go.
Thank you, Your Honor. All right, so my name's Andrew Holcomb. I'm a deputy prosecuting attorney with the Thurston County Prosecuting Attorney's Office, and I'm going to endeavor to be viewable by everyone. I also tend to be rather loud, so I don't anticipate volume being an issue, but if anyone struggles to hear me, feel free to raise your hand or just like tap your ear, and that'll be my subtle cue to increase my volume. So, anywho, believe it or not, we are at my favorite part of the trial, or one of my favorite parts of the trial, where I actually get to ask you questions to get feedback from you as the potential jurors to see how you go about solving problems, how you go about what's your thought process, what makes you tick. This is interesting, partially because I like connecting with people and talking to them about it, but also because during openings and closings, I'm going to be taking that into account when I am presenting the evidence to you. So I'm going to ask a couple of questions. I'm not going to single anyone out. If you want to answer the question, you can just raise your hand and then I'll call out your number and then we'll interact with the question. We may have some answers bouncing off of each other, which is what I actually hope to happen here. I hope that we have like some kind of a group discussion with a couple of prompts, if you will. So the first question I have is, it's a fun legal hypothetical. You're in your apartment and you look outside and there's snow on the ground. What happened? Number 10, it snowed. Okay. Yeah, number 7.
Calling out of work.
You're calling out of work. Okay, yeah. That's what you will do because of it. But yeah, 5.
Yeah.
You're happy. Okay, number 15. Snow day. Yep. Snow day for
This
school.
conversation.
Yeah, number 20.
What happened? The temperature dropped below freezing. You weren't very close to freezing. There was enough moisture in the air to precipitate.
Okay, that's a very scientific way of saying it snowed outside. That's
everyone else is like snow day.
That's important for me to know how you think. So
there was frozen precipitation.
Does anyone think that something else happened? I mean, the only things could have happened. Okay.
It's not likely that somebody had a big snow machine outside of your place only. It's not likely.
Okay.
That's possible.
So it's a possible option. It's not likely. It's a possible option. Anybody else? Snow machine was the possible alternative option. Anybody else? Okay. So it's possible. It's possible there's a snow machine outside. If someone told you, like some random person walking down the street told you, hey, someone must use a snow machine over there. Juror number 1, would you be inclined to believe them?
Somebody just said that to me.
Yeah.
I want to know, is there snow in front of me everywhere, or is it snow in a localized area? I need to know this.
So it'd make you look not just right outside your window, but also off to the side. Okay. General area. Okay.
Trust but verify.
Number 11.
Is that what I'm hearing?
You would want to see the machine? Yeah. Okay. Huh? Yeah.
If, you know, I have a
Yeah, yeah. We'll just say for the sake of argument, it's in winter. I forgot to add that. Yes, it's in winter. It's not the middle of summer. 13.
I'd ask, who are you? If you didn't change.
Yeah. Important questions to ask. So you're going to hear a term, reasonable doubt, used a lot in this courtroom because the burden of the state is to prove all of the elements of each of the charges beyond a reasonable doubt. And we're going to dive deeply into what that means, but what that fundamentally means is an abiding belief in something. So if you look out the window and you see snow on the ground, it's winter, you know it's snowed outside, beyond a reasonable doubt, unless something odd pops up to suggest otherwise. So that's what beyond a reasonable doubt means. Are there other possibilities? Potentially, but it's beyond a reasonable doubt, not beyond any doubt whatsoever. So going on to, all right, so let's contextualize this a little bit more. 2 people call law enforcement, say that an assault happened. They say that one person assaulted the other person. Let's say that no one here is with law enforcement, but let's say that come to the scene and your job is to figure out what happened. What type of questions are you going to ask? What are you going to look for? Yeah, number 16. What started the altercation? Okay, how would you find that out?
What separating the two?
Okay.
maybe another colleague questioning the other.
Okay.
Bringing the information together, speaking with a colleague.
Okay.
and putting it together.
Yeah. Number 2.
I would look for any physical damage, evidence that assault action.
Yeah. Number 1.
Is there any witnesses to what happened? Like, get information from?
Yeah. So figure out other people at the scene. 13.
Start by separating. Ask what happened. Why is there?
Yeah. Yeah. I would get that. Okay. Separating people.
You can get two-sided.
Okay. Okay. So in this courtroom, there's going to be a very definition of what an assault means. An assault means a harmful or offensive touching of another. In order for it to be an assault, it has to be a harmful or an offensive touching. That's what an assault is. So that doesn't necessarily require a mark be left. Can anyone come up with an example of a harmful or offensive touching that would potentially not leave a mark behind? Number 10. Pushing someone. Okay. 18. Huh? Kicking someone. Yeah. Number 11. I think you had. Nope. Okay. Anyway. Number 2.
Pumps of midsection.
Yeah. Punch the gut. Yeah. Okay. Yeah. Yep. Definitely qualify. Okay. All right. All right. So I just got one last question for you guys. So the state's going to be bringing evidence, and at the end, I'm going to tie all the evidence to each one of the elements. If you, in your independent decision-making, believe that those elements have been met, and it will be your duty as a jury to render a verdict of guilty. So the question is, this case involves a crime, an alleged crime of assault and an alleged crime of malicious mischief, property damage. So someone's going to be convicted of a crime if it is found beyond a reasonable doubt. That's a very serious thing. And I don't want to put people in that position lightly where they potentially have to make that decision. So if anyone is uncomfortable with that decision to the point where they do not believe that they could do it, if in that specific scenario, they had an abiding belief in the charge and they still just, nope, I just can't do it. Does anyone fall into that camp? There's no problem if you do. Number 18. Okay. Okay. Thank you. It's really
I'm
important.
sorry, ma'am. Could you say that a little bit louder, please? Okay, thank you.
Okay. Thank you. Number 18. It's really important for me to know. Anybody else? Okay. Thank you for being here today. I really appreciate your involvement in the process. This system only works when people like you show up, sit for jury selection, and potentially sit on a jury. So I appreciate all of you for being here and look forward to working with you.
He really doesn't care who he gets on the.
Thank you, Mr. Holcomb.
As long as there isn't
Members of the panel, we now give your
anti-government.
attention to the next 15 minutes for Mr. Shashevsky for his question and answers on behalf of Mr. Turner. Mr. Shashevsky, you may go.
Good afternoon, everyone. As I mentioned earlier, my name is Andrew Stashevsky. I'm counsel for defense, Mr. James Turner. I may remain seated during our conversation just because it's going to be easier for me to capture notes that way, I believe. I'd like to start with a very open-ended question. Does anyone here have a bumper sticker on their car? What does the bumper sticker say?
Oh, it says Feline Friends, because I volunteer with the animal rescue.
It says
I love it.
question
Great.
authority.
No other bumper stickers?
Okay. Does anyone here
If
drive
you
an
own
electric
a
vehicle?
house, could you please raise your hand and keep them raised until I call your name? And I'll just kind of go in consensual. Juror number 1, juror number 2, juror number 3, juror number 4, juror number 5.
6 is the only one not.
And then we
raising
have
their
juror number 8,
6 and 7.
juror number 9, juror number 10, juror number 11, 12, and 13, 14. Thank you, ma'am. 14, 15, 16, 17, 18,
and 20.
And then, oh, sorry, ma'am, I missed you. Number 5. And then 20.
Before you continue on, I would ask that everybody please check their phones, make sure they're silenced during now. I don't want to interrupt you, Mr. Shashevsky, as you were taking numbers.
Mine was reused my watch. I don't know how to.
Well, I knew that, ma'am, but I wasn't going to single you out. But just everybody who has their phones, just make sure they're. So anyway, I apologize, Mr. Shashevsky. You may continue.
That's fine. Thank you, Your Honor. Could you please raise your hand if you agree?
So hang on just a minute. Just wait there. Wait for.
Oh, yes.
If you're gonna,
She's trying to silence her phone on her watch.
When they're back and engaged, I'll let you continue.
This won't count against your time. You're okay.
Okay,
There you
go ahead, Mr. Shashevsky. That's all right.
okay.
Don't worry about it, ma'am.
Could you please raise your hand if you agree with this statement? There are no circumstances under which it would be appropriate to engage in violence or physical aggression.
So
And,
violence is never
juror
an
number
option.
20. Could you kind of explain your thought process there?
I think that, well, maybe I'm
misheard the question or anticipated it incorrectly, but I think that violence would be allowed.
Can you, even with violence being a last resort, can you envision a situation or a circumstance where that might be an appropriate reaction?
In self-defense.
Self-defense. And what might like a self-defense scenario kind of look like? And I know I appreciate that that might look 100 different ways, but can you think of one where you might think of a self-defense type situation?
If someone was armed and attacking me, or unarmed and physically assaulting me, I would have to see it as an immediate threat, not just vocalization of the threat.
Needs to be immediate threat, not just a vocalization.
Thank you. And then I might kind of just do a random point. Did someone else have their hand up?
18. 18 says protect
Thank you. And that was
yourself.
juror number 18. I thought I saw another hand. Juror number 13.
State has a monopoly on the use of violence. The system is set up so that we don't need to use violence. And that's about aggression specifically. I have no right to use violence or aggression against any other.
The state has a monopoly on
And
the use
juror
of
number
violence.
6, can I hear from you? You didn't raise your hand. So what would, again, be a circumstance where it might be permissible or appropriate to respond with physical aggression or physical violence?
There's any kind of direct threat towards me, be it, someone's armed, for instance, or is physically assaulting someone I love or me, say it's permissible to use physical violence.
And then I might switch to kind of a different hypothetical, a different question. Is there anyone here today that thinks because James is sitting at this table that he's done something wrong? That if you're accused of a crime and a prosecutor, the state brings you to trial, that means you've done something wrong? Anyone kind of agree with that sentiment?
Oh.
Juror number 9, could you kind of, and if you could keep, it was, I believe, juror 9, 10, and 16. And juror number 9, could you kind of speak to that a little bit?
I feel like if it's gotten this far in the process, something happened.
You must be guilty.
That some decisions were made and that it'd be very unlikely that you did nothing wrong if you're here today.
Chanted.
And then juror number 10, can you expand a little bit on your thinking there?
I'm just saying, if you're to this point that something's obviously led them here, and with evidence, but I do know that they're also been innocent and charged with a crime, so I wouldn't one way or the other. I'd be impartial to whether he has it.
It's obvious he did something wrong, but I know it has to be
I'm
proven.
sorry, could you repeat that, please, juror number 9?
I agree with her also.
And then I believe juror 16, you had your hand up.
It's not a coincidence that they picked up an individual off the state. There had been an account exchange of identification to lead to the process, and where the defendant is currently convicted.
Couple more hands. 5.
And then juror 18.
Can't hear 18. She's quiet. 18 doesn't want to serve.
Let me ask maybe a kind of a related question. Do you think that police officers occasionally arrest the wrong individual? Is that a circumstance that does occur? If you could, I guess, raise your hand if you agree with that.
Ooh.
And then so I might focus here on the folks that didn't raise their hand. And I apologize maybe if I phrased the question incorrectly, but juror number 3. So is it your belief that anytime an officer effectuates or completes an arrest that there's no mistake has been made?
He pulls the reverse card on her.
Something had happened, but it's not confirmed yet whether or not there's an incident that led to the arrest.
Let me ask that question again, because I don't think I did that very artfully. So if you could raise your hand, if you believe that it's very unlikely or near impossible that if an officer arrests someone, that officer has made a mistake. If you could raise your hand if you agree with that statement. Yeah, if you believe that if an officer has arrested someone, it's very likely that the person they've arrested has done something unlawful.
Oh, my goodness. Oh, arrest is proof of guilt.
I'm sorry, one more time.
You can't be quick to judgment, you have to get all the facts. You can't just really initially go.
People.
Now this
being arrested is not
case
a crime.
involves a physical altercation. There will be a video of this altercation. Will that be distressing to anyone such that they don't believe they'll be able to focus on the proceedings or kind of pay attention to the testimony from the witnesses?
Yep, 18.
Juror number 18.
She does not want to serve. Not that we're going to get to her anyway.
Another version of kind of a similar question I've gone into. On a scale of 1 to 1 being innocent, Mr. James Turner is innocent sitting here today, and 5 being guilty. I might just kind of do a random polling and ask some folks where they would put James. Juror number 2, where would you put James? 1 being innocent, 5 being guilty. Juror number 4? Juror number 12? Juror number 17?
If anyone says 3, it's wrong. The correct answer is 1 to this question. Even though 3 is in the middle.
Your Honor, I think that's all I have. I appreciate everyone's time and attention, and thank you for your responses.
Okay. So just a couple of follow-up. As I mentioned earlier about the schedule, we can be here the rest of the day today and then tomorrow. Would that present an undue hardship for anybody to participate in this trial? I recognize it's inconvenient for everybody. And when I say undue hardship, I mean, if you have non-refundable tickets to Hawaii tomorrow afternoon, I'm not going to make you cancel your vacation. But again, juror number 10, I'll hear from you.
Oh man, I wish we could hear these.
Do you have any medical appointments tomorrow? Okay, thank you. And then juror number, your number's being blocked for me. I'm sorry. 16.
I have a job interview with the state tomorrow. I can't schedule.
Job interview.
And juror number 13.
Mine is not tomorrow. I do have a root canal on Friday, so.
Okay.
I've got a root canal.
We'll be done by Friday. Thank you.
I don't want to miss
so
my root
what's
canal.
going to happen now, members of the panel, is the attorneys are going to come up here. We're going to have a session here where it's probably going to look like we're trying to keep this conversation from you. And that's for the very good reason that that's exactly what we're trying to do. So don't try and eavesdrop on what's happening up here. This shouldn't take too very long. And then when we're done here, we'll come back into a regular session. So Mr. Sashevsky, Mr. Holcomb,
okay.
Approach, please.
Well, while they go up and they're going to be off the record and while they have this conversation, they're going to be discussing. They're going to be discussing, we might be able to hear some of it, but they're going to be discussing who should be removed for cause. That means somebody who has a position that makes them ineligible to serve on the jury. Like they say, I have a firm and abiding belief that if you are arrested, you are in fact guilty. And I cannot set that aside and follow the court's instructions to consider you innocent until and unless you are proven guilty. Unless and until that person would be off. Anyone who has a for cause or has a hardship, the root canal might be a good enough excuse here. We'll see. The job interview, probably a good enough excuse. I didn't hear what, let's see, was 6, 7, 8, 9. Didn't hear what she had, but that might be a legitimate excuse. Those people all get set aside first. And then what happens is they start with number 1 and they'll alternate back and forth and say, do you want number 1? Do you want number 2? Do you want number 3? Do you want number 4? And each side gets a number of preemptive strikes where they can cross somebody off for whatever reason. They don't have to give a reason. It's just I don't like the way they look. I don't like what they're dressed in. They're wearing team colors that I'm not a fan of. It can be whatever they want, but they get a limited number of names they can reduce. They can strike from this. And once they have seated a panel. And depending on how they do this, once they've seated the panel, they can actually go back and strike again if they have more strikes available. But basically, they start at number 1, and if they're not crossed off for some reason, they're on the jury. So it's almost impossible for number 20 to get seated because you'd have to cross off a bunch of people before you get to him. It is, why wouldn't they want to be on the jury? A lot of people don't like serving. It is inconvenient. A lot of people won't even take the time to vote. Because that's also inconvenient. I do count both as a civic duty. And I think I've never been called on to serve on a jury. I'd love the opportunity. I've been a witness in court, which I think I completely butchered, but yeah, it's a good thing. They have a very offensive scent. Wagger says, I was number one in jury pool one time. Yes, I served all week. Federal court. Katie Russin, you should start a business in picking a jury. The thing is, you have to let the lawyers do it. The defendant has a right to a trial by their peers. There are professional jury pickers and people that will analyze, especially in bigger cases, instead of just showing up for court and answering a few questions for half an hour. There may be questionnaires that are submitted, many page questionnaires that are submitted ahead of time and then poured over by teams of attorneys as they try to glean from the answers, the facts that they're trying to get and see who would be most amenable to their position. Anyway, I was going to say, this is one of the courts where they do allow us to see the jury. It is tradition in many courts to not show the jury, but it's not the law of the land. Serving on the jury is not necessarily a secret thing. Anyone who shows up in court can, in fact, see the identity of all the jurors as they're serving. We just on the TV or on the camera here don't show them in many courts, but this one they do, and that's okay. There are a couple courts where they do show them. There are some courts even that cameras are allowed in where the judge rules state, the courtroom decorum rules for media state, don't zoom in too close on the jurors. That's the judge's rule. No tight shots on the jurors. Okay, the focus is supposed to be on the defense and the prosecution and the judge and the witnesses. Don't zoom in too close, but feel free. Pan, show everybody who the jury is. They're fine with that. It just depends on the court. So we're used to the not seeing it though. So it does feel weird the first time. You're like, this is jury selection. I served once, our courthouse 65 miles away, longest 2 weeks of my driving life, says Chris Wallace.
Okay.
Served on a week-long jury. It was awesome, says Stacey Ray. I also went through the jury selection for a death penalty case, but didn't get picked. Kind of glad I didn't. Yeah. AZDCS said, 1 week ago I started supporting the jury badge number. That is awesome. That was, once you can talk, I'd love to hear about that. I have to plug in my phone. It's going dead. Served on 2 juries living in San Antonio. Heidi, that's awesome. Anything with Judge Boyd? She's down there in that neck of the woods. The feds give you a hotel room if the juror lives over 50 miles away or transportation issues. Oh, you're free to talk now. Wonderful. I can skip ahead through this, but I think they're done. So, but now we're going to find out who served and who
we're going to
didn't.
come back into open session. So first of all, before I'm going to announce, these are 6-person juries in Thurston County District Court. And so I'm going to announce the 6 who are going to serve on the jury. After that, I'm going to be a 7th who's going to be the alternate, and I'll say who the alternate's going to be. But before I announce them, I want to thank everybody again for participating in the jury selection process. If you are not selected, you might be relieved. You might be disappointed, but whatever your reaction is to being selected or not, again, your presence and participation was essential to the jury selection process. So thank you all again for being here. After today, your term of jury service is completed. You do not need to call back, and that's the end of it. And so jurors who are going to serve in this case are as follows. Juror number 2, come forward, sir. And in the order that you have a number on now, but I want you to sit in these chairs in the order that I call you. So even though you're juror number 2 now, you're going to be number 1 up there.
See, the attorney's out.
Which is just chronological, not order of importance. So don't try and order over the others. Next is going to be juror number 3. Come forward, ma'am. Juror number 4, come forward. You're going to be serving on the jury. Juror number 5. Juror number 7.
6 thought it was him. You got skipped 6.
And juror number 8, you, sir.
And now we
skip the alternate is going to be juror number 11.
I knew it. I did not watch this beforehand. They talk too much, and they said
And
that
then for the rest
they
of you,
think he's guilty
I'm
because
going to
he was
excuse you in
arrested.
just a moment, but before we do that, I'm going to swear in.
Everyone else,
Area. It's not the jury box.
everyone
Could
else
you please
gather
stand
your
and raise your
eggs and
hand?
go home.
Raise your right hand. All of you, each of you solemnly swear and affirm that you will fairly try the issues in this case according to the evidence and the instructions from the court. If so, please answer by saying, I will. You can put your hand down and you may sit down. And the attorneys, you can move your chairs to the other side of the table. And then the rest of you, again, I thank you again for appearing here, and then you're all free to go. You're all free to stay too. No one ever does when I make that offer. Thank you again for your participation in the process here today.
So clerk's gonna want information.
Don't feel bad because you're passed over. See, 20 never had a chance at serving. It was never going to happen.
Well, we might give Mr. this one. This is the stuff that definitely needs to go back.
This is a fairly new prosecutor. We've seen a couple cases.
Maybe take a seat there. We're going to give the opening instruction.
He has a lot of he does a lot of pauses.
So, members of the jury, I'm now going to give an opening instruction. This instruction is going to remain in place throughout the entire trial. It'll take about 3, 4, maybe 5 minutes. Once we're done with that instruction, the clerk is going to take you back to the jury room, just acquaint you with the jury room, and you can take a break. We've been in session for a while. One thing I forgot to mention that I'm going to mention now, and that is while the trial's in session, she's going to hang on to your cell phones. You can have them during breaks if you need them, but we take away cell phones during the testimony just to make sure that you eliminate the distraction. If you need to call someone during a break, of course, you can do that, or over not lunch today, but lunch tomorrow. You can have them during then. But the procedure that we're going to follow in this case is as follows. First, the prosecuting attorney is going to make an opening statement outlining the witnesses or other evidence that he expects to be presented during trial. The defense attorney may then make an opening statement or may choose to make an opening statement at a later time. After that, the prosecuting attorney is going to present the testimony of witnesses or other evidence to you. When the prosecuting attorney has finished, the defense attorney may, but need not, present the testimony of witnesses or other evidence. And each witness who testifies may be cross-examined by the attorney for the other side. After that, when all of the evidence has been presented to you, I will instruct you on what law applies to the case. I will read the instructions to you, and you will have copies of the individual instructions with you in the jury room during your deliberations. After that, the attorneys will make closing arguments. Finally, you will be taken to the jury room by the clerk, where you will select a presiding juror. The presiding juror will preside over your discussions in this case, and until you are in the jury room for those deliberations, you must not discuss this case with any other jurors or with anyone else, or remain within hearing distance of anyone discussing it. It is your duty as a jury to decide the facts in this case based on the evidence presented to you during the trial. Evidence includes the testimony of witnesses, documents, and physical objects. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you think it ought to be. And you are to apply the law from my instructions to the facts, and in this way, decide the case. The only evidence you are to consider consists of the testimony of witnesses and exhibits into evidence. When witnesses testify, please listen very carefully. You will need to remember testimony during your deliberations because testimony will rarely, if ever, be repeated for you. And any exhibits admitted into evidence will go with you to the jury room during your deliberations. The lawyer's remarks, statements, and arguments are intended to help you understand the law and understand the evidence and apply the law. However, the lawyer's statements are not evidence or the law. You must disregard anything the lawyers say that is at odds with the evidence or the law in my instructions. You may hear objections made by lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. One of my duties as judge is to decide whether or not the evidence should be admitted during this trial. Do not be concerned about the reasons for my rulings. You must not consider or discuss any evidence that I do not admit or that I tell you to disregard. Our state constitution prohibits a trial judge from making a comment on the evidence, and because it is your role to evaluate the evidence, it would be improper for me to express by words or conduct my personal opinion about the value of a particular witness's testimony or an exhibit. I will not intentionally do this. If it appears to you that I have indicated in any way my personal opinion concerning the evidence, you must disregard this entirely. You will be allowed to take notes during trial. Whether or not you do so is entirely your own decision. If you do choose to take notes, you should make sure that it does not interfere with your ability to listen to and observe the witnesses. You must not discuss your notes with anyone or show your notes to anyone until you begin deliberating on your verdict. And this includes other jurors. During your deliberations, you may discuss your notes with other jurors or show your notes to them. You are not to assume that your notes are necessarily more accurate than your memory. I'm allowing you to take notes to assist you in remembering clearly, not to substitute for your memory. You're also not to assume that your notes are more accurate than the memories or notes of other jurors. Throughout this trial, you must come and go directly from the jury room. Do not remain in the hall or courtroom, as witnesses and parties may not recognize you as a juror, and you may accidentally overhear some discussion about this case. And I have instructed the lawyers, parties, and witnesses not to talk to you during the trial. It is essential to a fair trial that everything you learn about this case comes to you in this courtroom and only in this courtroom. You must not allow yourself to be exposed to any outside information about the case. Do not permit anyone to discuss or comment about it in your presence. You must keep your mind free of outside influences so that your decision will be based entirely on the evidence presented during the trial and on my instructions to you about the law. Until you are dismissed at the end of this trial, you must avoid outside sources such as newspapers, magazines, the internet, or radio or television broadcasts, which may discuss the case or issues involved in this trial. Having said that, ladies and gentlemen of the jury, I don't expect that there's going to be any news coverage of this trial. There's no one here other than the attorneys, parties, and jurors and court staff. But that's still an important instruction in that we live in an age where one can access, and one frequently does access, the internet through one's phone. Don't do any research. Don't look up any terms you may have heard. You've already heard some. You're going to hear more. Don't do any sort of independent research on that. Don't be searching on social media for anything involved or related to this trial. Don't post anything on social media about your experience on jury duty. It's been a few years now, but there was a famous case further east. There was a big trial in Michigan. After several weeks of jury trial, someone was posting on Facebook from the jury room, and the whole thing had to be tried over again. So don't do that on Facebook or any other social media application that I've never heard of. So just don't post on social media about this case. I'm pretty sure that when you get home, friends or family members are going to ask you, hey, what happened? And I'm going to give you some specific questions. You can tell them you were selected for a jury. You got selected. You're going to be on a jury. I guarantee you the very next question you're going to get is, hey, what's the case about? And to that, I'm going to give you a very specific answer. And the answer is, it's a criminal case. That's it. You were selected for a jury. You were selected for a criminal case. Go no further than that. Because what could happen, what has happened, is they might mention to a spouse, family member, or friend, and well, I'm on this case, and tell a little bit about the case. And then that spouse, family member, or friend will say, oh, that's really interesting. I know someone who, and then they'll launch into a whole series of things that would be inappropriate for you to hear and may affect your ability to continue to serve. So again, yes, you were selected. You were selected for a criminal case. Don't go any further than that. During this trial, do not try and determine on your own what the law is. Do not seek out any evidence on your own. Do not consult any reference materials such as dictionaries and the like. You can tell how old these instructions are in that references newspapers, magazines, and dictionaries, which don't really get used that much anymore, but these are still relevant instructions. Do not inspect the scene of any event involved in this case. If your ordinary travel will result in the passing or seeing of location of any event involved in this case, do not stop to try to investigate. Throughout the trial, you must maintain an open mind. You must not form any firm or fixed opinion about any issue in the case until the entire case has been submitted to you for deliberations. As jurors, you are officers of this court, and as such, you must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. And to ensure that all parties receive a fair trial, you must act impartially and with an earnest desire to reach a just and proper verdict. That's the opening instruction. It's going to exist throughout the entire case. I'm going to make an effort to remind you of that instruction at every break. And so we're going to take a break now. So that instruction is going to, don't talk about, you haven't really heard much so far, but don't talk about anything you've heard thus far. We can take, it's now 3 o'clock. We can come back into session at 3:15. Then you'll hear opening statements from the attorneys, and then we can all go home after that. So Ms. Lopez is going to take you back there and acquaint you with the jury room. She'll also hang on to your phones for the opening statement, but you'll get them back when it's time to go.
All right, so we're going to skip forward through this break. We are going to listen to opening statements from prosecution and defense, and then it will end the day. We are going to pick up live on this case today as it proceeds through. I believe this will be a one-day trial.
3:15. Back at 3:15. Thank you. Okay.
Let's see. So let's skip ahead. We're very close to being done.
Okay.
There we go. We're back.
Okay.
I okay.
I don't think so. But okay.
Okay.
That's okay. Thank you.
No problem.
I gave him my 500.
Huh?
I gave him 500.
Cool. Oh, perfect.
So we're going to hear the opening statements.
Can't get over how these seats are basically whoopee cushions.
Yeah, they make a lot of noise.
Make you sit down and.
No, that the seat's not a whoopee cushion, and that excuse it doesn't fly with us. Apparently, Holiday Inn Court has whoopee cushions for chairs. So these are going to be short opening statements. They usually are in these small trials. It's not a lot of time wasted. They cut straight to the chase, really. Not a lot of drama, and obviously they're not playing for the cameras of the courtroom. It's just, it feels, I'm sure for them, a quite intimate setting, with just, a handful of jurors and a witness or three. I think we got 3 witnesses in this case, so it's going to be pretty quick. I thought we were there, but apparently we're not. Skippity, skippity doodah, skip ahead. Okay, there we go.
Please give your attention to Mr. Holcomb for his opening statement on behalf of the state. Mr. Holcomb?
The juror's off to the
Thank
right
you,
of the
Your Honor.
screen. That's why he's facing the way he is.
All right. Thank you all for being here. You made it through. So I appreciate you all being here today. Again, the system only works when you guys show up, and really appreciate you being here today as well as tomorrow. So going into the facts of the case, the two crimes in this case occurred at a residence located on Day Drive Southeast in Olympia, Washington, here in Thurston County. Both were alleged to have been committed by the defendant, Mr. James Turner, against his then roommate, Mr. Calvin Malone. In 2020, Mr. Malone had purchased the home on Mr. Turner's behalf and was granted permission to live there and manage the property. In the years that followed, Mr. Malone improved the property prior to Mr. Turner moving in August of 2023. In the months that followed Mr. Turner moving into the residence, Mr. Turner and Mr. Malone's relationship deteriorated. In May of 2024, Mr. Malone was on vacation and Mr. Turner changed the locks without telling Mr. Malone while he was on vacation. Mr. Malone, however, was still able to access the home and continued living there. In mid-June of 2024, Mr. Turner typed up an eviction letter and attached it to Mr. Malone's bedroom door. Mr. Malone told Mr. Turner to let him stay until at least October of 2025 or to take him to court. At this point, they were no longer on speaking terms, primarily resorting to leaving written notes for one another. All of this serves as the setup for the incident that occurred on June 30th of 2024. That evening, Mr. Malone walked out the front door of the residence to do yard work. As he was walking out the door, Malone heard the door slam shut and locked behind him. Mr. Malone then entered the side door of the house and told Mr. Turner that slamming and locking the door like that was unacceptable. Mr. Turner aggressively approaches Mr. Malone, prompting Mr. Malone to walk in towards the main living area where security cameras recorded the rest of the incident. In the video, the defendant's girlfriend, Jennifer Lanham, is visible in the video sitting on the couch. In the video, Mr. Malone can be seen reaching for a piece of paper on the kitchen counter. Mr. Turner responds by grabbing Mr. Malone's wrist, yelling, "That's not yours." The two men grapple. Malone pushes Turner away and starts walking away. Turner responds by grabbing Malone from behind around the neck and shoulder, then slamming Malone to the ground, permanently damaging Mr. Malone's glasses that were on his face at the time. The two men struggle, with Mr. Turner remaining on top of Mr. Malone for a few seconds until Malone is able to gain the upper hand and get on top of Mr. Turner. Miss Lanham approaches, telling Malone to get off. Mr. Malone then promptly releases Turner and leaves the room. Both men call the police. Deputy Nick Anderson arrives, interviews witnesses, takes photos of both men and Malone's glasses. Turner gives Deputy Anderson a copy of the security footage of the incident. The issues before you here today are relatively straightforward. Did Mr. Turner's actions, Mr. Turner's choices that day, constitute an assault in the 4th degree and constitute malicious mischief in the 3rd degree? You will hear testimony from Mr. Malone about the tensions leading up to this encounter and Mr. Malone's firsthand account of what happened that day. You will see video of the assault on camera. You will see photos of Mr. Malone's glasses and a receipt of what it cost Mr. Malone to replace those glasses. At the end of the trial, I will show you how each of the evidence presented, taken together, meets each element of the crime charged, at which point I will ask you to render a verdict of guilty.
It sounds like mutual combat to me. How about
Thank
you
you,
guys?
Mr. Holcomb. Now, members of the jury, we now give your attention to Mr. Stashevsky for his opening statement on behalf of Mr. Turner. Mr. Stashevsky?
Good afternoon, everyone. My client, James Turner, and Mr. Calvin Malone were friends. That relationship soured, and ultimately, James became a prisoner in his own home. Now, regarding the relationship between these two men, James owned the home that the two of them lived in. In return for not paying James rent each month, Mr. Malone was responsible for general upkeep around the property and in the house. Mr. Malone believed the house was going to be used to help folks recovering from homelessness kind of get on their feet. James had different plans for the home, particularly after he met Jennifer Lanham. James and Jennifer started dating. Eventually, they became engaged. Jennifer moved into the house in May 2024. They decided that they wanted the house to serve as their marriage house, where they would reside as a married couple. There were initial discussions about Mr. Malone leaving the property. When Mr. Malone went on an extended vacation from late May through early June, James and Jennifer changed the locks to the front of the house. They did this because they were aware that several spare keys had been made to the front door, and they no longer knew who had those spare keys. And they wanted some security and assurance of who was able to access the house from the front of the door. Importantly, the locks in the back of the house had not changed. When Mr. Malone returned from his several-week vacation, he was still able to access the house, and he continued residing there. In mid-June 2024, James informed Mr. Malone that he needed to leave the house no later than mid-July, so about 1 month. Testimony will show that Mr. Malone did not believe that James had followed proper procedures and that he therefore was not required to leave the residence. One other rule that was implemented in the house at this time was James and Jennifer asked Mr. Malone not to use the front door. Testimony will show that they asked him not to use the front door to ensure it remained locked for security. That Mr. Malone had a tendency that when he exited the front door of not locking the front door after he left. And that was the basis of the request that he access the house from the back door and not the front door. Mr. Malone was upset by this restriction, the rule that he could not access the house from the front door. Mr. Malone was in fact livid at this rule. Regarding the physical altercation itself, it took place in the home that James owned. James's fiancée, Jennifer, was also present when this physical altercation took place. Jennifer was located just behind James. And notably, Mr. Malone weighs more than James. He's a bigger guy. The evidence will further show that right before the physical altercation took place, Mr. Malone was upset. Mr. Malone had just exited the house through the front door. After he exited the front door, Jennifer, James's fiancée, shut the door and locked it. She shut the door with some force.
She blamed Jennifer.
Mr. Malone re-entered the house from the back door to confront James, as Mr. Malone had believed that it had been James that had shut the front door. Mr. Malone was frustrated that James had other plans for the home. He was upset at being asked to leave the property, and he re-entered the house to confront my client, James. Mr. Malone then picked up a note off the counter of the kitchen. This note was not addressed to Mr. Malone. It was not written by Mr. Malone. This note did not belong to Mr. Malone. When James reached for the note, Mr. Malone pushed James. Mr. Malone also raised his fist, kind of in level with his head, in the direction of James. This physical altercation was quick. It lasted only 30 seconds. There wasn't a lot of time for calm deliberation once it occurred. And this physical altercation ended with Mr. Malone's arm pressing down on James's collarbone. As you listen to the evidence in this case tomorrow, please pay particular attention to the testimony of Mr. Calvin Malone and what motivations might influence his testimony. The prosecution has the burden of presenting a case to you. The prosecution has the burden of proving that a crime was committed. James has no duty to prove his innocence. There is a presumption of innocence, and it's my request that you take that presumption seriously. This is a case of self-defense.
This guy's on 1.25
By the conclusion of the evidence,
too.
the state will not have shown that the force James used was unlawful. Thank you.
All right. So we are waiting for court to start today.
So members of the jury, we'll conclude for the day. Now you'll get your phones back and then you're free to go home. And then we'll start at 9 a.m. If you could all be back in the jury room tomorrow by 8:50, and then we'll be underway at 9 a.m. And we're still well on schedule to finish the case before the end of the day tomorrow. The instruction I gave earlier remains in place. I hope you remember the instructions I gave you with regard to the questions I'm sure you're going to get about your experience here today. And with that, have a good evening, and we'll see you tomorrow.
All right, so they're done. We're gonna watch. We're probably gonna jump over to Judge Simpson's court really quickly while we wait, because Thurston County, being in Washington, it's the West Coast. It doesn't come online for a while, so we've got to wait for them to get going this morning. And once they do, we're gonna pick up that case and follow it as it happens live. Now that we've heard the openings, it's a gripping case. You can tell. I mean, there's probably no jail sentence involved. I'm just spitballing here. I don't think there's going to be a jail sentence. But let's see. It is 11:30 here. Let's see. Let me ask Siri. a quick question here. What time is it in Thurston County, Washington?
It's 8:28 in Thurston County, Washington.
So they're either going to start at 8:30 or 9 o'clock is usually the starting time for them. So we might get a little bit of time here. Let's see. Everyone's just leaving for the day, packing up. I'm going home. Mics are off. There we go. He was sped up. The attorney was sped up. While we wait for Thurston to start, we're going to jump over to Judge Simpson, who's still working through cases as we speak.
Probable cause conference will be adjourned March 20th, 2000. Well, let's make it March 27th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus John Fulton.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with me on behalf of Mr. Fulton, who's standing to my right.
Hello. Hello. Your name?
John Fulton.
Thank you.
Your Honor, I would be asking for a 1-month adjournment. I did make a referral to our AIM division, and I think it's really important there's some social work intervention. I think that's going to be crucial to.
He was here yesterday, but I'm not sure what date we adjourned this.
Well,
let me see.
yesterday you adjourned, you had me on from out of Pittsfield Township for. No, go ahead.
No, that's okay. I don't mean to
For
interrupt.
Just don't
for
talk.
a traffic ticket.
That's right.
Right.
And I think it was adjourned, Your Honor, to the March 19th.
Okay. But this is obviously a more pressing issue, so.
On behalf of people.
Sorry.
All right. You wanted a month out?
I think that's what I actually asked social work this morning if they thought a month was a good time frame. I haven't heard back, but I think it's probably safe to assume that
They're going to take as long as they possibly can. They understand no urgency in it. No, I'm kidding. You can let them know I said that. Probable cause conference will be adjourned to April 3rd.
Thank you, Your Honor.
2025 at 9. Bond in this matter will continue.
Okay, thank you.
Court calls case People versus Tim Crawford.
Stephen Crawford. Right here. No, I know you are. Assistant Public Defender Jay Bellinger on behalf of Mr. Crawford, who stands to my right. Mr. Crawford, can you please state your name for the record?
Stephen Crawford. All right. I have a plea form that indicates that the defendant will be pleading guilty to 2 charges: attempted resisting and obstructing a police officer's account 4, the 1-year offense, and account 5, operating while visibly impaired, the 93-day offense. Upon a successful guilty plea to those charges, counts 1, 2, and 3 would be dismissed. That's the court's full understanding. Is that correct, counsel?
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Stephen Crawford. All right, Mr. Crawford, it is the court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes, sir.
All right, the first charge is that of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
The second charge is that of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail and $300 fine plus court costs. The court could order any community service or rehabilitative services the court deems necessary. Court could also order your vehicle immobilized, could order your vehicle forfeited, could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. Understanding all of that, well, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Moore in the 15th District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5, and you'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of rank.
Yep.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
And of your own free will?
Yes, sir.
Let's hear what he did.
November 14th, 2024, at the location of 380 Parkland Plaza, Ann Arbor, Michigan, Scioto Township, Washtenaw County, Ann Arbor, Scioto Township, Washtenaw County, State, Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
I had a couple shots of whiskey.
All right. Were you stopped by the police?
Yes, sir.
What do you mean, yeah? Were you stopped by the police or was there an accident?
I put the car in the ditch.
Oh, so that's an accident unless you did that on purpose.
Right.
Right? Accident. Police did arrive?
Angie, OG.
Yes, all right. Were you ultimately arrested?
Yes, sir.
Were you taken to the hospital or police station?
Both.
All right. At the hospital, was there a blood draw?
Yes, sir.
What were the results of that blood draw?
Your Honor, I believe that there was a combination. I believe the official results,
It was a 0.04 alcohol, but then 45 nanograms per milliliter of cocaine and some quantity of benzos as well.
All right.
Stipulate to that, Your Honor.
Alcohol.
Okay. You have no, stipulated to, you have no reason to dispute those results, do you, sir?
Put your car in the ditch.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and ingestion of those?
Yes, sir.
Drugs? All right. When you came into contact with the police, what happened that makes you think that you're guilty of the offense of
That trail's going on right now.
When I was detained, they put me to the ground. And I got put to the ground. My foot hit them in the face. So, yeah.
Okay, so they were just putting you on the ground.
Well,
What do you do?
I was resisting.
Thank you.
In what way were you resisting?
I
kicked
was
him in the
holding
face.
my arms back, and I wouldn't let them put my arms behind my back.
Because they were trying to cuff you.
Yes.
And you were resisting being cuffed.
Yes.
And that's why you went to the ground.
Yes, sir.
Yeah. Okay.
Defense is satisfied, Your Honor.
Court will accept the defendant's pleas guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. I don't know why people do that. It doesn't work out well.
Roman ADCC. Thank you. Glad we
Pre-sentence investigation as well as screening and assessment is ordered at 15th District Court. Sentencing in this matter will be
March 14th at 9 a.m. before Judge Moore.
March 14, 2025, 9 a.m. before Judge Moore. Bond with its conditions will continue.
All right.
Courthouse case, People versus Devin Gawthorne.
On behalf of the people, Your Honor.
Stephanie Can on behalf of Mr. Gawthorpe, who is approaching, Your Honor. Mr. Gawthorpe, when you are present, could you please state your name for the court?
My name is Devin Gawthorpe.
What are we doing?
That case is already
Why
going.
do you always have a conversation once you get
Your Honor, in this particular case, I did file paperwork for an adjournment. We're asking for a 2-week adjournment of this matter, Your Honor.
March 20th, 2025, 9 a.m. Bond continued.
Thank you, sir.
Thanks.
Court calls case People versus Gregory Davis.
Good morning, Your Honor. Raymond Cook with People.
Assistant Public Defender Dea Call on behalf of Mr. Davis, who approaches. Mr. Davis, can you please state your name for the record?
Gregory.
He's wearing headphones? What? Michigan shirt?
And Your Honor, we are.
You state your name, please.
Gregory Davis.
That gold doesn't look so bright today after the Maryland throw.
Oh, come on, Your Honor.
Okay, I'm sorry. I couldn't resist. Go ahead.
That team lost.
At this time, we believe all discovery to be complete, to the extent that we'd be asking the court to set this for a preliminary examination.
Judge is a big Michigan fan.
People have their witnesses available the 18th.
Yes, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge 4. Bond will continue. Thank you.
Thank you, Young.
Thank you, sir.
Text
Mays.
Sounds good. All right. I have a good number.
That's true. That's Mays. Because we have gold.
I didn't want to.
And gold is much brighter, especially today than Mays. Is that right, Mr. Allen? Thank you, sir. Court calls the case, People versus Brandon Jeever.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Gevers. Please state your name for the record.
Brandon Gevers.
Thank you, sir. You're requesting an adjournment now.
We are, Your Honor, for discovery purposes, and I would also ask to briefly address bond.
Probable cause conference in this matter will be adjourned to March 20th, 2025, 9 a.m. Yes, that's the bond.
Your Honor, we are requesting release on tether, a personal bond with a tether. My client, we have information that the complaining witness has left the state. He would like to go back to his home. He is very concerned about losing his home and his car, essentially most of his life in custody for longer. He is involved with this church. He's sober and he understands he has to come to court in the future. So we're asking you to consider release on a tether.
Response.
Your Honor, I would object to any modification of bond. In this case, the victim had been trying to leave the defendant because he had been mentally and verbally abusive. He became upset at the victim, pushed her on the bed, grabbed her neck with both hands, and strangled her. He was holding her down on the bed, and the victim described it as he was staring through her as he was strangling her. Afterwards, she thought she was going to die, and she wanted to call police, but she was afraid he would hear her. So she then drove to the police department to report the strangulation. She had red marks and scratches on her neck, and she said during the strangulation she began to lose consciousness and couldn't breathe, and remembered the defendant saying he would kill her. So I have very extreme concerns for her safety, even though she might not be in the state because of this event, Your Honor.
Anything else?
We're aware of the allegations in this case. I do think that a tether to his residence would protect both the complaining witness and the community in this case.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Yeah.
Your Honor, what was the date on that?
20th.
Thank you.
Court calls the case, People versus Matthew Gibbons.
Morning, Your Honor. Raymond Cook for the people.
Jake Hill, Judge, first of all, my apologies for being late today. I'm on one of the cases. PD has two. My case is 25 F5 5038.
I'm sorry.
No, go ahead.
Assistant Public Defender Chelsea Vergils with and on behalf of Matthew Gibbons on the older case.
All right.
Judge, on my case, Matt, you want to sign this? We're going to waive up the circuit court on. Judge, on my case, Matthew had decided that we would waive up the circuit court.
On 5038.
Yes, Your Honor. And he, for the record, he signed the waiver.
All right. What are we doing on the other two?
You would like to set a preliminary exam on his other two cases?
All right. So let's get the waiver out of the way. This is the case involving the possession of a controlled substance.
Correct.
So you're on that case, you're waiving your right to a preliminary examination?
Yes.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand you'll not have that hearing on this case and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right on that case?
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over on the single count on that case.
Oh, Your Honor, acknowledge to receive the information, waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in that matter will be set for
March 25th at 1:30 before Judge Cook.
March 25th, 2025, 1:30 before Judge Cook.
Thanks, Judge.
Birthday.
Bond will continue on that case.
So we've got two cases.
Other
One's going to go
matters.
to circuit. One's going to stay here.
Council discovery is complete.
I'm sorry, Your Honor. I'm getting new information currently. Do you mind briefly passing this matter so I can speak?
Yes, I do.
Just wave it.
I'm getting new information and I'm understanding that Mr. Gibbons would like to now waive his exam in the cases I represent him on. I would really appreciate a brief chance to talk to him about this new information.
Okay, never mind.
Pass it.
Thank you, Your Honor.
Nah, just
She is so frustrated. He gave her instructions right at the during
court does call the case People versus
the
in that
hearing that he
Harrison.
wanted to change what he was doing, and she's like, "Oh, call them campfires. Thank you very much." The camera buttons are actually automated. They're triggered by the microphones.
Your Honor, Assistant Public Defender Jay Bellinger on behalf of Ms. Harrison. Ms. Harrison, can you please state your name for the record?
Lynette Harrison.
Thank you.
And Your Honor, at this time, we are asking the court to set this matter for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 18th.
We'll try.
Preliminary examination will be set March 18th, 2025 in person. That's at 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of People versus Tyler Henry.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with on behalf of Mr. Henry, who's approaching. Can you state your name for the court?
Tyler Henry.
Thank you.
Your Honor, the people have
White.
extended an offer in this case. I have asked if they would hold it open till the exam. They indicated they would. So at this time, we would ask that this case be set for preliminary examination.
All discovery is complete.
To my knowledge, Your Honor, yes.
Yes, Your Honor.
People have their witnesses available the 18th.
Yes, thank you.
Preliminary examination will be set March 18th, 2025, 9 a.m. in person before Judge Moore.
The color of the jail outfit
Bond will
often
continue.
indicates
Oh, Your Honor, would Your Honor can entertain a motion or not?
Briefly.
status.
Okay, very briefly. Mr. Henry, just in full candor, does have a few holds. We're not sure if they would actually come get him at this point. This is a case from 7 years ago, from presenting a false $100 bill to the big boy. The big boy has since closed down and no longer exists in Washington County.
So that makes it less of a crime?
It doesn't, Your Honor.
Okay, go ahead.
Mr. Henry's in custody because he failed to appear previously. He does.
Where's he been for the last 7 years?
So he has been working. He's been living in Taylor, Michigan, which is the residence he'd return to if he is able to be released. He's a father. I have been trying to get in touch with his family. Unfortunately, haven't been successful with that, but he indicates that he does have a stable residence he could return to as well.
Why didn't he turn himself in?
I actually did turn myself in once, and then you guys didn't come pick me up. One time I was in the Inkster, I think, jail cell once, and you guys didn't even come pick me up. I watched my day.
They advised you, released you, and told you on and take care, right?
Yeah, I didn't have
Yeah. Did you come to Washington and take care of it?
Oh, you
No, you didn't. Okay, go ahead, Mr. Yagi. Anything else?
No, Your Honor.
No, I don't need anything from the people. Motion for bond reduction denied. Bond will continue. Thank
Thank
you.
you, Your Honor.
Court calls the case People versus William Johnson.
Alexander, on behalf of people.
Ryan Bowling will be able to Mr. Fence.
Is Big Boy a restaurant? Is it like a burger stop?
Just state your name for the record.
William Johnson.
Thank you.
Your Honor, we're asking for this matter to be set for exam. To my knowledge, all discovery is complete.
People have their witnesses available the 18th.
We'll try our best, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Barr.
Your Honor, may I address bond?
Here.
Thanks, Judge. Mr. Johnson is asking to be released. He indicates to me that he can reside with his mother in Charlotte. His mother is here in the courtroom, and she confirmed that today. He also indicates to me that he has a job that is waiting for him, or at least potentially waiting for him at a wastewater treatment plant in the Charlotte area as well.
You can make good money there.
He's 33 years old, has 5 children, none of them with the complaining witness in this case. There'd be no reason for him to have any contact with the complaining witness. He would comply with all the conditions of bond set at his arraignment. So we'd ask the court to consider releasing him on a personal bond with tether of people.
Your Honor, we would be opposed to any modification of bond. In this case, an argument began. The victim was trying to avoid the defendant, and he ended up going outside, coming back inside, beginning to yell and spit in her face. And then had distracted him with an opening to try to get him away from her. He then threw a bottle of hot sauce, a can, and a shelf at the victim. She then went to her daughter's room to get away from the defendant. He then kicked open the door to that room, pushed the victim into a wall, and began to strangle her with both hands around her neck and holding her up against the wall. She had to trip him to get away. He then began kicking and stomping on her ribs, and she started having trouble breathing after that as well. And her daughter had to call 911 to get the assault to stop. So I'd have great concerns.
Yes.
Your Honor.
Anything additional?
Nothing further, Judge.
Motion for bond reduction is denied. Bond will.
Thank you.
Thank you, Your Honor.
Yeah, don't do that sort of thing where you might not get.
Court calls case
bond
People
reduced.
versus Robert Lewis.
Ashley Laundry for the people.
Assistant Public Defender Shananta Carey, I can really, Your Honor, on behalf of Mr. Robert Lewis on all matters. Mr. Lewis, get your name for the record, please.
Robert James Lewis.
Judge, we respectfully request that all of these matters be sent to preliminary
All discovery is complete.
to our knowledge, Judge.
And all these matters with the people have their witnesses available the 18th.
We can try for that date, Your Honor. Thank you.
Preliminary examination in this case will be set March 18th, 2025, 9 a.m. That's in person before Judge Moore. Before Judge Moore, bond will continue.
Thank you, Your Honor.
Your Honor.
Thank you.
Thank you for the raid. Appreciate it.
Did you need some? Court calls the cases of the people versus Lee Patton.
Alexander on behalf of people.
We're about to return to Thurston County,
Assistant Public
Washington
Defender
for a
Constable
live
Basie on
trial.
behalf of Mr. Leandre Patton, who is present to my right. Can you state your full name for the record, please?
Leandre Patton.
Should start in about 10 minutes.
Your Honor, at this time, would you respectfully requesting to set this for a preliminary exam?
In both cases?
Yes.
All discovery complete?
To my knowledge, yes.
People have is available the 18th.
And may we briefly address bond?
Preliminary examination in this matter will be set March 18th, 2025, 9 a.m. Those are in person before Judge Barr. As to bond.
Your Honor, my client is asking for a PR bond. He has a child that he's expecting in 2 months. He has a job waiting for him on the outside. He has a family that he wants to support. He would be willing to go on a GPS or a hot zone tether or whatever the court may deem appropriate for him to get a PR bond.
Response.
Your Honor, I would object to any modification of bond in these two cases. The first case, the defendant had went to the victim's residence, tried to open the door, she found the door closed, and she had kicked down the door. She then tried to barricade the door with objects in the home. He still managed to break in, left when police arrived. While she was on the phone with 911 in that case, he took her phone and destroyed it. Then in a later case of 2025, he went to her residence, took her phone, credit cards, ID, and left, and he didn't have permission to be there or to take those items. He also has previous convictions for a CSC first and an AWIM from 2002, a CCW from 2020, and then a CCW in possession by felon from 2018. So I would just object to any modification of bond.
Yeah.
Anything else? Nothing further.
Motion for bond reduction denied. Bond will continue. Thank you.
Guys, don't even ask at this point. I realize your client wants you to.
Court calls case People versus Jeremiah Sawyer.
We're ready.
We tried to go to a Shoney's restaurant as a family. Well,
Is Miss Mackey lost her
driving
voice?
across the nation.
Well, actually, she's on spring break. She's doing us an honor by showing up today.
We got lost and
Saw
ended up
that.
at a
She goes on
Wendy's.
spring break, so she doesn't have to do anything.
No, not at all.
Not at all?
Not at all.
Because of the school calendar?
Yeah.
Huh? Whatever, must be nice to be the princess. Go ahead.
Good morning, Your Honor. Ashley Lonnie for the people.
She called me a princess. Hey. Laura Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Sawyer. Your Honor, we would respect.
Mr. Sawyer, can you state your name, please?
Yes.
Jeremiah Sawyer. Thank you.
Your Honor, we would respectfully request that this matter be set for a preliminary examination at the earliest possible date.
All discoveries complete.
To the best of our knowledge. Your Honor.
People have their witnesses available the 18th.
We will try for that date, Your Honor. Thank you.
Preliminary examination in person, March 18th, 2025, 9 a.m. That's before Judge Moore. Bond will continue.
Thank you. We won't be addressing bond.
Okay. She's telling you what to do?
Ms. Mackey would like to know that she's working.
Oh.
I mean, I hadn't seen it. I hadn't noticed, but
Wow. So she tells you, tell the judge this. And he just jumps right up to the podium.
Lauren, right there you are.
I know, Your Highness.
Sorry about the 5-minute
got to
delay.
that level.
But thank you for the rate. Appreciate you.
No, not all that. Some of that just comes natural. Court calls the case B versus Justin Tittle.
Justin Tittle.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And good morning again, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Tittle, who's approaching the podium. Could you state your name for the court?
Justin Lee Tittle. Thank you.
This matter was adjourned previously for discovery. The people have, we have an update on discovery. So at this point, we would ask that it be set for exam. And we believe that we have all discovery that is available.
I don't know what that means. All right. So discovery at this point is complete.
As far as we are aware, the discovery we were looking for is no longer in existence. So we believe that that it is.
It was in Canton.
People have their witnesses available the 18th.
We will do our best, Your Honor.
Preliminary examination will be set March 18th, 2025, 9 a.m. That is before Judge Barr. That's in person. Bond will continue.
Thank you, Your Honor.
They just did it. Crunchy Frog.
Court calls case of the People versus Michael Ware.
Ashley Lonnie for the people.
Brian Boley on behalf of Mr. Ware.
Who is approaching?
And
who's coming?
I don't know what's going on.
Okay, I'm coming.
Just state your name for the record.
Michael Ware.
Thank you.
Judge, we're requesting an exam. To my knowledge, all discovery.
People have their witnesses available on the 18th.
We'll try for that date, Your Honor.
Pardon?
We'll try for that date, excuse me.
All right. Preliminary examination in person will be set March 18th, 2025, 9 a.m. That's before Judge Moore.
Thank you, Your Honor.
Bond will continue. Thank you.
We're about to jump back to Thurston County for a one-day trial.
Court calls case of the People
Should start
versus
in just a
Jerry
couple
Ashley.
minutes.
When you get it.
On behalf of the people.
Mr. Public Defender, Chinaza Carey, I can really, Your Honor, on behalf of Jerry Ashley.
We did not sign in.
Oh, this is a Wayne County. All right, so Wayne County did not sign in. I will then adjourn his proceeding to the 27th.
No bench warrant?
Thanks, Rich.
This judge has some style.
Yes, so
That's gonna go last.
that is Miss
Constantino's.
Constantino's case, but I don't,
She's here.
oh, huh, you are short. I did not even see you. All right. I mean, I felt it, but it's just. Okay, that's gonna,
That's gonna go
are
last.
they, okay,
I think I have everything you need.
on this one?
On that one. Yeah.
Okay,
It's over there, but
okay, it's over there, so you
Yep.
gotta get that.
you're down to just recalls.
Yes.
So Mr. Gibbings, that's Mr. Geo's recall. They have Mr. Gibbings' recall.
Are you ready on Gibbings? Court recalls case People versus Gibbings.
Good morning again, Your Honor. Raymond Cook for the people.
Assistant Public Defender Chelsea Virgil with and on behalf of Matthew Gibbings, who approaches. Mr. Gibbings, please state your name.
Matthew Gibbons.
Have we seen him before?
I apologize for the delay, Your Honor.
Yes.
He would like to waive his right to a preliminary examination
In both of these cases?
in both, Your Honor. And
Is that correct, sir?
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution as you did in the other matter?
Yes, I do.
Okay. People also waive their right? in this
Yes,
case?
Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court in the 3 counts between the 2 cases. Mr. James,
we acknowledge receipt of the information, waive its formal reading, and stand mute as to the charges.
been in every way, formal reading, standing mute as to both count, as to all counts, I should say.
Court will enter not guilty on his behalf.
Pretrial in these matters will be set for
March 25th at 1:30 before Judge Cody.
March 25th, 2025, 1:30, Judge Combs. Bond in these cases will continue.
Any minute
Thank you.
Thank you, Your Honor.
Any minute now, Thurston Washington's going to come online, and we're going to jump to that one. We watched just a few minutes ago. We watched the openings, which were given last night, yesterday. We watched jury selection as well, which is always a treat out of Thurston. So that case is going to be starting here shortly, and I'll jump to it as soon as that happens. We'll stick with Judge Simpson until then. The other jewels, thanks for gifting 5 memberships. I'd rather be day working. And 4 great people besides that. I can
Recalls case People versus Sheldon Brement.
Andrew Childers praying on behalf of the people.
Brian Bowling on behalf of Mr. Brement.
MJ Spidey and Cheese Curd have it.
For the record again, please.
Membership.
Shale. Your Honor, thank you for passing this matter and recalling it. At this time, my client will waive his right to the exam.
Is that correct, sir?
Yes.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People also waive the right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Thanks, Judge. Waive formal reading, stand mute, ask for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for April 24th, 2025, 1:30.
Thank you, Your Honor.
Bond continued. Appreciate it.
We're almost done with this block.
Call the case People versus Nathan Burns.
Andrew Childers praying on behalf of the people.
And Assistant Public Defender Samantha I can really on behalf of Mr. Nathan Burns. Mr. Burns, state your name for the record, please.
Hello, Nathan Burns. I have a plea form. Is that what?
That is correct.
Plea form indicates that the defendant will be pleading 2 counts and added count 4 and 5. The first charge is attempted resisting and obstructing a police officer. It's a 1-year misdemeanor. I think the fine is wrong on here because it should be a $1,000.
Josh, thank you. 10
Fine.
gifted memberships.
1,000 for 1 year, $1,000 fine plus court costs. And the count 5 is operating while visibly impaired. that being the 93-day misdemeanor. Upon a successful plea to those charges, counts 1, 2, and 3 would be dismissed. There's further the agreement, no delayed or deferred sentencing. That's court's full understanding of the agreement.
That's our understanding as well, Your Honor.
That's correct, Your Honor. Thank you.
All right. May I have him sworn?
And do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but so help you God?
Yes.
State your name.
Ayden Burns.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to 2 charges. Is that correct?
Yes, sir.
First charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that?
Yes, sir.
All right. The second count that you'll be pleading to, the added count 5, is operating while visibly impaired. That's a misdemeanor punishable by up to 93 days of jail, up to a $300 fine plus court cost. Court could order any rehabilitative services.
These charges
or community
often run
service
together.
The court deems necessary. Court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
Understanding all of that, do you
Andrew,
still wish to
thank you
plead
so
no
much.
contest?
Gifted membership.
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
To the chart, well, and I also had to advise you, you understand I would not be your sentencing judge.
Yes, sir.
And that while I'm taking your pleas, you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. So, sir, to the charge of attempted resisting, obstructing, how do you plead?
No contest.
To the charge of operating while visibly impaired, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights for every day, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on the floor.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And all right. Court has been provided Michigan Department of State Police report for their case number 8086-24. Any objection to the court has?
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of these offenses. Counsel, have I complied with the court rule?
People satisfied.
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of no contest to counts 4 and 5. Counts 1, 2, and 3 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered as well as screening and assessment. Sentencing in this matter will be April 10th, 2025, 10 a.m. before Judge Washington. Bond will continue.
Judge, can I address bond just very
You want me to lock him up?
No, absolutely not, Your Honor. Mr. Burns tells me that he is scheduled to lay his mother to rest on Saturday this week. He is also on his way to the Air Force, right?
Air Force.
To the Air Force. So he will begin basic training on March the 25th. That is going to be in San Antonio, Texas. In regards, he wanted to see if we could get the sentencing date, but we'll just contact 14B to get a better date for that, unless this court could do something about that.
No, I don't have another day.
Okay.
Because he has to go through the screening. Sure. Somehow they'll have to figure out how to try to work.
Absolutely. And I'll explain that to him, but he just wanted permission to be able to travel to San Antonio, Texas on the 25th. You know, when you'll be back.
When will you get back?
July the 9th is his return date. How long is basic training?
I don't.
Okay.
What are you talking about?
He's going to basic training in San Antonio, Texas for 8 weeks, Your Honor.
Correct. But he's trying to leave before his sentencing, right? That's currently set.
That is correct.
So you're gonna have to address that with
Okay.
Judge Washington,
No worries, Your Honor.
okay?
I will reach out to the court and let them know.
All right,
Thank you, Judge.
thank you. Thank you. Ready on this one. Court does call the case People versus James Falconpour.
Good morning, Breakout Assistant Special Attorney.
And Christina Costantino appearing on behalf of Mr. Vapopor. Looks like they are probably going to get him.
Oh, my God.
Okay.
No, I didn't.
While we're waiting for counsel approach.
Let's see. Trying to get, we're waiting for the court to begin up in Thurston County, Washington, so I'm going to check that and watch for when it opens, but it has not started yet. It's a short little trial, shouldn't take long. Do have an update on the podcast. My podcast partner, Thomas, is feeling a ton better, but he can barely talk. and so we're going to give him a pass today on the podcast. I'm going to check and see if we want to fill in with a substitute for 1 week, or if we're just going to take the week off. You're saying, please, Mrs. R.A. I don't know what her schedule is. I'll have to check with her. We might open it up. Might open it up to craziness. It makes the mods work really hard, but I don't think he has strep. I think it was like one of those, the flu or the cold bug or something was going around. Josh is available. Thurston's live. Let me just pull it up here. Thank you very much. Let's actually jump to this one. We'll stop. Thurston County Courts. Okay. It did just go live just a moment ago. Okay. Here we go. We're all standing as people come in, so we'll pick it up right here. Thank you, Tomoto Troy, for the reminder. My phone has not yet shown it was live, and that's where I was checking on it. It was not updating. Not getting any audio yet. There we go. Here we go. It's the beginning of the trials. The state begins, and our defense is off sitting watching. The jury's off to our right. We watched jury selection last night. There's 6 jurors, 1 alternate. Judge is sort of sitting where we are, but a little to the left.
Opening statements, and Mr. Holcomb, you may call your first witness.
Thank you, Your Honor. The state calls Mr. Calvin Malone to the stand.
Mr. Malone, if you'll remember, is the renter or the friend of the defendant. The defendant owns the house. The defendant wants him out, change the locks, said, quit going out the front door because you leave it unlocked. And the defendant went out the front door, left it unlocked. The girlfriend slammed the door and locked it. The defendant Mr. Malone walked back into the house and said that wasn't called for. And a fight began. It was captured on camera. We might see a sliver of that as the TV that's going to play it is sort of on screen. But ended up with a assault, criminal mischief charge as the homeowner trying to kick someone out of his house.
So before we start, and Mr. Holcomb's getting some things ready, I just want to let the jury know. Again, as I said yesterday, this is a holdover from COVID, which people are apart from each other. So if at any time you can't hear anything, let me know. Either get my attention or wave, or I'm looking away, say excuse me or something. So it's very important that you hear all testimony. And with you, sir, I would just ask you to speak to the back of the room so everyone can hear you. Okay.
The witness is right underneath us.
You may inquire.
Thank you, Your Honor.
You can turn the podium too.
Could you please state your name for the record and spell it?
Calvin Malone, CALVIN,
Okay, could you, was everyone able to hear that? Okay, no. So again, tap your ear or just let us know if you're hard of hearing, if you aren't able to hear, okay? All right. So, how did you come to live at the residence located at 8235 Day Drive?
We don't need the address.
I helped Mr. Turner purchase property, and we made an arrangement there.
Okay. Could you describe that arrangement to me?
Yes, several years ago, approximately 12, maybe 14 years ago, we were having a discussion about the fact that both of us had experienced homelessness at some point in our life, and that we were trying to do something to help alleviate that. And so we had a common interest, and that's how we met. So when I got out into Thurston County from my previous address, I started looking for a place to live, but then COVID hit, and I was living at the Olympia Zen Center at the time. The community at the Olympia Zen Center was trying to help me find a place to live, because I'm on Social Security, and it's a very low level of Social Security, and with the current housing situation.
Okay, so fast forwarding a little bit to when you encountered the 8235 Day Drive Southeast address. Did you purchase that property on behalf of Mr. Turner?
Well, Mr. Turner had asked me to help him locate an inheritance, and that's why he'd asked me to find a property while I was searching for a place to live for myself.
Okay.
And I found it for him, and he asked me to purchase it because he gave me power of attorney. And after transferring the funds from his inheritance from a bank in Detroit to a trust attorney, I made the purchase and let him know that, well, prior to that, I told him that the house needed a lot of work and repair, and the grounds as well. It's on 1.5 acres or so, and a lot of manicured landscape. So I said I would, I helped him purchase the property, and then he said, since you're looking for a place to stay, what do you think about the idea of living there and doing the maintenance work and cleaning it, doing the landscaping and repairs and so forth in lieu of rent?
Okay.
I thought it, because of our mutual desire to work on homelessness, and this was a 3-bedroom home, and that we can use property for that purpose, I thought it was a good idea. And I thought it was just an ideal fit.
Okay. So approximately when did you move into the house?
October of 2020.
Okay. And approximately when did Mr. Turner move into the house?
August of 23.
Okay. August of 23. So there's roughly a 3-year gap there, correct? Okay. So, and during that time, could you just describe what you were doing to the property?
On the exterior, I did all the landscaping. I bought all the plants back that the previous owners had planted. I fixed the asphalt driveway, repaired the garage door, reset the sprinkler system, painted the entire interior to help repair the floor, and did some sealants on the roof, removed the moss, power washed the building, painted the deck, the wraparound deck, and had to bushwhack and clear the grounds, some of which took a year or two, depending on which project I was working on that particular time.
Okay. And during that period, did you pay for anything other than repairs?
I did. James covered all the major repairs because there were some big things that needed to be done, like new water pipes and so forth, which is beyond my ability. I cleaned the entire house, and so that's pretty simple. Painting it is just step-by-step thing from one end to the other. But it was, and often I would submit a receipt for purchases, but sometimes it was just difficult when I was working and I ran out of paintbrushes or something to go and fill out another request and then have it approved and have the trust attorney send me a check. It's just too much bother, and I just do it out of pocket. I was living there. I thought that was a responsible thing to do. Other than that, I paid for all the utilities from the very beginning to current.
Okay.
Wow.
I'm still maintaining the
Okay.
Not your typical squatter situation. That's
and just to clarify, is this address located in, like, what city is this address located in?
It's right on the border of Lacey and Olympia.
Okay.
So it's very difficult in the southeast side near
Okay. So it's located in Thurston County?
Yes.
Okay. Do you see Mr. James Turner in the courtroom today?
I do.
Could you just point him out to the jury?
He's at the defense table.
Okay. Can you just describe what he's wearing?
He's wearing a hoodie of some sort, gray shirt of some kind, and looks like sweatpants.
Okay. Let the
Sweatpants
record
and a
reflect that the witness has identified the defendant.
It will.
All right. So at the time that you were living in the house, was the plan for you to live there long term with Mr. Turner, or what was the living arrangement there, like the planned living arrangement?
Like I said, we had talked about making the home into a transitional home, and because it was extra bedrooms and other outbuildings. So when we wrote, excuse me, when we wrote the tenant agreement, I wrote it up for 5 years. James signed it, and we agreed to that. My time there could expire October 2025, with the option of extending that if we both agreed to that. Because we had no idea how long it would take to do the renovation and get approvals for housing for homeless and reentry.
Okay, so there's a written agreement between the two of you for you to be there from until October 2025, potentially to extend it.
Yes.
Okay. In the weeks leading up to June 30th of 2024, can you describe your relationship with the defendant? Well, firstly, had Mr. Turner moved into the house by then?
Yes.
Okay, could you just describe your relationship with the defendant at that time?
It was confusing to me.
Okay. Could you further elaborate?
After our discussion about what we wanted to do with the property, when he arrived, he moved into the master bedroom with the ensuite bathroom and never came out. Week after week, month after month, and I constantly tried to find out. I thought he was having difficulties or something, so I didn't want to intrude on his life. But at a certain point, after several months, it was baffling to me that he didn't engage in repairing the home, getting involved in anything that had to do with the maintenance of the home, no communication. So this caused us to have issues about what we're going to do moving forward.
Okay, so there was a lack of communication there and engagement from Mr. Turner.
Yes.
Okay. Did you go on vacation in May of 2024?
I did.
Okay. Could you describe returning home after vacation?
I returned home. All my kitchen utensils, a lot of my property had been removed and had disappeared, some of which I found in the garage. The front door lock had been changed. Later, I discovered, excuse me, that the garage door keypad had the code had been changed, and access to the garage had been locked.
Okay. And did Mr. Turner inform you that these changes would be happening?
No.
Okay. Did Mr. Turner provide you with the key to the residence?
No, I was able to get a key to that door from the neighbor that he gave the key to a neighbor, but he did not give me the key to the front door. However, he did send me a text message, even though we're living in the same house. He texted me and said that how was that put? From henceforth, your designated entrance is the back door.
Okay. Did he tell you why?
No.
Okay. The keypad, did Mr. Turner ever give you a code to the changed keypad?
No, despite the fact that my moved property was sitting in the garage and I couldn't access it. He did not, and I wasn't aware of it. I had, because it's still my responsibility to take care of the grounds. On a certain day, I wanted to get in the garage and the keypad didn't work. Not unusual. Sometimes wires come loose. Once before, and the garage door did not open. So I checked and I couldn't get in, but I had left the windows open to air it out. So I climbed through the window, opened the door from the inside to access it and then get tools. And then on that particular day, I was going to water the plants and do some gardening. But James was with his girlfriend downtown somewhere. And, apparently, he had set up a security system and was watching me and called the police and said that I had broken in, and they arrived.
Okay. So, would it be fair to say that the relationship between the two of you had deteriorated? Were you two on speaking terms? You described a lack of communication.
Yeah, I tried many times to ask if we could sit down and talk about the property, talk about our future. He said he would often say, "Well, not now."
Okay. Did you communicate with one another through any other means other than speaking to each other?
I don't know. I don't understand the question.
Such as leaving notes, papers around the house.
Objection leading.
Oh, he did give me an eviction notice that he had typed up and taped to my bedroom door.
Okay.
Sounds official.
That was one. I don't recall leaving. I did send him, I think, emails about a list of repairs that still needed to do that were more costly so that he could decide which ones he wanted to prioritize. But I think that we did not really communicate a lot at all with writing or written communication.
Okay. You said earlier that the defendant attached an eviction notice to your door. What was your response to that?
It was a 2-page eviction notice. It listed that I owed $12,000 for the cost of 2 other people who were temporarily staying there. One was in an RV in the driveway, and one was in a home occasionally. And that both of those individuals, when I asked them about the issue, they said that James had told them that they could stay as long as they liked, no matter what. He said that I owed $12,000 for their stay, which kind of baffled me, because if you're going to invite people to stay, why would you charge someone else for that stay? also repairs that, a broken light switch that someone else did, that I had not repaired it, and that he billed me $40 for. And there were some other things that were very similar to that. So I approached James and I tried to let him know that if he wanted to evict me, we have a written agreement. But according to Washington tenant laws, if he wanted me to be evicted, he has to serve me properly. And the reason I wanted that to happen is because without it, I have to pay for an attorney to represent me in this eviction process. Whereas if he evicts me officially and files this to the court, then I have the option, because of my financial limitations, I can get an attorney without cost.
Okay, so your response was essentially to take me to court. Okay.
Okay.
Showing you what has been marked as State's Exhibit number 2. And do you recognize that?
I do.
Okay, can you tell me what it is?
It is a flash drive.
Okay, can you tell me what's on the flash drive?
Of the incident of the alleged assault.
Okay, so by incident of the alleged assault, do you mean like a photo, video, like?
Video.
Okay. The state moves to admit State's Exhibit number 2.
Mr. Shashevsky, any
No
objection? Okay. It'll be admitted.
Permission to publish?
You may.
Thank you.
See if we can watch part of this on the TV. Please don't slide it or move it closer to us. Like back it up towards you. That'd be good.
You've seen what's depicted on this video, correct?
I have.
Can you just describe to me what happened in the minutes leading up to the video? So like say 30 to 15 minutes before the video starts.
Yes, I had noticed that the hanging plants in the front porch had not been watered. And so I was looking out the window at them and I said, well, I'll just go out and water these plants. If I go out the back door as my designated door, because I was not allowed to use the front door. The front door has a carport, which is easy access to the car. You go from the car to the steps to the porch and you're inside. Or if I use my designated door, I have to go from the back door around the back side of the house, along the side of the house, along the front. And so it just did not make sense for me when I simply, we were all in the house. So there was not a need for security. It was daytime. I thought, no problem, I can go out the front door. I went out the front door to water the plants, and suddenly the door slammed. I was startled and proceeded to water the plants. Admittedly, I was pretty angry about the fact that I had been treated that way. So I went around the house to my designated door, went in, which leads into the utility room and into the kitchen. James was standing at the far end of that common area and watching me. His girlfriend was sitting on the couch. And I said, James, that was not cool. He rushed across the room up to me, which caused me a little bit of anxiety, but he stopped and we started talking. And that's what led up to it.
Okay.
Here we go. Do we get to see? Please show us. Hope it all happens on the left side of the screen. Don't move it. Don't move it. Don't move it. Don't. Defense lawyer wants to see as well. You might have some adult language here.
So starting just playing it straight from the beginning with audio up. Can everyone clearly see it? No. Or should I move it a little bit?
This way.
Can everyone see the whole screen?
This way. Move it
okay. Or yeah, well, those yes.
Heard that. It's recorded on a potato. There's nothing that we can see. Got
All right.
That was the crime.
That is the entire video. I'm going to start it back from the beginning. Pause it. So first off, was everyone able to clearly see the video? Now that's a little small in the corner there, but everyone's got a clear view. Okay. So starting it off here. So who is seated on the couch there?
That's his girlfriend, Jennifer. I think her last name's Slender.
Okay. And there are two individuals approaching from the right side into camera view. Can you tell me who those are?
Yeah, that's James and I. I'm facing the camera. James is back to me.
Okay. So do you recall, the audio isn't particularly clear, but do you recall the substance of the conversation that's happening here?
I really don't.
Okay.
Nope.
All right. So can you describe what's happening here?
I felt, and I remember distinctly that part where I felt this conversation was not going to go anywhere. So I was going to go to the front living room, and which leads to my bedroom. But I changed my mind and came back.
Okay, so the front living area you're talking about, is that out of view of the camera? Okay, so is that to the right of the screen?
It is.
Okay. All right, can you describe what's happening here?
Jennifer just said the F word.
Well, we'll take it in pieces. Can you describe what you're doing here?
I was coming back to the living room, to the kitchen, because I felt that somewhere along this process, I felt really uncomfortable about where things were going. But I knew that James had set up the camera, and that if he followed in this corner, that where I'm sitting, it's a camera facing this way. And I knew that if something bad happened, at least I would have the assurance of the video. So, because there are no other cameras anywhere else. And if I'd gone to the back and they followed me, and if something happened, there would be two people's word against one.
Okay. So it's difficult to see because it's relatively small, but can you tell me what that is? Or
That's a note.
okay. Where like
it was on the counter. James sometimes would write me a note, or they would leave some writing or something. I wear bifocals. I can't read any distance at all. Things were escalating. His girlfriend was yelling, and I could see that at first James and I were conversating. It was not the most pleasant conversation, but it had not escalated to a point of where I was concerned about the outcome. So James and I were talking. She got up off the couch and said whatever she was saying, and I could see James getting more agitated. At about that time, I turned my head and saw the note, and I thought that if I'm looking at him and I'm responding, he may become more agitated or might escalate the situation. And I've learned throughout my life that if you're not confronting the person, that sometimes it'll de-escalate if you look away for a moment, turn your head, or do something that is not non-threatening. I saw the note. I was curious, is this another note to tell me I'm evicted, or is this another note to tell me something? So I picked it up to bring it closer, and that's when things went completely out of hand.
okay. And at this point, did you know what was on the note?
No.
Okay. All right. All right. Can you describe what the James is doing in this video?
Well, he lunged for me, and I thought he was lunging at me, but in actuality, I found later, moments later, he was lunging for the note.
Okay.
And saying, "This is not for you."
Okay. So at this moment, is he making any physical contact with you? Okay. Can you describe that to me?
It was more like reaching for the note in my chest area.
Okay. All right. Going back a little bit. 27. All right. Okay.
It's mine.
I'm showing you what has been marked as defense exhibit number 9. Can you just describe what that is to me?
It is very similar to what is depicted on the screen. I have the note in my right hand, and after he had lunged it at me.
Okay, but we're going to start to go through the process of introducing it first.
Okay.
So you recognize it. Is that an accurate depiction of what's in the photograph?
It is.
Okay. State moves to admit defense exhibit number 9.
No objection.
That'll be admitted.
All right. So, permission to publish.
You may.
I'm going to hand this to you, and then you can just pass it down after you've taken a look at it.
They pass it around the jury box.
Collect it from juror number 7 on your back. Juror number 7 at the end, and you guys are done looking at it. All right. So, can you describe what is happening in that photograph and also on the screen here? They're fairly similar as what you said. Can you describe what's happening in this?
Yes, everything went very, very quickly. When he lunged at me, I tried to push him away. I still had the note in my hand.
That makes him
I'm
the instigator.
left-handed, so I pushed him with my left hand and had the note in my right hand.
Okay, so you're pushing with the left hand and you have the note in the right hand.
Right, because I didn't know why he was lunging at me until he said, "This is not for you."
Okay. So you don't know what's on the note at this point?
No. Okay. I still don't.
Okay. And at this point in the altercation, you don't know why he's lunging at you?
No.
Okay. So is that a raised fist? Like, are you raising that as a fist or?
No.
Okay.
It was reaction. he's rushing at me. I have my left hand, I push, and he was reaching for the notes. I went back like that.
Okay. Okay. Is everyone okay? Thank you.
Been filed with the court.
Hey, did you hear, were you able to hear what was said just then?
No.
Okay, let me increase the volume.
That will help. It's such a bad recording.
Bear with me, there's a soundtrack going on. So it's overly loud, I apologize.
Warning.
Did you hear that?
It's garbled to me.
Okay. All right. So going back a little bit.
The witness can't remember what was
After
said.
he lunges at, what are you doing at this moment?
I'm watching him. I'm looking at him. To see what he's going to do next. I turned sideways to avoid his outreached arm. I don't know because his hand's moving very quickly toward me. At no time did I hit him or anything like that. I just was watching him.
Okay. All right. So can you describe what's happening here?
Yes. Between the previous frame and this frame, that's when he had hit me on a glancing blow to one side of my face. And then I turned my head. And as soon as I turned my body, he was behind me and grabbed me around the chest area and throat and threw me to the ground.
Reverse pile driver.
Can you just describe what's happening here?
Lands on top of me.
Do you recall what's being said here at all?
I don't know what is being said.
Okay. All right. Can you describe what happened there?
There was some point from prior to falling to the ground when I was starting to get to a point where I said enough is enough. And when I hit the ground, I'm sorry, but to chuckle, but I was thinking, it's weird how your mind works. I was thinking, I'm too old to be falling to the ground. You know, I'm 73 years old. I'm not going to be having a hip fracture. And this is what's going through my mind as I'm on the ground. And so right at that point, I said, that's it. And I just rolled over. At the same time, I was trying to keep him from getting to my face. I rolled over and on top of him, put my forearm.
Okay, so I think that we're about to get to that point. Okay. So let's get to that point first.
Get off
right, so it's obscured as to what's going on the ground here, but can you describe what's happening here? To the best
this is exactly what I was talking about just now.
Okay.
I had him on the ground, holding him down, had my forearm across the collarbone, and I said, "This enough is enough. Enough is enough." And he kept struggling, and she was yelling. It was a very confusing time. So I got up. As soon as she yelled, "Get up!" I was already in the process of trying to get up because he was no longer in danger to me.
Okay. All right. Can you just describe what happened there?
That's when I got up, and I was thinking about going there's a bathroom on the other side of that wall to the right of her and me. And I was going to go to the bathroom and check my face. I picked up my glasses and put them on, but they were askew. And so I was going to look in the mirror.
Okay.
Do we have his glasses as a item of evidence, or just pictures?
So I'm going to be showing you what's been marked as plaintiff's exhibit number 3 and plaintiff's exhibit number 4.
Yes.
Can you tell me if you recognize what's in those photographs?
Yes, those pictures are of James Turner.
Okay. And are those consistent with how the defendant appeared on June 30th?
It is.
Okay. State moves to admit plaintiff's exhibit number 3 and 4.
Mr. Krzyzewski?
No objection.
3 and 4 will be admitted.
Okay. Just permission to publish your own process as before. All right, so going back to the altercation when James is on the floor, where did you say your hands were located when he was down on the floor when you two were struggling?
Around the collarbone, the front collarbone side, and so on, like this.
Okay. Do you recall if you grabbed the defendant's neck or if the defendant had any problems breathing or anything like that? Okay. So no as in you don't recall, or no as in that didn't happen?
I don't recall because of so much going on at that time.
Okay.
So you tried to choke him out? More pictures of broken glasses, maybe?
I'm going to be showing you what's been marked as State's Exhibit 5A, 5B, and 5C. All right, so starting from the left side, Exhibit A, can you tell me what's depicted in the photograph?
It is the pair of glasses I was wearing at the time of the incident.
Okay. How do you know those were the glasses you were wearing at the incident?
Because they were bent and they look exactly like the glasses I put on when you see me get up. Right there, I just put on my glasses.
Okay. So is that an accurate representation of them on that day? Okay. And the same question with the center photograph. Can you just tell me what that is?
Yes, same pair of glasses, different angle.
Okay. Accurate representation?
It is.
Okay. And the final picture on your far right, can you tell me what's in that
Turns
photograph?
around to see which.
2 pairs of glasses. When I had purchased these, there was a special at Walmart, I believe.
There's Walmart.
I was able to buy 2 pairs. I mean, they're both identical.
Okay. So you say they're both identical. Is there any difference between them now?
The one that I was wearing during the incident was bent. The other pair shows how it looks when it's not bent.
Okay. So they're identical copies and one reflects what the other looks like before this incident. Okay. Your Honor, the state moves to admit plaintiff's exhibit 5A, 5B, and 5C.
Any objection?
No objection.
Okay, they'll be admitted.
Permission to publish?
You may.
The jury now has these pictures to look at as well. Got 2 pair of glasses, identical at Walmart on sale. Now one is bent and one is not. One is permanently bent, apparently, and the other is not.
All right. So, were you able to wear the bent glasses after this incident?
Well, I tried to rebend them, but it was not possible.
Okay. Did you take them to get looked at by what's the word? An optometrist. Thank you. Did you take it to get looked at by an optometrist or someone who sells or repairs glasses?
I took them to an optometrist to see if they could be repaired, and they laughed.
They laughed. Okay. Can you just expound on that a little bit?
Well, I said, is there any way for it to be taken to a repair shop and rebent or something? Because I was not looking forward to the price tag of a new pair of glasses.
Okay.
And so they said, just
objection. I believe this going into hearsay.
It is.
What the optometrist said.
Sustained. I mean, you can stop, and then Mr. Holcomb, you can ask your next question.
Yes. So did you have to purchase a replacement for these glasses?
Yeah.
Okay.
Curtis Stanley, welcome. Thanks for clicking the subscribe button. The repair shop laughed when they said, can you rebend the glasses?
I'm showing you what has been marked as Plaintiff's Exhibit 6A.
Is this a receipt for the new glasses?
Can you describe to me what that is?
it is a lab copy of the Walmart Vision Center receipt.
Okay.
A pair of glasses.
Okay. Are they for your pair of glasses?
They are.
How do you know that?
My name is on the receipt.
Okay. And is that a fair and accurate representation of the receipt?
It is.
Okay. The state moves to admit State's Exhibit 6A.
Page is a single exhibit.
Yes.
Mr. Stashevsky?
No objection, Your Honor.
6A will be admitted.
Okay.
I think
And
we must be done with the witness here soon.
Using that receipt, can you tell me how much you paid for the glasses?
$274.40.
Okay.
$274.40. Is that for two pair? Or is that the replacement pair?
Published, Your Honor. You may.
So what's the difference between an optician and an optometrist? One deals with glasses and one deals with eyes? I mean, they probably have some crossover at some point, you'd think.
Okay. So we're not going to.
He's just showing it again, the whole thing, for effect.
All right. So not going too far out from this incident, could you describe what happened roughly 5 to 10 minutes after this incident? That's in the video.
I don't even know. I don't know. There wasn't anything that happened.
Okay. Do you know if anyone contacted law enforcement?
I did.
Okay. And did law enforcement respond?
They did.
Okay. And when they arrived, did they interview people?
They did.
Okay. And did they take any photographs?
They did.
Okay.
Ready to turn the witness over to defense for some slow-paced cross-examination.
So, were you able to see what Jennifer was doing throughout this encounter?
At what point?
At any point, like at what point were you able to see what she was doing?
I knew she was sitting on the couch when I walked into the kitchen area and told James that it was not cool to slam the door. My assumption was that he was the one that was slamming the door.
Okay.
I might need some blue light lenses.
Nothing further, Your Honor.
Okay, cross-examination.
Mr. Stashevsky, you may cross-examine.
Thank you, Your Honor.
Now you're going to hear that he actually talks very slowly. We heard him last time on 1.25 speed. Apparently he doesn't need all that with him. There we go. Oh. Bring the rest up again. He's getting his steps.
First of all, good morning, Mr. Malone, and thank you for your time today.
Good morning.
I'd like to start with the end of your testimony there. You mentioned that the officers took some photographs when they came out to the property.
Yeah.
I'd like the record to reflect that I'm going to show the prosecutor what has previously been marked, Defense Exhibit 4 through 6.
Mm-hmm.
Then, Your Honor, permission to approach the witness?
You may.
Mr. Malone. And if you could, Mr. Malone, just describe, do you recognize those photographs?
I do.
And what are those photographs?
I recognize myself.
And are they fair and accurate copies of the photographs that the officer took that day?
I would have to assume so, yes.
And is it fair to say in reviewing those that they do not show any injuries to your person?
That's true.
No scratches?
That's true.
No red marks?
Right.
No bruising? And Your Honor, I would move to admit exhibits, defense exhibits 4 through 6.
Assault does not require
Welcome.
No
those
objection,
to be
Your Honor.
present.
And permission to publish, Your Honor?
You may. And they'll be admitted.
Thank you, Your Honor.
You're welcome.
For some reason, I'm getting tempted to take a shot of hot sauce, like Ian Runkle. Spice up the trial a bit. Just pausing while the jury looks at the pictures. The charge of assault does not require the victim to have visible injury. So lack of bruising, scratches, marks of any kind, that might give you an indication of how severe the assault may have been or may not have been. But it's not. I mean, it's not guilty. Do I have milk standing by? I do not. But this is not spicy. This is just mule sauce from Sticker Mule. Yes, the company that makes our channel stickers also makes hot sauce. I like it so much. They sent me one bottle for free as a gift when I bought stickers. And I just ordered 8 more bottles. So this is one of the 8. Myron says, I've got not guilty so far.
Now, stepping back a little bit in time, kind of going to the beginning, this incident took place at a house located at 8235 day drive southeast, correct?
No.
What was that's not the correct address?
8236.
36, thank you. And James owned that home, correct? And you did not have any ownership interest in that home?
Objection, Your Honor, calls for legal knowledge and legal conclusion.
Overruled.
Could you repeat the question, please?
The last question I asked, Your Honor, was you did not have an ownership interest in that home?
I'm going to overrule the objection. You can answer the question.
Please ask again.
Yes, you did not have an ownership interest in that home.
No.
And you and James had been roommates in that house since August of 2023.
That is correct.
At that time, in August 2023, you and James were great friends, were you not?
And long before that, very good friend.
You believed the house was going to be used to help people recover from homelessness as a way to kind of get on their feet?
That had been our discussion.
And in fact, at least one person who was struggling with homelessness lived at the house periodically while you and James were roommates. Is that correct?
That is correct.
And who was that individual?
John Ashton.
Now, regarding the
Don,
and you were the one to invite John Ashton to come into the home, correct?
Yes, because there were times when I couldn't do the work by myself, and so I hired him to help.
And just to clarify, John Ashton was living there kind of on and off again basis. Regarding the living arrangement between you and James, you were living there full time, correct?
Correct.
But you did not pay any rent.
That is correct.
In exchange for living there rent free, I believe you testified that you were responsible for maintaining the property and kind of the upkeep of the house.
Repairs, maintenance, renovation, and upkeep.
You did a lot to improve the value of the home.
I did.
You felt that James did not show any interest in home improvement projects.
He did not respond to my request to show interest.
And you felt that James expressed no gratitude for your efforts?
He never thanked me once for anything that I did there.
And you also helped James out in other ways. You transported him to appointments.
Often.
You took him to driver's school.
Yes.
You took him shopping.
Yes.
And you took him to obtain emergency medical care if that came up.
I did.
And James never thanked you for any of that.
There were several times when I transported James. I think he thanked me. I can count on one hand. I would say probably 3 times.
Is it fair to say that you felt taken advantage of by James?
I think taken advantage of is not correct. That's correct.
But you felt that he didn't express any gratitude for your efforts.
Which
particularly keeping the property in good repair.
To do the renovation and everything described here, yes.
In May 2024, a third person began living with you and James, correct? It was May 2024. James's fiance, Jennifer Latham.
I'm sorry, I forgot.
Is it fair to say that after Jennifer moved into the house, James came up with a plan for the property that was different from the one that you envisioned for the house?
I knew nothing of such plan.
When you say you knew nothing of such plan, you knew nothing of James's plan for the property?
Yes.
Okay. Is it true that you believed when Jennifer moved into the house that you no longer fit in James's plan for the house?
I think that the circumstances obviously have changed, but I assumed that this was just that since he had his own bedroom. That's where she was going to be, that she was going to be part of our original plan.
You believe that even though Jennifer was going to be there, that the house was still going to serve as a resource, a vehicle for people recovering from homelessness? And I guess I was looking for more of a yes or no question to the question of that you believed when Jennifer moved in, that you believed you no longer fit into James's plans.
I never thought of it that way.
And just so that the record is clear, do you remember having given an interview with myself, Mr. Streeter, my investigator?
I do.
I would like to show the witness a copy of the transcript of that interview. And that interview, that transcript was previously marked as Defense Exhibit 13.
Here's impeachment.
And I'll show a copy to the. Oh, do you have a copy? Yeah, I got a copy. I just need to know what page. Yes. This will be on page, and first I'll hand it to Mr. Malone. Mr. Malone, do you recognize that as the transcript of the interview?
This is the first time I've seen it, so I can't have recollection of something I haven't previously seen.
Oh, sure. And you can kind of page through and take a look, particularly maybe at the first couple pages.
It's a certified transcript. I don't think he needs to.
Okay.
And then, Mr. Malone, I'd like to direct your attention to page 78. Lines 2 through 3. And I'm going to read those lines 2 through 3.
Okay.
And I'm just surmising here, this is you speaking, Mr. Malone, but I think that I no longer fit in his plan.
Mm-hmm.
And I think that she, that being referenced as Jennifer, had a tremendous amount of influence. Did I read that correctly?
You did.
Thank you. Moving forward in time a little bit, from late May through early June, you went on a vacation, correct? And when you returned, the locks to the front door had been changed, correct?
Yes.
The access code to the garage keypad, I believe you testified, had been changed.
Yeah.
But you were still able to access the home when you returned from the vacation.
Initially, no.
You continued to live in the home.
I did.
And one of the doors in the back of the home, the locks had not been changed. Thank you. Now, in mid-June, an eviction notice was taped to your bedroom.
It was.
And that eviction notice requested that you leave the home by July 12th, 2024.
That is correct.
You did not believe that that eviction notice was enforceable.
I don't know if it was enforceable or not. I just felt that it was not proper.
So you weren't sure whether it was enforceable?
According to my understanding of tenant laws, I felt that it was not proper.
That it was not proper, which means you didn't have to, in that moment, abide by what it said.
Correct.
Thank you. Is it true, that being the case, that you had no intention of leaving the house by July 12th?
That is correct.
The physical altercation at issue in this case took place on June 30th, 2024. So just a few weeks after James told you that he was asking you to leave the property.
Yeah.
In June 2024, one of the house rules that Jennifer and James asked that you abide by was that you use the back door of the house to enter and exit the property. Is that correct?
Jennifer never asked me. James sent me a text saying that my designated door was the back door.
So it was your understanding that as of June 2024, the request was that you use the back door to enter and exit the property.
That is correct.
Thank you. You were really upset by this rule that you not use the front door.
Yes.
In fact, you were livid at the rule that you not use the front door.
I had a number of emotions regarding it, and livid might have been one of them.
I would like to direct you again to the copy of the transcript. This would be page 43.
I had a number of emotions regarding
line 17.
Livid might have been one of them.
What number was that again?
Page 43, line 17. And I will read that. Actually, I'll start with line 15 and read through 17. And so he, James, sent me a text that said, "This is now your designated door." I was livid. Did I read that correctly?
Yes, in context.
And you believed the rule that you not use the front door was similar to racial segregation that African Americans suffered during Jim Crow. You believed the request that you enter the house and exit the house in the back was on par, was similar to the racial segregation that African Americans suffered during the Jim Crow era.
Yes.
In the minutes before the physical altercation took place, you exited the front door of the house to, I believe, water plants on the porch, and the front door was shut behind you.
Yes, it was shut.
And you didn't actually see who shut the door.
That is correct.
And so then you went around the house and entered from the back door.
I did.
And I believe on direct, you testified that you were pretty angry. Those were the exact words I wrote down.
Yes.
And is it fair to say that you entered the house with the explicit intention of confronting James?
No.
Do you remember submitting an affidavit to the state prosecutor's office in relation to this case?
I do.
And I believe that affidavit was dated December 2nd, 2024. So that was some period of time after these events. So you had time to think carefully about what you were going to put in that affidavit?
Yeah.
And was that affidavit completed under penalty of perjury?
It was.
So that meant that everything you were going to include in there was going to be accurate and truthful.
To the best of my knowledge.
Your Honor, I would show the prosecutor what has previously been marked Exhibit 14, which is
affidavit.
Could you just tell me what number you're going to reference?
This is to show that the witness was angry. That possibly would allow the defendant the right to defend himself and act in a certain manner.
Actually, I could get it from the third. Make sure he has a copy.
Okay.
I'm not pushed one way or another by him not saying thank you for what you're doing. If they had a contract and it was, you do all this work, in return I don't charge you rent, it may have been a bad contract, but he got what he signed up for. Asking for anything else, even if it's just a thank you, would be more and above and beyond. Now, it doesn't sound like the landlord was the most personable type individual.
And
And
I'd ask
Jennifer
you and
definitely escalated
Mr.
things.
Holcomb to approach the bench first, please.
Yes.
And the other one.
Jim Crow, I don't know if there are any. Obviously, we don't know who's on the stand. I've never seen the witness at all, so I have no idea if there's any racial differences between the witness and the defendant. But invoking that as saying that using the back door is equal to or was similar to, that's a strong argument. It might be.
Thank you for your patience there, Mr.
Weakening.
So
or lessening
does what I handed you, what is that?
That is the transcript of audio recording interview of me by the investigative street.
Oh, I'm sorry. I apologize. I haven't given you the copy of that. My apologies. Here we go. That's what I'm looking at there. So the document that I just handed you, could you tell me if you recognize that document?
Yeah, I do.
And what is that?
That is an affidavit that I wrote. And I notarized.
Thank you. And the question I had asked was, after the door was slammed behind you and you re-entered the house from the back of the house, you said that you did not enter with the intention of confronting James. And what I'd like to direct you to is to page 5 of this affidavit. And I will read lines 15 through 16. I told James Turner that his angry response by slamming the door was rude and uncalled for.
Excuse me, I'm not following you here.
Oh, yes, I apologize. It's page 5.
Page 5 as the bottom of the page 5?
Correct, on the bottom left.
Okay.
It says affidavit of Calvin Malone, and then it has a number.
Okay. I have 21, 22, and 23.
And then there's lines on the side of the page. And I'm going to read specifically lines 15 through 16. It begins with, I told.
Your Honor,
Yes, I see. Go ahead, Mr.
Your Honor, I would just briefly object and ask that all of 23 be read. And it's fine if defense counsel wants to focus on that, but I feel like the greater context of.
Okay, so for now, I'm going to overrule your objection. Mr. Krzyzewski can use this exhibit that hasn't been admitted as he sees fit. If you want to, you're going to have a chance to redirect. You can address what you like to address that. Go ahead, Mr. Krzyzewski.
Taking one more step back, the question I had asked was whether you entered the house from the back to confront James. You said no. I'm now going to read these 2 sentences from the affidavit that you submitted. I told James Turner that his angry response by slamming the door was rude and uncalled for. This was the first time I ever confronted him for the way he had been treating me. Did I read that correctly?
That is correct.
Thank you. Now, before this physical altercation took place, you were holding a note, correct? You had testified on direct that you had picked up a note from the kitchen counter.
And you said before this altercation, I'm not sure when the altercation begins, is when we start talking and before Jennifer starts yelling.
Before there was any physical altercation, you were holding a note.
Yes, I reached for the note.
And you had not written that note?
No, I have not.
That note was not addressed to you?
That note was not addressed to me.
Did you laugh when you read the note, when you saw the content of it?
I don't recall laughing.
Now, when James reached for the note, you did not feel threatened, correct?
I don't recall if I felt threatened or not. I reacted.
I would like to direct you to a portion of the interview transcript in front of you. And for the state's benefit as well, this will be page 72, lines 7 through 13.
72.
Yes, page 72. Lines 7 through 13.
I'm just guessing the girlfriend's out of the picture by now.
And
I have nothing to base
this
that
is
on.
the beginning is me.
That's a guess.
And I say, and that's why I was asking the question of when James reached out, did you find that threatening? Your answer, Mr. Malone, no. I state, Mr. Stashevsky and myself state, okay. And then you state, Mr. Malone, not in the sense like he was attacking me. Did I read that correctly? Now, when James reached for the letter, you pushed him.
Yes.
That's.
And were you were aware that there were cameras recording the inside of the house during this physical altercation?
Singular. One.
And I would like to direct your attention to what has previously been marked Defense Exhibit 9, and I believe this was previously admitted State's exhibit. It's the still frame of the photograph. May I obtain that from Madam Clerk?
Yeah. Are these your exhibits?
I was going to refer to an exhibit that the State previously.
Okay. Those, the admitted exhibits are right here. You can go ahead and look at those. Pick out the one you wish.
What we have here is an admission by the witness that there was no threat prior to him making physical contact with.
So, Mr. Malone, I believe you testified on direct that you didn't have your hand in a fist, but you did hold up your hand. You were kind of mimicking what was in the photograph and kind of had something like this. Is that correct? Okay. And that your kind of fist was, you were facing James when your body was in that position. Is that correct?
Yes.
Thank you. And I will return this to you. Now, at a certain point, the physical altercation moved into the kitchen. It kind of started in the living area, but it moved into the kitchen area. Is that correct?
Right on the border of the dining room and the kitchen.
And then when it ended, you guys were in the kitchen.
Yes.
There were knives in a butcher block on the kitchen counter.
Whoa, weapons now. Hang on.
The physical altercation ended with your forearm on James's collarbone.
Yes.
Jennifer was pretty distraught during this physical altercation, yelling, screaming, upset.
Yes.
Did you, after you got up off the top of James, did you kick him before you exited the room?
No.
After the physical altercation was over, you believed James or Jennifer was likely to call the cops.
Yes.
And you believed that they were likely to tell the cops that you were the primary aggressor in this physical altercation.
Objection, speculation.
Sustained.
You were wearing glasses during the physical altercation? And they cost, I believe you testified, over $400?
Yes.
But you have no documentation regarding the cost of those glasses?
Not with me today.
And the glasses you were wearing during the physical altercation, I believe you testified that they had some bend a little bit in the center?
The stem and both stems and center, yes.
And you replaced those glasses with a pair that cost $274.
I don't recall the exact amount of the new purchase, but it's in that neighborhood.
And Mr. Malone, how much do you weigh?
I weigh 189.
189 pounds.
Yeah.
Now, after this incident, James began residing elsewhere. James no longer lived in the home. And Jennifer no longer lived in the home. You continued living in James's home.
I did.
Objection relevance.
So I might respond.
I will rule the objection, but you can move on to a different side. You can move on.
And you've continued residing in James's home.
Yes.
And since this physical altercation on June 30th, you have not been paying monthly rent.
Objection relevance.
I might respond, Your Honor.
That's overruled.
Since the physical altercation on June 30th, 2024, you have not been paying James monthly rent, correct?
You never had a monthly agreement. That's correct.
And just to clarify, since this
We
incident
never
on
had a
June
monthly
30th,
rent
2024, you've been living at the house without paying rent. No further questions.
Members of the jury, before we start Mr. Holcomb's redirect, we take morning and afternoon breaks. We're going to take our morning break now. We'll be in recess for about 10 minutes. And we'll be back in 10 minutes. The instruction I gave at the outset of the case yesterday remains in effect. You have heard some evidence now. Don't discuss among yourselves about what you've heard thus far. All that comes at the end, but we'll take a break right now. We'll be back in session in 10 minutes. Then Mr. Holcomb, you can have your redirect.
Oh, you have a break coming up right here. So I did just take a double swig of mule sauce. It didn't burn the throat, but I'm feeling it in the tummy. Wow. I might need some. Do we have any milk? No, we're out of milk. I should have thought of that before I took the swig of the mule sauce. It's not hot. Like, I swallowed it too quickly.
We'll be back in 10.
Okay.
I actually love this.
So you can use the restroom if you need to use the restroom.
I love it on rice. It's delicious.
You doing well?
Maybe Tums? Sorry. Tums might.
Do you want to use the restroom or get a drink of water or anything?
Yes, I need some water. Milk, actually.
Okay, yeah.
Sometimes
here's
the
a full water bottle for you. You can have that on the stand with you if you want. So.
Oh, that was our witness.
I would prefer that we just stick around here unless you need to use the restroom or something, just because we don't want witnesses interacting with jury members, and I don't know if they're going to leave, go to the restroom, mingle outside, all that. So.
That was, it's actually really tasty. It's not super hot. I'm just finishing off my first bottle. Have not started the second bottle yet. Is sauce supposed to be consumed that way? Probably not. It doesn't say not to. It's only 3 out of 5 peppers for heat. So Ian would be disappointed, but yeah, it's it's not hot when the first ingredient is red bell pepper. Cheetos. That'll heat things up as well. I do have the Cheetos dill pickle variety, but they're flaming hot Cheetos. Why are we drinking the hot sauce? I thought it was a good idea at the time. So, I didn't have anything to put it on. A Red Pen, tell him again. Let's see. What did Red Pen tell me before? Without having seen the video of the altercation, the advantage seems to go to the old guy for me. He appears truthful and honest. Watching the defendant, he seems sus. Rebecca has no mercy for me. It's my own fault. Okay, let me talk just during the break, if we can, just briefly. With Thomas out of commission for tonight for the podcast, I had already invited Mrs. R.A. on, and she just got back to me, and that may be a go. Maybe a go. I know Josh has also volunteered, and so we might go ahead and do a podcast. The reason why I don't want to skip it is the first podcast of the month, which is the one we give away memberships on, gift memberships. So I'll see what we might end up doing is doing a little Q&A with Mrs. RA and myself. So that really just opens up all sorts of fun topics. And then also depending on how things go, if there are no questions, we might open it up to allow a couple, short-term guests to be able to pop in and say hi. Oh, hang on. Hello. All right, we said the name and it summoned him. Thomas is on the phone. Thomas, you there?
I'm here. I wanted to provide proof of evidence of why I can't do an hour-long show tonight. Here, I feel 10 times better than I sound, but my mini-me has caught it as well, so it's best to take the night off. But what I think, I would like to hop on at some point in time and just give a quick hello and say hi, and you and Mrs. RA and everyone else do the show.
That would be
awesome.
At least
check in. It's the first one of the month. You give away memberships. It's always so much fun. So I don't want to completely be gone, but I as you could tell, I won't make it an hour. It's my voice.
Yeah. You've already deteriorated in the moments we've been on the phone. The hello sounded really good, and now we're fading fast. Well, that sounds great. We'll obviously let you up the hook if you feel up for it. We'd love for you to dial and connect. Obviously, you can join anytime if you want to, or call on the phone. We can do the burner phone. So, but we'll probably do some Q&A with Mrs. RA and maybe get Josh on and a couple other people. So, but we do have a question.
Lots of fun. That'll be perfect.
How's the bird? How's the parrot?
So the parrot is, so the name is Mango. I don't remember if I shared that or not.
Yeah.
That's what it's been. We were told, weeks of, in the cage, so it knows its food and where to go to the bathroom. And, you can pet it with the finger through the cage. And then she's, or he, it, we don't know yet, has been hanging out on my daughter's shoulder. My wife's Slender was hanging out on my daughter's bed the other day. He
owns the house.
Anyone leaves the room and leaves him solo on his cage, he squeals to the high heavens and says, "Get back here right now!" And so he is king. Mango is king of the house. He's settled in quite nicely.
That's awesome. Thanks for the update, Thomas. I look forward to being able to check in with you tonight on the podcast and rest your voice till then. So.
Will do. My wife told me the same. She said, "Get some rest. Don't do it." And I said, "But I feel like this is a better radio voice than my regular voice." So
it's an improvement. No, I liked how it was before.
I've been called ma'am in the drive-through fast food places before, and that won't happen with this voice. So I kind of like it.
Sounds awesome, Thomas. Thanks for checking in.
All right.
Talk to you soon.
Yeah. All right. Bye.
All right. See, I told you. He's not feeling the best. Okay, we're going to jump back to court really quickly because they're talking during the break, and we're trying to catch up.
I think glasses, but I don't know. Yeah, I think I did. Yeah, 6A. So the judge just needs to sign it.
Okay.
Yeah, it was my mistake. I should have collected it and brought it over to the judge.
All right. While we wait, we're now going to fast forward because we are a few minutes behind. We're going to wait for them to stand up. Not there yet.
There's two parts, one on each page.
There we go. Back up.
Send into the plan. Yeah, that was, I believe, 2 places. Yeah.
They're still just talking over documents.
Yeah.
Jury instructions, possibly. There we go. They're standing up. We're back.
Stand back up.
This hot sauce is actually good. It doesn't burn anymore. It's tasty. I'm excited because they've upgraded the bottle.
So you can be seated in the courtroom.
Oh no, it's the same. I thought it had a flip top, but it's the same screw off.
Mr. Holkins, you may redirect.
Thank you, Your Honor.
This is redirect of the same witness. Let me find I've got the little clip we can
So
see.
backing up
Show him what he looks
a little bit, the bigger picture here. Defense counsel specifically referenced in the transcript on page 77 through 78 that you believe that the plans had potentially changed. Is that correct?
Yes.
Did Mr. Turner ever sit down and talk with you about those changes in plans?
No.
Okay. Did he ever send you an email or a text talking about those changes in plans?
No.
So did he at any point explain to you in any detail the changes in the plans?
No.
So just from the context, you had, I believe, your exact words. I can look for it real quick.
I'm gonna cut and show you. While you keep hearing the current audio, I'm gonna show you what
on page 78
what this looks like.
Well, we'll start with 77. There's the last paragraph. Starts with the words "and then when."
Yes.
If you could read that paragraph
That's the witness.
up to the point where it says Investigator Streeter. So everything from there to the point where it says Investigator Streeter on the next page.
And I apologize, counsel. What page was that?
Page 77.
Thank you.
It's the last paragraph, line 23. Thank you.
Hot sauce and lemon in your water.
Okay. And if you could just read from that paragraph to where it says Investigator Streeter.
When he got hooked up with Jennifer, it was about building a gazebo at the lower end of the property, setting up lights in the woods, having fairies and goblins and Wiccan stuff going on. And I'm just surmising here, but I think that I no longer fit in his plan, and I think that she had a tremendous amount of influence.
Fairies, goblins, and Wiccan stuff?
You mentioned changes to the property, like seeing changes on the property. So would it be accurate to say that you concluded based on those changes in the property that were going on that the plans had changed?
Yeah.
Okay. And specifically on page 78, it says, and I'm just surmising here. So what do you mean by surmising?
I'm guessing.
Okay. So you're guessing. Okay. So this isn't something that was previously discussed beforehand with Mr. Turner? The plans changing?
Oh, no.
And did you ever indicate that you had spoken with Mr. Turner about the plans changing on the property?
No.
Okay. Going to the affidavit, which I believe you also have in front of you. If you turn to page 5, we're going to go to section 23. That's the section defense counsel referenced, I believe, 2 sentences in this section. So if you could just read all of number 23. So that starts from line 9 and ends on the next page at line 2. Just as loudly as you can so that everyone can hear you.
Yes, and if anyone can't, I speak softly, so please say if you can't hear me.
Your Honor, I might object to the first line as including a legal conclusion that's there for the jury.
So members of the jury, occasionally we take breaks. You're going to go outside for just a moment and then go back in the jury room for just a minute. I anticipate this will just take a minute or two, and then we'll come back in session. Same story. Everything come up there. Go ahead and read what, read what Mr. Holcomb directed you to read.
Okay. On June 30th, 2024, the day of the assault, I went out to the backyard to deal with gophers, after which I accessed the house through.
So hang on just a second. When you say, is it the assault?
Yes, yeah.
Okay, I'm going to overrule the objection. I'll allow him to read from that. And then you can either cross-examine him on that, or you can address that in argument, whatever you wish to do. You can bring them back in.
Please try it on the podcast. It is good. Birthday cake upside down in a bowl with milk. It is delicious. It becomes soup, really. It's cake soup is what it is.
Fast. You can take a seat. And Mr. Holcomb, you may continue.
Okay, just wait until everyone's situated. Okay, if you could, again, just read number 23, that's starting on line 9, and it ends on the next page on line 2.
On June 30th, 2024, the day of the assault, I went out to the backyard to deal with gophers, after which I accessed the house through my designated back door to use the bathroom, then went out through the front door to water the plants on the porch. JT aggressively slammed the door.
So just really quickly. So JT, what's JT in reference to?
Sorry, it's James Turner.
Yeah, thank you. You can read it as it's written. I just want the jury to know what JT means. Go ahead.
JT aggressively slammed the door behind me. After watering the plants, I went around the house to enter the house through the designated back door. JT and his girlfriend were in the TV room adjacent to the kitchen watching me for reaction. From the kitchen, I told JT that his angry response by slamming the door were rude and uncalled for. This was the first time I ever confronted him for the way he had been treating me. He rushed toward me and then stopped just inches from my face, yelling. I was not sure of his intent, but tried to remain calm to avoid further aggravation. This was recorded on his security camera. JL.
So what's JL?
Jennifer Landrum.
Okay.
Suddenly got up from the couch and moved toward us, yelling loudly at me, goading JT on. I noticed a note on the counter, and assuming that this was addressed to me, I ignored JT and reached for the note. At that moment, in a fit of rage, JT grabbed my wrist and appeared to be on the verge of striking me. I pushed his arm away and tried to step back, but JT quickly moved forward and grabbed my upper torso, forcing me to fall backwards on the floor. JT grabbed at my face, and I felt that he was trying to hurt me, so I tried to block his attempt with my forearm. I was able to gain control and got up, grabbed my glasses from the floor, put them on the bent glasses, and walked away.
Okay, so going back to defense counsel specifically asked you to reference lines 15 and where was it? There's a specific line about confrontation. So number 15 and 16, if you could just read from I told to treating me, if you could just read that section, because I think that's the section defense focused in on.
Are we talking about the affidavit?
On yeah, the affidavit. So if you go to page, so it's same section, so it's page 5.
Okay.
I'll switch to page 5, and then 15 and 16. So starting from I told, and then ending at treating me. Yeah. So just that section.
I told JT that his angry response by slamming the door was rude and uncalled for. This is the first time I ever confronted him for the way he had been treating me.
Okay, so You mentioned confront in this affidavit. I think you may have mentioned it elsewhere as well. Can you tell me what confront means in this context when you said it at the time?
Yes, in this context, I meant that I never talked to him about the many things that he had done that either aggravated me or insulted me or treated me in a negative way.
Okay.
I never talked to him or sent him a text or anything of that nature.
So you're speaking of verbal confrontation. Yes. Okay. So this, according to your affidavit, was the first time that there was a real verbal confrontation about this.
Making sure here, there were, yes.
Yes. Okay. So defense counsel earlier asked you if you're intent upon re-entering the home through your designated door, whether you intended to confront the defendant at that time. What did you believe defense counsel meant when he said confront?
Objection, speculation.
Sustained.
Okay. In the context when you were coming in, what were your intentions when you came in?
Objection, asked and answered.
I'm going to overrule that objection. He can answer this question.
Please ask again.
So when you re-entered through your designated door, what was your intention? What was your goal?
I don't recall exactly what my goal was. I know that I intended to let him know that I was not pleased with the fact that he had slammed the door.
Okay. Did you at any point intend to physically confront the defendant?
No.
Okay. In the photographs that defense counsel showed you, there weren't any marks on you, correct?
Yes.
Okay. Did you find the defendant's conduct offensive when he interacted with you physically?
Objection. Calls for a legal conclusion.
No.
Overruled. You can answer that question.
Please ask again.
Were you offended by the defendant making physical contact with you in the video? Were you offended by his actions in this video?
And
Okay, describe your feelings. How did that make you feel?
I was shocked, frankly, deeply hurt.
Okay, shocked, deeply hurt. Okay.
But was it offensive?
During the altercation, specifically, you mentioned you were on your back. Did you have any concerns about your physical safety?
Please say, ask again.
When you were on the ground and the defendant was on top of you, did you have any concerns at all for your physical safety?
I do.
Okay. With permission from the court, I would like to publish State's Exhibit number 2.
And which one is that?
It's the video.
We've already seen it like 3 times.
Okay.
Okay, prepare your ears.
Right. So defense counsel asked you if you had written the note on the counter, and you said no, correct? Did you at that time, when you were reaching for the note, or during this struggle, did you know whether that note was addressed to you or not?
No, I did not.
Okay. When did you discover the note was not written to you?
I came to the conclusion with James that it's not written to you.
Okay.
During the struggle.
And at what point, I'm going to play it back a little bit. At what point did the defendant tell you that it did not belong to you? Right there?
Mm-hmm.
Okay. So is that before or after the defendant lunged for your arm? You want me to play it back?
Yes, please.
Okay.
How many times do you get to play the video?
I grabbed it, he lunged at me, then he said that it is not for me.
Okay.
Yeah, but you also said you weren't threatened by his lunging, that he didn't make contact with you, and that he was only reaching for the note.
Counsel talked about how the interaction starts in one room and moves into the other. So I just want to play, and we're focusing on where the altercation starts and where it ends up. So at this point, what room would you say both of you are in?
James and Jennifer are in the dining room area. I am partially in the kitchen and partially in the dining room area.
Okay. Okay. Where are you now?
I'm on the floor. James is on top of me.
Okay. Did you plan on moving the altercation into the kitchen?
That's where it ended up. No.
Okay. Defense counsel mentioned that there were knives in the kitchen. Is that correct?
Yes.
Did you at any point reach for a knife?
Never.
Did anyone in this video ever reach for a knife?
No.
Did anyone in this video say anything about knives?
No.
So the knives just happened to be in the kitchen where they belong.
It was on a butcher type block. Yes.
Okay. So if I could get State's Exhibit. So on cross-examination, defense counsel talked about you estimating the cost of the glasses at $400, correct? So was that your estimate at the time, or did you like look up numbers for it? Like, where did you come up with that figure?
That is the amount of my insurance covered some of it.
Okay. All right. So, and I've shown you this exhibit previously. It's Exhibit 6A. So, and can you just tell me what that is again?
That is a Walmart Vision Center receipt for an order for glasses.
And if you flip over on the next page, it's got the rest of it.
And this is a lab copy of that order with the same order number.
In front of the Walmart.
Okay. Does it list the total that you paid for the glasses on there?
Yes.
Did you pay for those? Did you pay for that?
Yes, I did.
Okay. Oh, Do you know roughly how much the defendant weighed during this incident? Like, do you have a rough estimate?
I do.
Okay. How much would you say he weighed?
230 to 40.
230, 240. How much would you say that you weighed during this incident?
190, 200.
Okay. Nothing further, Your Honor.
Could you return that? Please?
Yes.
And then Mr. Stashevsky, any recross examination?
Yes, Your Honor. Mr. Malone, you were upset when you re-entered the house.
Yeah.
No further questions.
May this witness be excused?
Yes, Your Honor.
Mr. Stashevsky?
Brought the binder up for that.
You may step down and you're free to leave.
Or you can sit in court and watch. That's also an option.
Your Honor, if I could just ask for a 5-minute recess.
Why?
Yes, you may leave. Yes, okay, you can take a 5-minute break. Jury's going to go back to the jury room, and then stay in session.
Wait for the jury, please. He can't hold it. He was headed to the bathroom. He's like, I really need to go. Now he's out of here. Nope. Still waiting.
You can be seated. Do you have additional witnesses to call?
Your Honor, the state just reserves the right to call the deputy as a potential impeachment witness. Okay. I'm primarily asking for the recess to, Mr. Malone's belongings are upstairs.
No, that's fine. Yeah. That's what I was going to ask. So you're going to rest following this.
Yes.
Is that correct?
Yes.
Okay. And then if you plan to make sure he's available, because we're not going to wait around if you decide to call the deputy or recall Mr. Name escapes me at the moment, but recall the first witness for whatever reason. They need to be available. Do you understand that?
Yes, Your Honor.
All right. We can reconvene in 5 minutes. Then actually, as long as you're here. So the state's going to rest. You have witnesses to call. You have one listed witness, and then maybe Mr. Turner.
Is it Jennifer?
Who do you wish to call? Who do you plan on calling?
Your Honor, first we call Miss Jennifer Lanham, and then we call Mr. James Turner.
Okay. Go ahead. We'll be back in. Just go ahead, go upstairs, give him the stuff. And then as soon as you come back, we'll call him back in. You can rest on the record. And then Mr. Stashevsky, you can call your witness.
Okay, so we're going to skip ahead so we're all caught up. Oh. Let's see. Back up.
Okay. So is that before or after the
I think we're still in break. There we are. We are live. Okay. This is it. I thought we were behind, but we're not. Can you imagine if there was a code brown? Oh, look. They shut off the feed for now. So we'll have to wait for them to come back. Let me move my hot sauce bottles. This is good stuff. This is really good. Jennifer's might be spicy. She was I guess the Wiccan in the house. See if we can get. Oh, the mental health court's going. We're not going to watch that one. Shows 5 minutes ago they finished, so any second now they should be back. Easy on the hot sauce. We're already down one for podcast. It's all good. Watching for the live stream so we don't miss anything. Want to watch it live instead of delayed. There's 2, there's 4. They were going to release the girl from the Slender Man case, but with new evidence, the judge may stop the release. Slenderman, that was the 2 schoolgirls that stabbed their friend to please Slenderman, who was a fictional character, right? That's a weird one. A little creepy, too. That was in Wisconsin? All the judges in Thurston are working right now.
Who Mr. Madison's been over in the family court and is.
Let's see. Yes, Wisconsin. Are we taking a break for the ex-girlfriend the RA broke up? I didn't break it up. I just guessed that they were done. Let's see. Red Pen says, I looked it up. A 5-ounce bottle of mule sauce. Yep. 31 teaspoon-sized servings per bottle. That's the right size. I'm pretty sure. I probably had like maybe 2 or 3 servings is all. Links don't work in here, Barb. Sorry. Zero calories per serving. It's because they're so small. Okay, it's been 9 minutes since they were live last. It's supposed to be a 5-minute break. Link for the hot sauce. If you go to Sticker Mule, do you have the Sticker Mule page? Sticker Mule is the company that makes our stickers, our magnets and our stickers. And they make some great stuff. Like, let me show you here. It's called Sticker Mule. They send me this every time I order something. They send me something that says Sticker Mule on it. And then they send me little, I've got like Where's Waldo Sticker Mule as well as just the regular one. And this is their hot sauce. They even send me coasters, mule sauce coasters. There's the link. That's where we sell all our stickers and our magnets. So we also have a few shirts that are available over there. So my hair's doing funny things today. Okay, it's been a 10-minute break. Gonna let your hair grow long and go gray with all the hot sauce. There's only one Ian Runkle. I would never take over our favorite elf's position in LawTube. The coasters is set the mule sauce on when you run for milk. Sounds about right. Sorry, I'm watching for the restart so we can get the resting from the state. And then the Jennifer's testimony from the defense. Not happening. It's usually loaded with salt. Yeah, it's 20 milligrams of salt, which is 1% of my DV per serving. They're not at lunch. They're just on a quick break, trying to get the new witness in and get the old witness his belongings out of the office, apparently. Guess he brought some stuff to court that needs to be returned to him. It's just not starting up again. It's been 13 minutes. The 5-minute break has turned into 13 minutes, which is weird. Check the sugar. Man, I can barely read these things. Let's see. Total sugar is less than 1 gram. This is just healthy stuff. I'm telling you, it's good. It's good hot sauce. There might have been a code brown. It says right, Risky Dogs. Maybe there was a code brown. We're going to need to take a little longer break. Checking everywhere and it's not restarting. Jennifer did some magic. Samantha, let me check mod chat. Thank you. This court does often shut down their live feed, especially on jury deliberations. And then it's almost impossible to find it once they come back. Okay, 15-minute break. How long do you need? Guess when he said he wanted a break, he really wanted that break. So the plan tonight is to continue with the live stream without Thomas, sadly. And then we're going to have Mrs. RA on, and then we might open it up to allow some others to come in and join us temporarily. We've got Josh who wants to come. We might allow some of you to come on and make an appearance. We'll share the StreamYard link so you can join us. If you've never joined from StreamYard before, it's actually remarkably simple. If you have a device that has a microphone and a camera, and you're able to be in an area that's not noisy and lit well enough that we can see you, you've pretty much got everything you need to join, because any device can join StreamYard just by clicking a link, and you're there. You're there with us. And it's a lot like being on a Zoom call for you on your end. You don't need to have like that open and YouTube or anything else. It's pretty easy. So I guess they forgot to go live again. No, because I think it's tied to how they record everything. My guess is Code Brown. I think we had an accident. Okay, so we're going to jump over to Judge Cedric Simpson then, while we wait for just a minute. Apparently they're waiting as well. How long have they been waiting?
On the last.
About half an hour. There's a federal hearing transcript for Karen Reed, but I don't know how to get it. I think you have to pay for them. Amber, do you know if that's already been released publicly or how much it would cost? We might be able to spring for that. Like that hair color. I thank you. It's natural. Are you talking about them? Sorry. Ginger looks like he's 12. I just noticed he has things on his shelf, and so I'm trying to see what it is. It looks like hair product. I would say mousse of some sort. I'm seeing the Q-tips. The green and black bottles look like a mousse, like a hair styling gel. Maybe a wine bottle up there on its side up higher. Little of everything right there. Ron Weasley, I see the resemblance. Kurt has it. He's reading it live. Awesome. Okay, so it's out. I don't have to go buy it. It's not a decision. It's just the arguments that were made. She got really close to the camera there. Chloe is not happy about having to wait this long. So. And little hit on the vape. Maybe blow a few smoke rings for us. If you hold it long enough, all the smoke, all the vapor goes away. Still trying to check on Thurston County. They're still not live. Tisha's taken us to Lowe's to go look at some paint swatches. I think he's in the bathroom. Is there a shower curtain? Let me look. You think you're right. I think he is in the bathroom. Hopefully he's not on the... very few bathrooms have seating aside from like the throne. I hope he's not on the throne. Maybe he's in a salon of some sort. or the annex. He's on his throne. He's trying to get a little peace away from the roommates. They'll be banging on the door during the hearing. You've been in there for an hour. It's like, it's not my fault. It's the judge. Dorm life. Thurston just does not come back. 21 minutes. Should we call Thurston? Hang on. I have to remember the laws here. Is the state of Washington one-party consent? Is the state of Washington one-party consent state for recording calls? Yes. No. It's two-party consent, which means I can't call on the air.
Court does call the case of the People versus Sonia Cook Taylor.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Wendy Burnwell, P42-505, on behalf of Miss Sonia Cook Taylor. I think that's what you said, right, Judge?
That is what I said.
Good.
Sorry. What's your name, ma'am?
Sonia Cook Taylor.
Thank you. And what are we doing today?
Your Honor, we're requesting an exam.
All discovery is complete.
Yes, I do have paper and electronic.
People have their witnesses available the 18th.
Yes, Your Honor.
Oh, they match.
Preliminary examination in person, March 18th, 2025, 9 a.m. That is before Judge Moore.
I'm here that day, Judge, in front of Judge Barron, an exam.
It's only about.
Can we do both same time?
Oh, yeah. It's
okay.
A walk. They'll be right next door.
Okay, good. Thanks.
All right. Thank you. On continued. Court does call the case of the People versus Cynthia Lake.
Good afternoon, Your Honor. David.
Good afternoon, Your Honor. David Shan, on behalf of Cynthia Lake Pier.
Okay, first, and your name, ma'am?
Cynthia Lake Pier.
All right, there has been an added count two on the amended information.
Yeah, Mr. Cook sent that to me. The defendant will stand mute.
All right.
And wait formal reading of the charges.
Defendant having waived formal reading as to count two, standing mute. Court will enter not guilty plea. All right.
Your Honor, we're waiting for an implied consent hearing with Secretary of State that was set up for March the 3rd. On March the 3rd, the hearing officer had the flu and had to cancel the hearing. It was adjourned. We have a new hearing date of April the 7th. We're hoping we can move this out past April the 7th because of the implied consent hearing goes forward and she does lose her license. We're going to have to apply to felony treatment court in order to give her a chance.
Right.
So there are a few different balls in the air here, but that would give us a chance to find out what's going to happen in that hearing before we proceed with the felony charges and now the new high.
How quick do the results on that come?
Instantaneously. I apply consent hearing, we'll get a decision at the time of the hearing.
All right. So if I set this for April 10th, that'll work for you.
That would work. Yes.
Any objection from the people?
None from the people. Thank you.
Probable cause conference, April 10th, 2025, 9 a.m. Bond will continue. All right. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Justin Nickerson.
Good afternoon, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Good afternoon, Your Honor. Tyler Vila, P number 75702 on behalf of Justin Nickerson.
Your name?
Justin Nickerson.
Thank you. What are we doing?
Requesting exam, Your Honor. I believe all discovery has been exchanged. Hoping to get at least 2 weeks out.
Hope what you want, but people have their witnesses available on the 18th.
We should, Your Honor.
Preliminary examination in person will be set March 18th, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor. Have a great day.
You do the same. Court calls case of the people versus Andrea Petkovich.
Good afternoon, Your Honor. Ranking for the people.
Good afternoon, Your Honor. Deborah Schlussel on behalf of the defendant, Ms. Andrea Petkovich. She is on Zoom, Your Honor.
Petkovich?
Yes.
I need a camera on, please.
Oh, I'm so sorry. Hold on. Okay, I'm here.
All right. Thank you. And can you state your name?
Andrea Petkovich.
All right.
Your Honor, today is the date and time set for an adjourned probable cause conference. I'm asking for one more adjournment. I believe we will have this matter resolved to stay in this court. We just need some time to work out the details.
March 20th, 2025, 9 a.m.
March 20th? That works for me, Your Honor. Thank you.
Okay, great. Bond continue. Thank you.
Thank you.
Court calls case of the people versus Robert Trombley.
Andrew Childers appearing on behalf of the people.
Yes, Your Honor. Please this honorable court, Brandon Bird, PA 734 on behalf of Robert Trombley. Can you please state your full name for the record? Robert Trombley.
All right. What are we doing today?
Respectfully, Your Honor, I would ask for brief adjournment due to the fact that I was disappointed on the case Friday and was able to get a hold of my client. I also need to ask for a video.
Probable cause conference, March 27th.
Sounds good, Your Honor.
2025, 9 a.m. or as your invite indicates, bond in this matter will continue.
Thank you, Your Honor.
Thank you.
Before have a great day.
Court calls case, people versus Peter Heenan.
And then on behalf of the people.
Good afternoon. Good afternoon, Jackie Moss for and on behalf of Mr. Heenan. We are both appearing via Zoom from separate locations.
All right. Mr. Heenan, can you state your name?
Peter Heenan.
Oh, there he is. Oh, you're blocked by something on my screen. All right. Okay, what are we doing?
Your Honor, today was the date and time set for a probable cause conference. This matter has been adjourned several times in the past due to Mr. Heenan's being in treatment. Today, Your Honor, I have two proposals. First, I don't recall if the plea agreement was ever placed on the record. I know that Mr. Heenan's plea has not been entered, but I'm not sure if the court was apprised to the agreement. The parties did reach an agreement on November 14th of 2024. In pertinent part, a condition of sentencing was that Mr. Heenan was to complete a sober living treatment immediately following his inpatient treatment. Your Honor, I'm happy to update the court that Mr. Heenan has completed the inpatient treatment. He is currently still in the sober living facility. However, as of March 4th, he has 90 days in. He's expressed to me that the facility is good for him and he would like to remain there until June. That being said, if Your Honor considers the 90 days under his belt as fulfilling that part of the sentence, that part of the agreement, I would propose that we move forward today with entering the plea on the record. Otherwise, I would ask for an adjournment until sometime in June so that Mr. Heenan can complete his stay at the sober living facility.
People have a position on that? Because I think it's going to be, I don't think it's going to be up to me regarding the 90 days. I think it's going to be up to the people.
Your Honor, I had in my notes from Ms. Poisson that it said that he was going to plead to count 2 stalking and to count 1 be dismissed, and it was contingent upon completion of inpatient treatment and sober living program, but she wrote 90 days, so I believe that would be appropriate to enter the plea then today.
Today. All right. And he's going to plead to.
I'd have to write up a plea form, Your Honor.
Okay, you have to write up a plea form. Okay. All right. So why don't we do this? Let me pass it briefly. Let the prosecutor write a plea form and so that counsel knows and everybody knows exactly what's happening. Okay.
Sounds good. Could I have a breakout room with Mr. Heenan, Your Honor?
I don't do breakout rooms. With Mr. Heenan? I don't. You know, that's the second person that's asked me. First person I said no. And here comes Moss asking for one.
Yeah, I asked Your Honor specifically because I have not had a chance to consult with Mr. Heenan about the possibility of entering the plea on the record today. So I'd just like to briefly go over that with him.
Mr. Heenan, how are you doing?
Very well, Your Honor. Thank you.
You're looking good.
Thank you very much.
Well, you've been through some stuff, right?
Yes.
All right. We'll give him a breakout room.
Thank you, Your Honor.
He's just giving my heart.
Was this recorded? Oh, now everybody knows I will do it under certain circumstances. I'm only doing that. I don't like Moss, but I like Mr. Heenan, so I'm going to do it. Okay. All right. We'll give you a breakout room. Thank you.
Thank you, Judge.
Court calls the case. People versus Jack Moniz.
Jack, you're up.
Good afternoon, Your Honor. Joshua Kaplan on behalf of Mr. Jack Moniz. Jack, will you state your name for the record?
Jack Moniz.
Thank you.
Andrew Childers, people.
All right. What are we doing today?
Your Honor, I've been trying to get all the people. I haven't been able to. So this time, I think, unless the court is willing to adjourn this, we just set it for an exam date.
I'm willing to adjourn it, but so that
Your Honor, just as a court's aware, Ms. Lonnie was assigned to handle this. She had to log off. I'm covering the case.
Got it.
Today. But obviously, as the court's aware that she's been kind of out sick all week. So there's a reasonable explanation why Mr. Kaplan has had some issues with getting her.
Okay. So let me adjourn this out a couple weeks and let you get in contact with him. All right.
I appreciate that.
With him. Probable cause conference will be adjourned to March 20th, 2025, 9 a.m.
Yeah, could we do March 27th? I apologize. I'm in trial on the.
This is like 2 things in a row I don't do. Attorneys pick their date and give a breakout room.
And Your Honor, may I have a breakout room with my client to go over this? So.
Yeah.
Now you're pushing it.
Everybody got jokes. All right. Anyway, no, we'll do the March 27th, counsel.
Thank you, Your Honor. I appreciate it.
All right. Thank you. You take care. Court calls the case. People versus Chloe Whitsett.
People.
Chloe, you're up.
Yeah. Okay. It's Attorney Hickman. We'll wait her because otherwise she's gonna start yelling at somebody.
Oh Lord.
Anyway, counsel, state your appearance, please.
Kia Hickman for Miss Chloe Whitsett. Miss Whitsett, please state your name for the record.
Chloe Whitsett.
How are you, Miss Whitsett?
I'm here, Your Honor. Thank you. How are you?
I'm doing great. Thank you for asking. All right, what are we doing on this case today?
Yes, Your Honor. As you know, Ms. Wissett has finally been added to the wait list for the 36th District Court sobriety list. I contacted the director. He hasn't responded back to me yet. I also called again today, and the coordinator who monitors the list, he wasn't available.
Okay. All right. Well, certainly that is a key to trying to resolve this case. So I don't mind adjourning it out if we have to adjourn it out so that we can get clarification on that. Okay.
Yeah, it's just moving up on that wait list at this point. You know, she's good to go. We just have to get her up on that wait list.
On that list.
She's on the list. We just don't know her placement.
Yeah, got it. Okay. So why don't would another 30 days you think do us, and then we can see exactly where we are? Or okay, all right. Well, everybody's been working hard trying to get this through, and
Yeah,
Miss Whitsett's been doing her part.
she has. She's been
I don't know what that-
well, going through a lot, you know, personally. She lost her mom, and there's things in regards to that. So she's doing really good handling all of that.
All right. I'm very sorry to hear that, Miss Whitsett.
Thank you, Your Honor.
All right. Probable cause conference, why don't we do April 10th, 2025 at 9, or as your invite indicates. All right.
Thank you, Your Honor.
All right. And trust me, Miss Whitsett, while it looks dark, there'll be some light on that. Don't let that send you in the other direction. Okay?
Yes, sir.
All right. You take care of yourself.
Thank
All
you.
right. All right. Bye-bye. Court calls the case People versus Martez Richard.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Richard.
Your Honor, I just want to put on the record, we did reach out to YPP and were informed that we did in fact make a call for service yesterday. However, the report was not written yesterday because apparently the officer wasn't aware of the bond conditions in place. So we are working to get the report written today, and hopefully we'll have it by tomorrow. And we did receive text messages from the victim screenshots, and some of those were from as recently as I think March 1st, as from the defendant.
And certainly after the date of arraignment.
Yes.
Jackie, I know it's going to be hard for you to respond because, gee, there's no client. The one that I told not to leave the courtroom.
That's
but
right.
I'll let you go ahead.
I haven't seen what the prosecutor is referring to. Obviously, I would ask if the court would consider setting the bond violation hearing for the 20th. And my client was eager to make some calls. I have no representations as to his whereabouts.
Bench warrant.
Well, and we were kind of informed that he had left the courtroom. So just so that the record is clear, and I had told him not to, that I had personnel check to see if he was still here or had just gone to the restroom or whatever. And he was not here at all, and had indeed left after being told by the court not to leave. So we will not be adjourning the probable cause because he's not here. He decided to he's here and left. So a bench warrant will issue in both of these cases for defendant's failure to appear based upon his leaving as well as the preliminary representation to the people. No bond on both of these matters. Don't know where he thinks this is going to get him.
I can
and
guess.
That warrant will issue immediately.
Okay, Thurston County just did not come back. I don't know if they're coming back or.
And I think these are
might actually be a
YPD
code
cases.
brown.
They are. So after we get that warrant issued, if you could ask the officers over there to go find him, bring him to me.
Thank you, Your Honor.
Thank you.
Tells the bailiffs, fetch.
Or does come to where's Margaret?
That was quick.
Andrew Children's appearing on behalf of the people.
Brian Bowling on behalf of Mr. Richardson.
Thank you.
Judge, I'm seeking an adjournment. I will just place on the record that Ms. Londi and I resolved an issue with some video I was trying to obtain related to this matter. Now, I would just like to get into some plea negotiations with Ms. Londi.
Probable cause conference, March 20th, 2025. 9 a.m. Where's your invite indicates bond will continue.
Thank you, Your Honor.
Thanks, Judge.
Court calls the case of the people versus Brandon Smith.
Andrew Children's appearing on behalf.
Assistant Public Defender Chelsea Vergils with on behalf of Brandon Smith. Please state your name.
Brandon David Smith.
Thank you.
Your Honor, we have a resolution in this case. He would take the offer if it is still available. We have given the court a signed advice of rights form.
Is the offer still available?
Nope.
I'm happy to write one up if we want to pass it. I didn't know that that's what we were doing.
There's no offer in the file?
Okay.
Okay.
Sorry, yes.
No, it's okay. It's because of a lot of different pieces there moving. Let me pass it and then we'll call you back up, sir, and get take care. All
Thank
right.
you, Your Honor.
Thank you. Court does call the case of the people versus Julian Tebron or Tabron.
Good afternoon, Your Honor. Assistant Public Defender Constable Mason on behalf of Mr. Julian Tabron, who is appearing by Zoom. Could you go ahead and unmute and state your full name for me, please, sir?
Julian Tabron.
All right. What are we doing?
Your Honor, we're going to be requesting a brief adjournment to continue negotiations.
Probable cause conference without objection, March 20th, 2025, 9 a.m. Where's your invite indicates bond continue.
Thank you, Your Honor.
It's really nice.
Court calls case people versus Devon or Davion Thomas.
Andrew Children's appearing on behalf of the people.
Oh,
Was I speaking French?
I'm sorry, Your Honor.
No, it's okay. I was speaking French.
No, you were. Laura Yagi, Assistant Public Defender. Mr. Thomas should be on Zoom. He texted a screenshot that he was on Zoom, and I believe our Zoom request was granted for him to appear on Zoom.
Hello, guys.
Hello.
Hello. State your name.
Davion Thomas.
All right.
Okay, thank you, Your Honor. We're going to request a brief adjournment in this matter. My understanding is my colleague did make an AIM referral who's preparing or maybe already finished a mitigation report that we are going to finalize before sending to the APA for review for discussion for resolution.
March 27, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Court calls case people versus Adrian Vasquez.
Andrew Children's appearing on behalf of the people.
Stephanie Can on behalf of Mr. Vasquez, who's appearing to my right. Mr. Vasquez.
Wow. Wow. No, I called one of your cases that you actually were here.
Judge.
Shocking. You know?
I had 7 today.
This is kind of like a blind squirrel finding a nut. It just happened.
I had 7. It was 1. It was 1.
It was no.
Can you state your name?
Okay, no, you're right. Thank you, sir.
Proud of myself as well. Your Honor, we are just waiting on a couple of bits of discovery here. One is restitution.
You're waiting on a figure.
Yes, because my client is HIDA eligible, but before he makes that decision, he is trying to see how much that would entail possibly. So if once we get that number, he'll be able to make an informed decision about how he would like to move forward.
Got it. How much time before that number can come forward do we?
Well, I've been in contact with Ms. Lundy about it.
Okay.
This is her case.
Don't say anymore.
Okay.
Probable cause conference, March 27th, 2024, 9 a.m. or as your invite indicates. Okay. Bond will continue.
Thank you so much, Your Honor.
Court does call the case of the People versus Madison Wells.
Assistant Public Defender Chelsea Virgils with and on behalf of Madison Wells. Mr. Wells, please state your name.
Madison Wells. Thank you. I have a plea form. Is that what we're doing?
Yes, Your Honor.
All right. Plea form indicates that defendant is going to plead to 2 charges. First being the stated count 2 of operating while intoxicated, the 93-day offense, and also to an added count 4 of use of a controlled substance, the 1-year offense. Upon a successful plea to that charge, counts 1 and 3 would be dismissed. There's also an agreement that it's okay to seek HIDA on count 4. That's the court's full understanding of the agreement. Is that correct, counsel?
That's correct. Yes, Your Honor.
All right, good. And I have it in place, right? May I have the defendant sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Madison Wells. All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Correct.
All right. First of all, that you'll be pleading to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order rehabilitative services or community service as the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Correct.
Also, that you're going to be pleading guilty to an added count 4 of use of a controlled substance, that being
No
fentanyl.
resisting arrest.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. I do have to advise you, sir, that while you're pleading guilty and I'm taking your plea, that you would be sentenced, that I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Correct.
All right. Now, understanding all of that, you still wish to plead guilty?
Yes.
To the charge of operating while intoxicated, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
All right. Hang on a quick second. You signed an advice of rights form, is that correct?
Correct.
Any questions regarding any of those rights?
Oh, Your Honor.
Look at paragraph 5. See about them. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be waiving or giving up those rights contained in that paragraph, as well as all the rights contained on that form.
Yeah. Yes, Your Honor.
All right. You understand also you'll be giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Correct.
And also because you believe that you're guilty of these offenses?
Correct.
November 30th, 2023, at the location of Rawsonville near Bemis Road in Augusta Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
What controlled substances did you ingest?
Fentanyl.
All right. Were you stopped by the police or was there an accident?
Police.
Pardon?
I was pulled over.
You were pulled over. Why'd they pull you over, sir?
The car was in my buddy's name that I bought it off of, and he had a warrant.
Okay. After you were pulled over, were you ultimately arrested?
Yes.
Or were you taken to the hospital?
Yes.
And was there a blood draw?
Yes.
And did the results of that blood draw show the presence of fentanyl and or the derivative thereof in your blood system?
Correct.
All right. Do you have any reason to dispute those results?
No, Your Honor.
All right. And on that date, you were in possession of fentanyl at some point.
Correct.
And had used it. Is that correct?
Yes.
And knew what you were using was fentanyl?
Mm-hmm.
Yes?
Yes, yes, yes.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's pleas of guilty to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14H probation. Sentencing in this matter will be
April 1st, it's time again.
April 1st, 2025, 10 a.m. before Judge Barr. Bond with its conditions will continue.
Your Honor.
Thank you.
Okay, so Thurston did us dirty, and just trying to see how much we missed before they turned the cameras back on for us. Give me just a second. Looks like we missed a little bit. Hang on.
At the start, when did you fear for the defendant's personal safety?
Objection. Asked and answered.
We missed all the direct.
Does that mean I have to answer?
Yes, you means you have to answer yes.
Okay. It was when Calvin put his arm on JT.
Okay.
So we're already on cross-examination of Jennifer.
Okay. And in the video, we see you are shouting at Mr. Malone, correct?
Yes.
Okay. Do you recall what you're shouting to him about?
Not really.
Okay. Nothing further, Your Honor.
Any redirect, Mr. Sheffield?
Briefly, Your Honor. Jennifer, who started this physical altercation between Mr. Malone and James?
Mr. Malone did.
And how did Mr. Malone start this physical altercation?
When he grabbed JT's arm.
No further questions.
Anything further, Mr. Holcomb?
There we go.
Had Mr. Malone never reached for the note on the counter,
oh, you can't say that.
Do you believe this incident would have happened as it occurs in the video?
What?
Objection. Speculation.
Yeah.
Could you repeat that question, please?
Had Mr. Malone not reached for the note that was on the counter, do you believe this incident would have happened as seen in the video footage? Would this fight have happened?
I'm sustaining the objection as to calls for speculation.
Do you believe Mr. Malone reaching for the note in any way prompted this altercation?
Same objection.
You wish to have him repeat the question now?
I don't really understand.
Why don't you
what he's
repeat your
trying to
question,
ask.
Mr. Holcomb?
Do you believe that Mr. Malone's act of reaching for the note in any way prompted this altercation?
Partially.
Okay. Nothing further, Your Honor.
Anything further, Mr. Sheffield?
No, Your
Honor. May this witness be excused?
Yes.
And then you sit down and you're free to go. Okay.
Now we have the defendant taking a
So,
stand.
members of the jury.
Oh, Jennifer, sorry. You're okay.
You're okay. Exit door. We're going to take our noon lunch break right now. It's a little bit early, but not to break up.
We missed half of the trial.
The sequence of events. It's now 11:46, so we'll reconvene at 1 o'clock. And if you brought your lunch, you're free to eat it in the jury room. If you want to go out for lunch, that's fine too. You eat with others, either in the jury room or out, that's also fine. But if you are with other jurors, don't discuss what you've heard thus far. The instruction I gave yesterday afternoon remains in place. And then you can be back in the jury room at 12:55. We'll continue on again at 1. All right.
All right, we may pop in a hearing that is going to be happening in just a moment. The Slender Man stabbing hearing. This is a hearing, a release hearing. This is on the tail end. This is a trial that happened a long time ago.
You could be seated. And we're still on the record. So, Mr. Krzyzewski, I know the decision to call a defendant is always frequently, not always, but frequently an ever-changing decision. Do you intend to call him, or are you going to talk about that over the noon hour, or what?
We do intend to call.
So you will call him. So we're going to print jury instructions, and we're going to eliminate the instruction then that says, well, you know what it says, that it has no duty to testify. So, all right.
Here we go.
So
We're
we'll
gonna
be
jump.
back at 1 o'clock, and then we'll go from there.
We're going to jump. This is a conditional release. This is one of the defendants in the Slender Man hearing. She was in a mental health facility. She was going to be released. The judge heard about some contact she was having with the guy on the outside. And he put a pause on her release because of that. So we're just going to jump
Court will
in.
call the matter of State of Wisconsin versus Morgan E. Geyser, case number 14 CF 596. Appearances.
Good afternoon, Judge. Abby Nicolai appears on behalf of the state.
Good afternoon, Judge. Morgan Geyser with Attorney Anthony Cotton. She's here in person.
All right, thank you, and good afternoon, all. We're here on the review of the court's petition, the order to proceed with conditional release, and then the petition filed to revoke that order. So how is the state calling a witness? Or how should we proceed?
Judge, given today's scheduling was primarily based around the 3 doctors' schedules, I would suggest that we perhaps start with their testimony, because I know that they were all available today, and I believe they're all on Zoom. And I know that the court had questions for the doctors, so that would be my proposal.
Well, should we introduce the petition, though, of why we're here?
That would be good.
Sure.
We have the petition that seeks to revoke the conditional release.
Right.
Is there a witness here to testify about that?
I have several witnesses on the state's burden, none of which I anticipated including any of the doctors.
All right. Well, I think we should put the petition into the record officially so we can have individuals comment on it. So who is calling to authenticate it?
Well, I have, this afternoon, I plan to elicit testimony from Nicole Whitaker from WCS, who helped author some of the information, as well as Kathleen Martinez from the Department of Health Services. And then there's also a witness on Zoom who is part of the defendant's treatment team from Winnebago, Lisa Portman. I was going to have testimony from all of those individuals in regard to the information that was filed in document 655, the petition to revoke conditional release.
Well, it was signed by the amended petition that they filed most recently. It was signed by Nicole Whitaker. Is she available?
Yes, she's here, Judge.
Well, we should have her then be the one that introduces it so we have it in the record.
Okay. She did sign that memorandum. The actual petition to revoke the conditional release is signed by Aaron Graff from the Department of Health Services, who's also here. The WCS memo is included underneath that petition as a factual basis. Ms. Graff is also here, as is her supervisor, Ms. Martinez. So however the court would like me to begin, I can do that.
Well, I'll allow you to decide how to begin. I just wanted to get it in to the into the process. I'm just looking for it. I have the statement of probable cause for detention and petition for revocation of conditional release. That was filed in court here on February 27th. And that letter is signed by Nicole Whitaker as well. The reason we're here is they filed a petition.
Right. I did not mark the petition as an exhibit. Because it's already in the court record, and I apologize. Perhaps I should have done that.
Well, we'll use it as Court Exhibit 1.
Okay.
And who, I guess, should Ms. Whittaker be the witness that comes in?
She will be one of my witnesses, yes.
Well, let's call her and she can identify it so we have something to proceed with.
Sure. I'd call Nicole Whittaker.
Okay.
Ma'am, if you'd come forward, have a seat behind the court reporter.
The Slenderman stabbing, we had two
two
girls who were friends who stabbed another friend to death, I believe.
And then, ma'am, if you'd remain standing, raise your right hand.
To
Do you
please
swear
a
that everything
fictional
you're going to
character.
testify to today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. You may be seated. And then state your full name and spell your
Not
last
to
name.
death. Okay, she survived. Thank you.
Nicole Whittaker. My last name is Whiteaker.
No. We're missing, excuse me a moment. We're missing sheets.
Missing the sheets. I thought she had died. She survived. She cried.
What I've done is I've copied the
I'm guessing
petition
they're not friends anymore.
and marked it as Court Exhibit 1.
Thank you, Judge.
All right, thank you. I'm just going to give you now what's marked as Court Exhibit 1.
Thank you.
So
And
the,
then I'll
the
turn it
defendant
over.
has been in a mental
Thank you,
hospital
Judge.
and was
Ms.
going to be
Whittaker, where do
released.
you work?
I work for Wisconsin Community Services.
And what do you do there?
I am the Conditional Release Program Supervisor.
What does that mean? What are your duties?
I oversee a team of people who are overseeing participants who are released into the community under conditional release.
Did you become involved in preparing a plan for Morgan Geyser in this case?
I did.
And did you begin to prepare that plan in this case?
I did.
Ultimately, did you write a memorandum with some information in it that was filed with the court?
I did.
And you've been handed Court's Exhibit Number 1, is that true?
Yes.
Is that a multi-page document?
Yes.
What's the date of filing on that document, please?
February 27th, 2025.
Okay. And do you recognize that document?
I do.
What is it?
This is the 5177 petition for revocation.
Is there information in that petition that you generated?
There is.
What information is that?
I generated a portion of this that are numbered, and that comes out of case notes that were done after meetings with Ms. Geyser.
Could you refer the court to a page number where your content begins?
Mine is not numbered, but I'm on the 4th page.
Okay. Is there a WCS logo at the top left corner of that page?
There is.
Okay. On the final page of that exhibit, is your electronic signature there?
Yes.
Okay. Why did you compile the information in this memo?
We, as a treatment team,
I'm going to object to her testifying as a treatment team when she's asked what she was tasked with doing.
Sustained.
Just say
Sustain the objection. Can we go ahead?
Sure. When, I want to back up a little bit.
What's the sign on the ground to the
Did
left?
you meet Morgan Geyser when you were assigned to this case?
I met her previously to being assigned to this case.
Okay, and specifically to planning the conditional release plan, did you meet with a team that was tasked with creating that plan?
I did.
Who was a part of that team?
There are several members of the team that include myself, a case manager, our partners at DHS, and members of the Winnebago Mental Health Institute treatment team.
And when you say DHS, are you talking about the Department of Health Services?
I am.
And would that include Aaron Graff?
It would.
For the record, is that GRAF?
Yes.
And is her signature actually also on Exhibit 1 that you were given by the court?
It is.
And what part did she play in this filing, if you know?
She filed the 5177.
And she's an employee with the Department of Health Services, is that true?
She is.
Okay. But was she also a part of the team that was helping to prepare this conditional release plan?
Yes.
Okay. And how many meetings do you think that this group had in regard to the conditional release plan in this case?
Initially, the treatment team meets as a whole in the beginning when a participant's granted conditional release, and then a smaller group meets with the participant on a weekly basis going forward until she's released.
When the group became smaller, what participants were left in it?
Myself, my case manager, the participant, and sometimes her social worker at Winnebago.
Was the social worker always in those meetings in this case?
Not always.
Why not?
There were times that Morgan had asked her to leave.
Was that social worker someone that was recently brought into Morgan's team?
Yes.
Okay. At some point in time during these planning meetings, did reading material become a topic?
It did.
And why would it be important for you in preparing a conditional release plan to know about a participant's reading material?
In the beginning of preparing a conditional release plan, it's really important for us as a team to build rapport and get to know the participant, coping skills, things of that nature. And the purpose of the conditional release plan is to mitigate risk to the community. When we started looking into things that Ms. Geiser liked to do, reading became a topic. To then we inquired about what types of books and things like that.
Okay. At a point in time, did you become concerned about information you learned about reading material that Ms. Geiser was using?
I did.
Why?
Because it is related to the index offense, I suppose.
In what way?
It's violent.
Specifically, is one of the books that you're referencing called Rent Boy?
Objection leading.
Okay, quick
Overruled.
Google.
It is leading, but we all are familiar with these various documents, and this will move the hearing along, so overruled.
Yes.
And did you have concerns about the fact that Ms. Geiser had read that book?
I did.
Why?
Because it was a dark novel that revolved around murder and the selling of body parts on the black market, along with sexual sadism.
Okay, I can see the problem there for this particular.
Is that
defendant.
information contained in the material that you put together in Exhibit 1?
It is.
Okay. How did Ms. Geiser react when she was informed the treatment team and conditional release team would be monitoring her reading material?
She was upset.
Did she say why?
She didn't feel it was necessary for the team to oversee things that she used as coping skills and a creative outlet.
Do you consider it an important part of a treatment plan, a conditional release plan, to monitor things like reading material and media usage?
Yes, that's a standard thing that we do as a conditional release team, and it's very individualized to each participant as well as their index offense.
Was that fact relayed to Ms. Geiser?
Yes.
And was she receptive to that?
No, she still thought that it was unnecessary.
Did you talk about monitoring Ms. Geiser's reading material during more than one meeting with her?
We did.
Did her response to that monitoring ever change?
No.
Would it be fair to say she pushed back on that monitoring?
Yes.
Did she ever come around and acknowledge that that would be an appropriate thing for the team to do?
No.
Was that concerning to the conditional release team?
It was.
Why?
Because it shows risk, and the conditional release plan cannot, or the conditional release team, I'm sorry, cannot write a conditional release plan when we aren't aware of the risk to the community.
Was there a point in time when you approached Aaron Graff and Kathleen Martinez with the Department of Health Services about preparing this plan?
Yes.
Why did you do that?
Because things were coming to light that the treatment team wasn't aware of, and I needed to pass that on to other people as she's being released into the community. I can't be the only one harboring that information. The team needs to be aware.
How did you know that the treatment team wasn't aware of these things?
Well, initially I brought it to Aaron and Katie, and they then looked deeper into things with Winnebago.
So that discussion and comparing information with Winnebago was not a role that you took on personally?
Correct.
Okay. Are you aware of an individual named Jeffrey Pickles?
I am aware of him, yes.
Who is he?
When you are creating a conditional release plan, is it important for you to know people who a participant is having contact with outside of an institution?
It is.
Why?
There are a number of reasons, risk being the number one. We have to take in the participants' treatment needs, as they're in the community. And so I asked Ms. Geiser, who are the people that she's communicating with on the outside, and that his name came up.
How recently had she had communication with him?
I'm not sure the answer to that. I know that she stated he did send her a letter after she was granted conditional release, and she stated that she ripped it up and threw it away.
So at the point in time when you discussed this individual with Ms. Geiser, did it seem that she wanted contact with him?
No.
Okay. Is there information nonetheless about this person in the memo in Exhibit 1 that you wrote?
Yes.
Why? What is included in here and why?
After the team became aware of him, it was during that meeting that Ms. Geiser asked for a no contact. We further looked into things to find out if there was such a need for a no contact and what was the reason. And we found a number of things on his Facebook that pertained to Ms. Geiser that we were concerned about.
And before I forget, I apologize for jumping topics here, Ms. Whitaker. I want to ask you one more question about the book Rent Boy that we talked about.
Okay.
Were you able to ascertain how Ms. Geiser got the book to read in Winnebago?
I was under the understanding that she had got it from the library, but then it later came out that it was sent to her.
How?
Via mail from somebody, I'm not sure.
Okay. Now, going back to, you indicated that there were things, did you do research on this individual on the internet, or how did you know these concerning things about this individual, JP?
I did not personally do the research. My lead case manager did, as well as the social worker at Winnebago Mental Health.
And what was anything that was found significant to your assessment of Ms. Geiser's risk to the community or herself?
I'm going to object to that. She didn't do any research on Jeffrey Pagel.
Overruled. Witness can answer.
Can you repeat the question, please?
Sure. Was there any information about this individual JP that was relevant to your assessment of Ms. Geiser's risk to herself or the community?
Yes, but it was also concerning for Ms. Geiser. And when we talk about risk to the community, she is included in that assessment. And he had things directly relating to her on his Facebook page. So yes, that was concerning.
What types of things relating to Ms. Geiser was on his social media accounts?
I'm going to object on relevance grounds. And I'm happy to make further argument.
In overruling objection, I think it's relative and probative to the issues that have been raised by the petition to revoke the conditional release from the standpoint that information the person, Mr. Pickles, may have on his Facebook account could be from any place, but it may also involve information that purportedly may have come from Ms. Geiser. I don't know that, but I wanted to be able to hear that, and that should be part of the record. So I'll overrule the objection.
We found that there were letters and drawings that she had sent him, a postcard, and he was selling them. He was selling the items.
Were you able to see the drawings that he was purporting were from Ms. Geiser?
Yes.
Were they concerning to you?
Yes.
Why?
They were very dark in nature. I would describe it as a horror type picture.
Excuse me?
Horror.
All right.
I want to show you what's been marked as State's Exhibit 1.
Yep, thank you.
Thank you.
Do you recognize that?
I do.
What is it?
It is a drawing that Morgan has done.
Where did you get it?
Off of Jeffrey Pagel's Facebook page.
Was that one of the items for sale?
Yes.
How was it being was Ms. Geiser's name linked to that piece of art in the sale information?
It was.
Does that look like a fair and accurate copy of the item that you found for sale in this case?
It does.
I'd move Exhibit 1 into evidence.
Any objections? Received.
And Judge, I can either display it digitally or just have the witness hand you the paper copy of it.
You can display it digitally.
Are we going to get to see that one?
Ms. Whitaker, is the Exhibit 1 on the screen in front of you the same as the paper copy that I handed you?
It is.
Okay. And remind the court again what this is?
That's a drawing that came off of Jeffrey Pagel's Facebook page. He compiled a number of items that he was selling as, he called it the Slenderman package.
Okay, thank you, Madam Clerk.
Nowadays, they just make him an EFT.
Were you able to ascertain how long Ms. Geiser had been a willful participant in communicating with that individual, JP?
I do not have knowledge on how long the relationship lasted or how long they communicated.
Okay. At a point in time did you learn any information about JP that was concerning as it related to sexual behavior?
Yes.
And what was that?
In speaking, we were very open about this topic with Ms. Geiser during the meetings, you know, as it's a great risk as she comes into the community, and she was aware, and she recalled that he would get sexual gratification from her index offense, and I believe that there were letters written back and forth.
Is that information something that Ms. Geiser told you during a meeting?
She did tell us that, yes.
Okay. Is that, as far as you're aware, is that information something that she had worked on in therapy or with her treatment team to that point?
I was not sure.
Okay. Was that concerning that you didn't know the answer to that?
Yes.
Why?
Because it tells me that there's an unknown risk.
When you first...
Ooh.
Strike that. The Exhibit 1, you testified that the bulk of the information you included is bulleted with numbers. Is that true?
Yes.
Okay. So would it be correct that in terms of creating the conditional release plan in this case, one of your first meetings with Ms. Geiser would have been on or about January 17th of this year?
That's correct.
Okay. During that initial meeting, did you learn what Ms. Geiser's preferred pronouns were?
I did.
At that time?
I did.
How did you learn that information?
At the beginning of the meeting, my greeting or opening statement was, "Hi, Ethan, how are you?" And she had responded, "JK, I'm going by Morgan, she, her pronouns."
What was Ms. Geiser's demeanor like when she said JK to you?
Very light, aloof, you know, just very casual.
Why did you greet Ms. Geiser as Ethan?
Because I had previous knowledge that she was now identifying as Ethan using him, her pronouns. He, him pronouns, I'm sorry.
In terms of Exhibit 1, the conclusion section and recommendation section, is that something that you authored?
I did not.
Okay, who authored those pieces, if you know?
Katie Martinez from DHS.
Okay. And in terms of the decision to actually file this material as a petition to revoke conditional release, was that a decision that you made on your own?
It was not.
Was it even your decision at all?
No.
Okay. Those are all the questions I have.
All right, thank you. Cross-examination.
Do we have a hard copy of Exhibit 1?
She has it.
That's the February report. You have Exhibit 1 in front of you, ma'am?
I do.
Yeah. Yes, she does.
Okay, can I go?
Sure.
Can I see that, please?
Sure.
Good afternoon.
Good afternoon.
This report that you just testified to is dated, what date?
February 27th, 2025.
Can I mark Exhibit 2 down with this date?
Now, are you marking the one that came in on March 4th?
Yes.
I have it already marked as Exhibit 2.
Perfect, can I use that?
Sure.
So what you just testified to is an exhibit from February 27th. I'm showing you Exhibit 2. What's the date on that report?
March 4th, 2025.
The reason there was a second report is because the first report that you authored contained inaccuracies, correct?
Correct.
In other words, you made mistakes.
Not me. It was Winnebago had not given accurate information to DHS.
So inaccurate information was provided to DHS from Winnebago.
Yes.
Then DHS provided that inaccurate information to the court.
Through the filing, yes, that's why we amended.
Okay, well, we're going to make sure we have accurate information today, okay?
Perfect.
So the March 4th report, Exhibit 2, in front of you has certain things that are crossed out, right?
It does.
And just so I'm clear, ma'am, I only want to ask you questions about things you have personal knowledge of that you did. I don't want to get into what other people did, okay?
I just want to note for the record that Exhibits 1 and 2 are actually Court Exhibit 1, Court Exhibit 2. You may continue.
Yes. So just so we're clear, when things are crossed out in Exhibit 2, it's because that was inaccurate information and you're trying to correct it for the record, right?
Yes, but I did not make those corrections.
Okay, so points 1, 2, 3, 4, 5, 6, 7, 8, are those, did you type those line items?
I did.
But in terms of making the corrections, some other person did that?
Right.
Okay, so as I understand it, your job is, well, I don't know that we got into this. What is your educational background?
I have a bachelor's degree in criminal justice.
Okay. What else?
As far as my education, I have ongoing mental health education through, employment. I've been working in the mental health field over 17 years.
Okay, so you have a bachelor's degree.
I do.
You are not a doctor.
I am not.
Not a psychologist.
Nope.
Not a psychiatrist.
No.
You're not holding yourself out that way at all, I'm assuming, right?
Absolutely not.
Okay. You would agree that,
Judge is dying.
You are in charge of the condition, you are a WCS conditional release supervisor, right?
Yes.
And so would I be on solid footing if I said that part of your job is to manage the team that will oversee the conditional release?
Yes.
For Morgan
Is everyone just
specifically,
dying in this
as
courtroom?
part of this
Everyone's just
process,
coughing.
did you yourself ever speak to any of the 3 doctors who did the reports in this case?
I had not.
Okay. You've never called Dr. Lundbaum.
No.
You've never called Dr. Collins.
No.
And you've never called Dr. Robbins.
No.
Have you, as you sit here today, have you even read their reports?
Yes.
Okay. Which ones?
I don't have the dates memorized. There were a number of reports. I can't give you specifics.
Okay, well, there are 3, you are aware that there are 3 doctors who have authored reports that have gone to the court in support of Ms. Geiser's release.
Yes.
And it's your testimony that you have read, you're not sure if you've read all of them or you have read all of them.
No, I had at one time. I have not read them recently.
Okay, well, I wasn't asking about dates, but you're sure you read all 3 reports, right?
Yes.
Okay. And did you read those reports before you authored or before you put together the petition to revoke Ms. Geiser's release?
I didn't put together the petition to revoke.
Or before you typed the WCS letter?
Can you rephrase the question, or can you restate the question? I'm sorry.
Did you read those 3 doctor reports before you put together the letter that you authored?
Yes.
Okay. So as I understand it, you've met with Ms. Geiser on a few occasions. How many times?
I'm not sure the number of times off the top of my head.
Okay, is it more than 5 or less than 5?
More than 5.
So you drive up to Winnebago and do meetings there at Winnebago?
We do Zoom meetings.
Have you ever met her in person?
I have.
How many times?
About 5, maybe.
So you've done Zoom meetings and you've also driven up to Winnebago to meet her in person, right?
I have, but that was different conditions, yes.
What does that mean, different conditions?
We do what's called community success groups that we go up to Winnebago and do education. So that's when, I've met Ms. Geiser.
Okay, so you're talking before before conditional release was
Yes.
granted. So since conditional release was granted, were those meetings those were Zoom meetings? Then?
Yes.
Okay, but the other occasions in the past you met her face to face?
Yes.
And to be clear, I think the last question Ms. Nicolai asked you is about the petition to revoke. That's not your doing, the petition to revoke.
Correct.
What you've authored is a WCS letter that's attached to that to provide information for the court, as I understand it.
A portion of the letter.
Right, not even the whole thing.
Right.
Now, you said that it's important to build rapport with a person who's going to be released, right?
Absolutely.
And because you're going to be involved in Miss Geiser's life going forward on a practical level. If she's released, you're going to be involved in her life, right?
Yes, her case manager would be more so, but yes.
But just so it's clear, WCS as an agency provides support in the community for people who are on conditional release, right?
It does.
So rapport is sort of a two-way street. It's important for you to have a positive rapport towards her and her to have a positive rapport towards you.
Yes.
And you're aware, I mean, you've been to Winnebago before, so you're aware of what the facility is like, right?
Mm-hmm.
Is that a yes or a no?
Yes.
Thank you.
It is a secure facility, if you will, is it not?
Yes.
And I know we call it a mental health institute, but there's security and guards and rules at an institution like that, aren't there?
Yes.
And in order for somebody to get a visit at Winnebago, whoever's in Winnebago, they're just sort of there, and another person in the community can request to come visit that person. Is that how it works?
I do not know.
What you do know is that Morgan had some visits with a person named Jeffrey Pagel, because you've testified about his name today, right?
Yes.
And if I go to Exhibit 2, if you have Exhibit 2, I want to draw your attention to paragraph 7, which is your note from February 19th. Did you author that?
I did.
And again, this is information that you had supplied to the court because it's being given to you by Winnebago, right?
I'm sorry. Can I correct something?
Sure.
That number 7 was authored by my lead case manager.
So some of the numbers in here are things that you wrote and some aren't?
Right. They come from case notes. That is a collaborative effort.
So, in other words, you put your name on a document that you've not entirely authored because it's a team approach.
Yes.
Okay. And on item 7, it's indicated that Jeffrey Pagel had visits with, well, I guess they used the initials JP. That's who we're talking about, right? Pagel?
Yes.
Had visits with MG, that's Morgan Geiser, right?
Yes.
At Winnebago 3 times.
Yes.
Initially, it was reported that it was 4 visits, but in fact, it's only 3.
Correct.
And every one of those visits that took place with Mr. Pagel was at Winnebago.
Yes.
There is no suggestion that Ms. Geiser ever met him in the community.
I'm not aware.
You're not aware of any of her outings that she secretly had contact with Jeff Pagel, right?
Correct.
There's no suggestion at all of that.
Not that I'm aware of.
Okay. And the 3 times that Ms. Geiser saw Pagel was inside, as you understand it, was inside Winnebago's secure facility.
To my knowledge.
So Pagel went through whatever process he would have gone through to get permission to go into the facility to see Ms. Geiser.
I suppose.
And those visits spanned 3 visits over the course of 10 days. That's the extent, isn't it?
From the records they provided us, yes.
June 3rd, June 8th, June 13th.
Yes.
Of 2023.
Yes.
So Winnebago supplied you with those records, right?
They did.
So Jeffrey Pagel's name was known to Winnebago in June of 2023.
It was.
In fact, they were aware of the visits because that's the institution that provided you with the records, right?
Correct.
And initially it was reported that Pagel visited her on June 30th, but then that's crossed out because that actually never happened, right?
That's what I'm told.
And in fact, it was Miss Geiser that there was a visit scheduled on June 30th with this Pagel person, and it was Miss Geiser that canceled the visit, right?
I don't have firsthand knowledge of that, but that's what I'm told.
Your report that you supplied to the court says Miss Geiser rescinded permission. That's the language you supplied to the court.
Yes.
So your understanding is that it was Miss Geiser who rescinded the ability of Pagel to visit her further.
Yes.
And there's been no further visits that you're aware of from Jeffrey Pagel.
Correct.
And there's been no contact with him in the community that you're aware of.
Not aware of any, no.
And as part of the release planning process, when you talk to Ms. Geiser about people she's had contact with, she brought up Pagel as a person. It was her that brought that name to your attention, right?
Correct.
It wasn't like she was hiding something and you found some notes or something in her room. She told you about Pagel.
She did.
And she asked, didn't she, to have a no contact with Pagel?
She did.
Because she still, as of the time you were meeting with her in January, was expressing a desire not to have contact with him.
Correct.
I want to ask you something totally unrelated to Morgan because I think it's important. You've been doing this for 17 years in the mental health field, right?
Yes.
And we don't need to get into the details of other people's cases, but you are aware that Ms. Geiser's case, if you will, is of a high profile nature, right?
Yes.
We all sort of know about it because whether you've been involved in it or not, people have heard of the Slender Man case and people are just generally aware of that.
Correct.
And the reason why that's important is because as part of Morgan's release planning, that's an additional variable that exists in her case that doesn't exist in everybody else's cases.
Correct.
And so thinking about that variable and talking with her about how to sort of constructively handle that is important.
Yes.
Pagel is sort of, feel free to disagree with me if you want, but Pagel is sort of a classic example of somebody who appears to be fixated, if you will, on the Slender Man case, or Morgan specifically, right?
It appears he's fixated on true crime as a whole.
When you looked at his Facebook page?
Yes.
Because you didn't talk to him, I'm sure, right?
Absolutely not.
So do you know that he's a former, has law enforcement background?
I do not.
Did you know that he used to be in the correction, work in the correctional system?
I do not.
So you know nothing about Pagel?
Nothing.
Other than what you see on Facebook?
That's correct.
And he appears to be somebody who's fixated on, what'd you say, true crime and things like that?
Yes.
And he's the one who's selling things on the internet that he purports are from Ms. Geiser.
Yes.
And you don't know, there's two things that are unclear from when you look at Pagel's Facebook page. One is whether the things he says Ms. Geiser sent him were even sent by Ms. Geiser, right?
I'm sorry, can you say that again?
When Pagel puts something on Facebook and says, here's the Slender Man letter.
Sure.
Do we know as a treatment team that Ms. Geiser even wrote that letter?
No, that was why we were looking into things.
Right, because any person on the internet could claim that I got this from Morgan or I got this from whoever, right? So you don't really know that the things he's saying he got from Morgan even came from Morgan, right?
She had told me that she had sent him things and she was aware that he was selling them. So we did know.
Okay. So Morgan was willing, was just discussing with you the fact that she had a letter communications and had sent him some drawings, right?
Yes, we asked her about it and she was aware.
Okay. Is there any suggestion that Morgan was trying to profit from her crime in any way?
That's unknown.
Okay. In other words, no. There's no evidence that Morgan was
correct
doing that, right?
Correct. Yep.
Okay. And because there's lots of things that are unknown, I just want to focus on what we do know.
Okay.
What we do know is that Pagel is posting things for sale on the internet.
Yes.
And Pagel is apparently fixated on true crime type things.
Yes.
But Morgan herself hasn't had any physical contact with Pagel in over 18 months.
Not that I'm aware.
And has never seen him in the community as far as we know. Right?
Correct.
And has herself asked for a no contact order.
Yes.
And as part of a treatment release, when you're planning someone's release, a person gets rules, right? It's sort of like being on probation. They have a list of rules that they have to abide by.
Correct.
And certainly on those rules, oftentimes there will be no contacts with certain individuals.
Yes.
I mean, one obvious no contact would be the victim of the crime and the family members, right?
Yep.
And then, so it seems like Ms. Geiser is aware of that. So when she uses the phrase no contact, it's in the context of, I'd like there to be a rule that makes it clear not to have contact, right?
Correct.
And in terms of making sure that somebody knows how to, well, let's go back to sort of the nature of the crime. There will be people who probably try to reach out to Morgan if they know where she is or they know how to get a hold of her because they might be obsessed with Slender Man case, right?
That's been the history.
But actually what's going to happen, as I understand it, is Judge had ordered conditional release, and so you, as part of the planning group, you were going to put together a plan for her to go to a group home, was the idea.
Correct.
And as I understand it, there were 2 group homes that were identified, but one was too expensive and one was affordable, right?
Yes, well, yes,
Two group homes that would take her, right?
yes,
And so the one that you had identified would be a location that would be confidential in a way, wouldn't it?
we were going to try to make it confidential.
Okay, I just want to explore that. I mean, the idea was even Morgan shouldn't reveal her own location to start with, right?
Yes.
So don't, and it may not be, we're not saying forever, but to begin, don't even let your mother or anybody know the exact location, right?
Correct.
Because what I think we're trying to do is make sure when she's released that these Pagel type people don't flock to a group home or start writing letters to her as she's transitioning into the community, right?
Correct.
And so in a way, as she sits here right now, anybody can write a letter to Winnebago where she is, and either Winnebago gives it to her or they don't, right?
That a yes or no?
Yes, I'm sorry.
But when she goes to the group home, the idea, your guys' idea, or the team's idea, was keep the location confidential as much as possible so we can help transition Morgan into the community safely.
Correct.
And that can be hard for her to process in a way because it's almost more restrictive in a sense than Winnebago is, isn't it?
Yes.
I know she's worked hard. You would agree she's worked hard to earn her release from Winnebago, right?
Yes.
And so she has release privileges where she can go into the community in a supervised fashion and have visits from family members and friends, right?
She does.
But that's going to change when she goes to a group home. She's actually going to be more restricted to start with.
Initially, yes.
And Morgan specifically and people in general, that can be a hard thing to have to work through, the fact that they're going from having some privileges to now having almost more restriction, even though they're not in an institution.
Yes.
So things like crying and let's talk about the books. Did you ask Morgan to put together a list for you of all the books she's read? Let's pick the last year. Did you say, Morgan, give me a list of all the books you've read in the last year?
No.
You do know that she read Rent Boy, obviously, because you mentioned it, right? But the reason we know that is because Morgan brought it up as part of the release planning.
Yes.
And that's important because it's not like you found it hidden somewhere in her. It's not like Winnebago found it hidden somewhere, right?
We asked her to provide us with a list of books that she would like to read, and she had brought up that she was reading Rent Boy. She stated that she didn't want to tell the conditional release team the kind of book she was reading because she was afraid that we wouldn't allow them because they were kind of dark, I think was the way she described it.
Did you ask, so you were asking sort of prospectively, can we have a list of books that you are planning to read as you are released?
Yeah, what are you interested in reading?
Okay, but you never asked her for a list of books she's actually read, right?
No.
And in something like Rent Boy, there's no evidence that she sought it out. It appears that somebody mailed it to her at the institution, as you understand it, right?
I don't know if she sought it out or not.
Well, but you said before you believe someone mailed it to her.
That's what I'm told, yes.
Okay, so all we know is that someone mailed her this book and she read it, right?
I suppose that's what I'm told.
Yeah, we're told that someone mailed her the book.
Yes.
She read the book, and then she disclosed to you or the team that she had read the book.
Yes.
Okay, and so isn't honesty an important part of one's release plan?
It is.
Morgan should be commended. Morgan should be commended for not concealing the fact that she was reading a book that has some dark themes to it. Agree?
I'm not sure. I'm not a doctor, so I don't, from the clinical standpoint, that's not my role.
Okay, so you defer that question to the doctors who can testify about whether that's applicable.
Yes.
But it gets presented to the court and disrupts her release plan potentially because it's being represented as a problem, but you've never talked once to the doctors about it.
Correct.
Okay, and you could have. Before you filed this letter from WCS that now seeks to revoke her release, you could have called any of these doctors before you filed this letter and asked them, hey, we learned that she read Rempboy. What's your opinion? Is that a problem?
Objection, she didn't file the letter.
Okay, before you authored the letter, you could have called any of these doctors and asked them, is this a problem?
DHS contacted the treatment team at Winnebago to look further into it. So that's what they were doing.
Okay, and so the answer is you didn't do that, right?
Did I contact the doctors? No.
Now, since you read Dr. Lundbaum's, I want to ask you about Dr. Lundbaum's report. You know you've read the 3 doctor reports, right?
Yes.
And therefore, you are aware of the fact that even back when Dr. Lundbaum authored her report in December, that it was known to the doctor, it was known to Dr. Lundbaum at least, that there are drawings, letters, and other items being sold on the internet purported to be drawn by Ms. Geiser. You were aware of that, right?
Yes.
So it's not anything new. Dr. Lundbaum knew that when she wrote the report.
Yes.
And in fact, when Ms. Geiser was questioned about it, she acknowledged that she had done that, right?
Yes.
Okay. And this Jeffrey Pagel person, are you also aware of the fact that Jeffrey Pagel was a known person to Dr. Lundbaum as well?
I recall that she had knowledge of him, yes.
In that Ms. Geiser had talked about how the fact that she learned on her own that this Pagel person that her letters or drawings that she had sent to him, that he was involved in trying to sell these things, she brought it to the doctor's attention back in June of 2024.
I don't recall what's stated in the report.
Now, the reason these reports are important is because when a person is released on conditional release, these reports become part of the treatment process, don't they?
They do.
And you've read the reports, but I just want to be clear, you never reached out to these doctors to discuss any of your concerns about the book or Jeffrey Pagel,
Objection
right?
asked and answered.
Sustained.
So, with respect to the art that Ms. Geiser does, were you aware of the fact that Ms. Geiser has discussed her trauma therapy and the therapeutic benefit from her artwork, and the fact that a lot of it is disturbing but helps me cope with the trauma I've been through? Are you aware of that?
That's not my role.
Okay, but we're using her artwork here, this picture that you testified to. What's the point of providing this to the court? What is the intention behind giving this to the state?
What is the intention behind giving it to the state?
Yes.
Because it raises a concern for risk.
But you never took this picture that you've now given to the state and asked Dr. Lundbaum, does this change her risk?
That's not my role.
Okay, whose role is that?
That would be the doctors that are treating her.
That would be the Winnebago doctor's role.
Winnebago, yes.
So you become aware of a drawing, and you then mention it in a revocation letter that is supplied to the court. But you were also aware of the fact that Ms. Geiser has been drawing disturbing things for a long time. And Dr. Lundbaum was aware of that when she suggested that Morgan was appropriate to be released, aren't you?
That's the report.
This is not new. Her doing a disturbing drawing is not a new fact at all. Agreed?
Agreed.
Okay. So we'll put that to the side. And nor is Jeffrey Pagel a new thing at all. He was known 2 years ago in June of 2023 when he was going to the institution.
To Dr. Lundbaum, yes.
Well, actually,
And it was in her report.
Right, and to the whole institution, because the records at Winnebago reflect the fact that he was a known visitor to their facility.
Yes.
And the records never showed anything inappropriate between Ms. Geiser and Mr. Pagel during any of those visits.
I'm
I'm going
unaware.
to object on foundation of this witness to testify about all of Winnebago's records.
Overruled. Witness can answer if she can. If she doesn't know, she can say she doesn't know.
I do not know.
So in addition to this one book, Rent Boy, did you ask Ms. Geiser about the other types of literature that she's interested in?
Yes.
You know that she's interested in biographies, right?
Yes.
And you know that she likes historical books, if you will. I might have said Westerns previously. She doesn't like Westerns, but historical books, right?
I am not aware.
But she's talked about her like of Vincent van Gogh, for example, and reading biographies about him, right?
Okay, yes.
And at Winnebago, she doesn't have internet access at Winnebago, right?
I'm not sure what she has access to at Winnebago.
But when you've met with her and talked to her about her hobbies, a central hobby for her is reading, right?
Yes.
It's really been, for the 11 years that she's been in custody, it's really been a crutch for her and something that she's relied on, isn't it?
I know that it's something she's interested in.
And so what Morgan has, and Morgan has an interest in a wide array of reading material. You're aware of that, right?
I'm not aware of a wide array. I know of the horror books that she's described. She mentioned fantasy and the biographies.
Okay. Those are all my questions.
All right, thank you. Redirect.
Argument that this is all old
Ms.
news.
Whitaker, why did you think it was important to share
pretty
this
strong.
information with the Department of Health Services?
It raised risk, and we needed to be aware that the treatment team was aware of these risks and that they were being addressed in treatment with Ms. Geiser.
When you say treatment team, what are you talking about?
I'm referring to the doctors and therapists at Winnebago.
Why, if Ms. Geiser is getting out into the community anyway, why does it matter what is being addressed with the treatment team at Winnebago?
We take that as a foundation as we go into the community and know how to treat her into the community to mitigate risks. It's a much different, what is allowed in a confined setting is much different than what can be allowed in the community.
Those are all the questions I have. Thank you.
Any further cross based upon the redirect?
No, Your Honor.
All right, thank you. You could put the exhibits just up on the counter here. That would be fine. Thank you. You can step down. Thanks for being here.
Thank you.
If your cell phone is ringing in here, it better be a direct phone call
Judge, at
from
this
God.
time, I would like to call Kathleen Martinez to
Wonder how
offer
he feels about
testimony on
phones.
Courts Exhibits 1 and 2 as well.
All right, very good, Ms. Martinez, if you'd come forward.
Do you swear that the testimony you're about to give in this matter before the court should be the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, thank you. Be seated. Pull up to the microphone. That's the bar with the red light. State your full name and spell your last name.
Kathleen Martinez, Martinez.
Is Kathleen with a C or a K?
K.
K. All right.
Ms. Martinez, where do you work?
Wisconsin Department of Health Services,
What's your role there?
Forensic Mental Health Section Manager.
Where's your office?
My office is 1 West Wilson in Madison, Wisconsin.
Okay. Do you work with someone named Aaron Graff, Graf?
I do. I supervise Aaron.
Okay. Were you involved in the filing that's been discussed at today's hearing regarding the petition to revoke conditional release for Morgan Geiser?
Yes.
Okay. I believe in front of you are Courts Exhibits 1 and 2. Is that true?
Yes.
Okay. Do you recognize both of those items?
Yes.
Looking at Court's Exhibit 2, and just to clarify for the record, were you just in the courtroom during the testimony that was offered by Ms. Whitaker?
Yes.
Okay. Do you know Ms. Whitaker?
Yes.
Okay. Are there portions of Exhibit 2 that you authored as well?
Yes.
Could you please clarify for the court which portions you authored?
Number 7 was hers.
The conclusion portion of the letter, page 5, part of page 6. DHS reviewing these documents is standard practice for conditional releases, and we often make edits or final approval before filing these documents.
Okay. So how does WCS relate to DHS when we're talking about someone that's been granted conditional release?
DHS contracts with WCS to provide conditional release case management to any conditional release person in certain counties in Wisconsin, including the southeastern part of the state.
Okay. Does that mean that the person would only work with a WCS case manager and no one from DHS?
Upon release?
Right. Or would they have both?
DHS also contracts with Department of Corrections to provide supervision. So the individuals that are conditional release work with their WCS or the contracted case manager, the contracted DOC agent, and any other treatment providers or service providers that are indicated in the plan.
Okay. In terms of preparing a conditional release plan,
We just passed the
is
6-hour
DHS
mark.
involved in that?
We review it when it's complete.
Okay. Were you involved
That might be
in
why.
any of the meetings that occurred in regard to the plan for Ms. Geiser?
No.
Okay. At some point in time, did you become involved in the planning for Ms. Geiser?
Yes.
Why?
I received pictures of Facebook posts that were concerning. I received them from Erin Graff that she received from WCS.
Okay. And are those some of the things that have been discussed during Ms. Whitaker's testimony and are detailed in Exhibit 2?
Yes.
Okay. Ultimately, were you able to review the information compiled by Ms. Whitaker in Exhibit 2?
Yes.
When you learned that information, what did you do?
I alerted the department administration because it is a practice to complete high-profile notifications if we believe that there may be attention or media drawn to a specific case, and that's what I did.
Okay.
How do we go 6 hours
Did
without
you-
a commercial and then everyone's getting commercials?
Have contact with Winnebago Mental Health Institute about some of these issues that were raised, or risk issues that were raised?
Yes, I did.
Why?
To ask them about their perspective from their, from their end.
When you approve a conditional release plan, is it important for DHS to have an understanding of what is in place with the current treatment team at the facility the person is in?
It is.
Why?
Because if somebody is making progress in treatment, we would like to continue it in the community. And when we write conditional release treatment plans, those plans should be informed by the assessed needs and risks that are done by various people in the current treatment team.
Now, would doctors who are court appointed to make evaluations about appropriateness for conditional release be the same as doctors that are in someone's treatment team in a facility?
No.
What's the difference?
The court-appointed doctors are independent examiners, not affiliated with DHS, and meet with conditional released clients or prospective conditional release clients for purposes of offering an opinion about whether the conditional release poses a threat to the individual or community or property. People at the institution treatment team would be people that interact with an individual at whatever frequency they determine is needed to address treatment concerns.
Did you try to ascertain whether information was known to the Winnebago treatment team regarding Ms. Geiser in this case?
Yes.
What specific information were you trying to learn whether they were aware of?
Had they seen the posts that I had received from around Jeffrey Pagel, including the contents of the postcard and the specific drawing, and if they knew the extent of the content of the current book, Rent Boy.
Why did you want to know that?
Because I would be interested in incorporating their opinion about what interventions would be needed to address any risk associated with those items, or perhaps they might say that they were aware and that they had no concern with it. And, so since they're treating her, I was interested in understanding more about that.
Ultimately, was a decision made to file a request to this court to revoke the conditional release as opposed to finalizing and offering a plan?
Yes.
What entity's decision was that?
Department of Health Services.
Okay. And why? Why is that the position of the Department of Health Services?
Because when we asked if the treatment team were aware of the extent of these issues and the content, they said the Winnebago social worker.
I'm going to jump on hearsay grounds.
No, I'll overrule it. I'm satisfied. To some extent, it's offered for the truth of the matter asserted, but it's also offered to it's offered to show what, after receiving the information, what the witness in the department did. So I'll overrule the objection. Witness can answer.
I can answer.
Yes.
The social worker indicated that she had not told the treatment team that the specific details of the posts and the specific details of the drawing and the specific content of the current book, Rent Boy.
Why did you
That was in
describe
a
that
meeting
as current
with
book, Rent Boy, instead of just the book?
Aaron Graff, Nicole Whitaker, and the WCS case manager were that. So to answer your question, so because the treatment team had no knowledge of these, they could not indicate whether they thought it posed a risk or they thought it was great or whatever. They couldn't answer that question because they didn't know about it.
Were there aspects of these concerns that had direct relation to the index offense that caused the department concern?
Yes.
Like what?
The material being horror related is similar to the content of the Slenderman content, and that was similar enough. The material being related to killing people and violence was similar enough to ask a question about risk.
Did the department have concerns about Ms. Geiser's self-reporting tendency to disassociate when stressed.
Yes.
What was that concern?
That in a report by Dr. Lumbaum, there was indication that Ms. Geiser was aware that she sometimes disassociates, and that was what was happening during the index offense when her environment is stressful. And releasing to the community is often includes elevated stress for the individual. And so we were interested in knowing what her treatment team thought about that in relation to her current reading material.
Was the decision to request revocation made before you checked in with her Winnebago treatment team?
No. But we would have liked more time to get more information. That's part of the problem, is that
I had this for 3
we
years.
didn't have the information we needed, and our job is to write a plan that mitigates risk to the community. It's hard to do that if the risk is unknown.
Is the information contained in Exhibit 2 that you authored still true and accurate as you sit here today, as far as you're aware?
As far as I'm aware, yes.
Okay. And is the position of the department continue to be that the court revoke conditional release at this time?
At this time, yes.
And what, you're aware that one way the department can seek revocation is when rules are violated, right?
That's correct.
Does that apply here?
No.
Why not?
Ms. Geiser did not violate any rules of conditional release.
Right. So then why
I'm
is
aware.
why is the department seeking revocation at this point then?
It's based on concerns about safety to the community and to Ms. Geiser.
What was the purpose of her commitment to mental health? Are they trying to cure her? Are they trying to restore her sanity?
You were in court when State's Exhibit 1 was offered, the drawing, is that true?
Yes.
Is that something that you had seen before?
Yes.
Is that something that you inquired with the Winnebago treatment team prior to filing the request to revoke?
We asked, had they received or aware of any of the posts that were done on Facebook, and they said that the Winnebago social worker indicated that the treatment team was not aware.
What about in terms of, was the treatment team aware or worked with Ms. Geiser on her tendencies to enjoy violent artwork or something like that? Was that something that was known and aware?
I believe that it was, but I don't know that for sure. But I think so, based on the reports submitted by the independent examiners. And so, yes, I think so.
So what aspect about the posting was concerning to the department and unaware to the treatment team?
They indicated they weren't aware of any visits. They weren't aware of the fact that he'd indicated sexual arousal based on the index offense. They were aware of the general themes, but not the details of the specific posts or drawings or the particular book.
Judge going to rule today?
From what you were able to review, did it appear that there was well, strike that. How do you know that this person, JP, was sexually aroused by the index offense?
I don't know that he was, but Morgan, the Wisconsin, the WCS conditional release team reported that Ms. Geiser told them that he was, and that was why she asked, part of why she asked for the no contact.
So she did everything right.
At that point in time, she hadn't had contact with him since June of 2024, right?
It says 2023 in the records. Exhibit 2, paragraph 7.
That was the June of 2023 is the last reported visit. I have no idea when the last contact they had was.
Okay. But from what you were able to gather, her treatment team, she never told her treatment team, hey, I'm writing letters to this person who's sexually aroused that I committed this crime 14 years ago.
Not that level of detail, but I believe they knew about him. You know, they knew his name. I asked if this was, that specifically, the sexual piece has been addressed at all in treatment, and I was told that they weren't aware of it, so.
This witness has a very halting mannerism when she answers questions, like she's trying to not say something. Knows no bounds, is the tissue box. You collect bad.
Are there any other risk concerns that the department has that you think that the court needs to know about?
I'm going to object on notice. I'm going to object on notice grounds. If they file a petition to revoke, they can identify the grounds, which they've done, so that we have notice and can investigate and respond.
Yeah, no ambush here.
Overruled. If the witness has additional information for the benefit of the public in the court, the witness can disclose that.
I would just say that generally the conditional release program places people in the safest environment possible. However, and we have the ability to write rules for people to follow, but obviously those rules are broken, and group homes are not locked. People can leave group homes. People can cut off GPS bracelets. So we try to make the best placement possible, the safest placement possible, and we understand that we have rules, and those aren't necessarily safeguards, but I wouldn't, I guess that's just more general information about conditional release generally, not Ms. Geiser specifically.
So you don't have anything else?
That's all I have, thank you.
Okay. Cross-examination.
Good afternoon.
Good afternoon.
You and I have talked one time before, haven't we?
Yes.
I think you were on a Zoom conference that we had about a week or so ago, right? Right?
Yes, correct.
Okay. So I just want to ask you some questions about what you testified to.
Sure.
It doesn't sound like there was any additional concerns that you had beyond what was expressed in your filing. Do I have that correct?
Yes, I think so. Yep.
Okay. And we all know rules can be broken. You mentioned people, I think you just said people could choose to, a person could cut off their GPS bracelet, right?
Correct.
Person could theoretically leave a group home if they wanted to get out somehow, right?
Yes.
He did the cutting action on his
mechanisms
leg.
in place that when people break rules, there's mechanisms in place to address that, right?
Like, for example, pursuing revocation, or do you mean something?
Yeah, a person could be arrested, right?
Yes, if they were, if we could find them, they could be arrested, or we could put them in, we could petition the court to, or ask the DOC to place essentially a hold on them if they were willing to come in and go to jail or something like that.
Yep. So
we could also adjust treatment if we needed to.
Sure. And so as we sit here today, Morgan has broken 0 rules, right?
As far as I know, yes.
Okay. Well, I only want to know what you know. So she's broken no rules.
Yes.
All right. So she's not facing revocation because she broke any rules.
Correct.
She's now, in fact, you've never even given the judge the conditional release plan for her to go to the group home, right? You pursued revocation first.
Correct.
Okay. And you said, I think I have your words correctly, the sexual piece wasn't addressed in treatment. Are those your words?
Yes.
Morgan has never expressed any sexual interest in her crime.
When I said sexual piece, I'm referring to the current reading material of being sexual sadism, plus her interactions with him around being interested, sexually gratified or aroused by her crime, exploring that in therapy to see whether or not that presents a risk to the community. That's what I meant.
Okay. What I heard you say before was that Morgan broke off contact with Pagel when she found out that he was sexually interested in her crime. That's what I heard you say 5 minutes ago. Right?
Are you asking me?
Yes.
Yes.
Okay. So Morgan,
she rescinded his ability to visit her in person.
Right. Which is what you would want a person to do in her shoes.
Absolutely.
She finds out that the guy is creepy, he has sexual interest in her crime, she cuts off contact.
Revocation is not about punishment or saying.
I'm not asking about. First, ma'am.
Sure.
I just want to ask you very specific questions.
Okay. Sorry.
What you want someone in Morgan's shoes to do is if someone reaches out to her and starts expressing sexual interest in her crime, you want her to cut off contact with that person.
Yes.
That is what she did. Correct?
Correct.
In June of 2023. Right?
June of 2024.
No, June of 2023.
She rescinded the release on June of 2024.
Right, but the last time she had contact with him at the institution was June of 2023.
It was 24 that I rescinded it
Right.
for that reason in June 24.
Oh, she became aware of it in June of 2024 and then rescinded the contact, right?
I don't know that.
Okay, all we know is that she rescinded it in June of 2024, right?
Correct.
But we know for sure that the last time she had any contact with him in the facility was June of 2023, right?
The last visit he came to Winnebago was in June of 2023.
Okay. Now, have you ever yourself met with Morgan?
No.
Okay. And you are what is your educational background?
I have a bachelor's degree in psychology and a master's degree in social work.
Okay, so you're a LCSW.
APSW, Advanced Practice Social Worker.
So you're a social worker by training, right?
Yes.
And you talked before about Dr. Lundbaum's report, so I'm assuming you yourself have read the doctor reports that were filed about Ms. Geiser, right?
Correct.
Because that's an important part of your job is to read those reports and know what the doctors are aware of, right?
It's not part of my job, but I did in this case.
Okay, why'd you do it in this case?
In order to understand the situation better.
Because of the high-profile nature of it?
No, because of the concern brought to me by the team.
Okay. So with respect to Ms. Geiser's artwork, you're aware of the fact, aren't you, that Dr. Lundbaum that Winnebago itself was aware that Morgan has part of her therapy is her artwork. You know that, right?
Yes.
In that it's been a method that they've used to help her cope with her trauma, right?
Yes.
In that, in fact, it's been known for quite some time, it was known even to Dr. Lundbaum, that the artwork is disturbing. That's not new information.
No.
And Dr. Lundbaum, despite that, and knowing that...
Well, that was a double negative.
Okay. Then let me be precise with it. I think I should ask the question. You know that Ms. Geiser has drawn artwork of a disturbing nature in the past, right? You know that?
I read that, yes.
Okay, you read that in Dr. Lumbaum's report?
Yes.
Okay. Now, with respect to the book, Rent Boy, are you aware of how Ms. Geiser got that book?
I was told that it was mailed to her.
Is that all you know?
Yes.
Okay, someone mailed it to her.
Yes.
And the reason you know about it is because she said that she read it, right?
Yes.
She brought it up. It wasn't like it was discovered. Right?
I don't know.
Oh, you don't know. Ms. Geiser stated she just finished a book titled Rent Boy by Gary, Indiana, which she stated was about prostitution and black market organ trading. Are you aware of that sentence in the WCS report?
Yes.
Okay. So Ms. Geiser was the one who disclosed that she read the book.
Yes.
Don't we want, as part of DHS, don't you want honesty?
Yes.
So it would be a concern if somebody wasn't honest about reading a book like that, but it's,
yes.
But it's also a concern when they are honest about it.
If the concern was that upon further investigation and looking into the themes of the book, when they asked her about it, her response was, oh, I forgot that part, which is also indicated in the memo.
She stated that it was darker and disturbing, right?
I mean, I wasn't in that meeting.
Okay. And really, you don't have any personal familiarity with Ms. Geiser as an individual because you've never met her, right?
Correct.
And when you talked before about the sexual piece that wasn't addressed in treatment, what we're talking about is Jeffrey Pagel, whoever that is, his sexual interest in whatever, right?
And sexual sadism, the combination of that.
That he's interested in sexual sadism and?
No, the book related, the Rent Boy book had themes of sexual sadism.
Right.
So
the concern is, as I understand it, the concern is one book that she read, one book in 11 years, one book.
Okay.
Had some themes of sexual sadism.
Okay.
That's a concern, right?
Yes.
And then there's another concern that someone named Jeffrey Pagel is sexually interested in her crime. That's another concern, right?
The concern is the combination of that. And right. Whether or not the treatment team has addressed that and what they think about it. The concern is a question of risk. It's not a determination of risk.
What is there to address about Jeffrey Pagel's sexual desire over a crime that happened? What can Morgan do about Jeffrey Pagel's problems? Other than contact.
I do not believe Morgan has any responsibility to address Jeffrey Pagel's concerns.
Okay. So all the stuff he's posting on the internet about his own behavior, that has nothing to do with Morgan, right?
I don't agree with that because the content of what is posting does have to do with Morgan, but that he's posting is not Morgan's fault or responsibility.
Right.
TSN, thank you very much.
And what would be your role, ma'am, in Morgan's future when she goes to the group home? Do you play a role in her life, or would you play a role in her life?
I oversee the forensic specialists that work at the Department of Health Services that oversee the contract for conditional release, case management and supervision.
So when a person is, in other words,
go ahead, sorry.
Selena K.
So when a person is released to a group home and they have their rules, if they violate the rules, then you oversee the treatment providers who would address that. Is that what you're saying?
Me?
Yeah.
No.
Okay. So really you would play no role in Ms. Geiser's life going forward. You wouldn't be involved in treatment or anything.
Very rarely would I be involved in any conditional release person's day-to-day life.
Did you ever ask Ms. Geiser to provide you with a list of books she's read over the last year?
No.
To see what topics? No. Did you ever reach out to this Pagel person to ask him any questions ever?
No.
Is he a real person?
And you did say before that the treatment team did know about him. You're aware of that, right?
They knew his name. They indicated they did not know about the visits or any other details.
Yeah, so the visits at the facility, right?
Do you have an answer?
Yes, sorry. Yes.
Thank you.
And between the time
Judge is
that the
on it.
judge ordered, so I'm sorry, you're a part of DHS, right?
Something's wrong about that
And
statement.
so it was actually your job to make sure that a conditional release plan gets filed with the court for the judge to either approve or not approve, right?
Personally?
Yeah.
No.
You're not involved in the drafting of that report?
No.
Or that plan, I should
Correct.
say?
No. I mean, yes, you are correct that I am not involved directly in the drafting of that plan.
That was
And Morgan, between the time that judge ordered that plan to be drafted and now, she hasn't done anything violent, right?
No.
And neither to herself or others, right?
I think that's true. I believe Winnebago would have reported that.
Right. If
can
she was
lead
doing
on
something
cross.
violent to
Right.
herself or others, you'd know about that.
I think so.
And before you put together, when Ms. Nicolai was questioning you about Exhibit 2 that you have in front of you, you are the one who wrote the conclusion section. Was that your testimony?
Yes.
So starting with conclusion and recommendation, did you write all that?
I did.
And you say that Ms. Geiser only provided the information about the book when prompted, but that's because she was asked about it, right? The specific question was asked what she's read recently, and she brought up Rent Book. Is that right?
That refers to the
Rent Boy.
Right. That refers to the detail of the content of the themes of Rent Boy. But Morgan did bring up the book name itself. That's how WCS knew to Google the contents of it.
Right. And you said in your conclusions that reading horror and murder-related books is not by itself necessarily a risk to the community.
Yes, I did write that.
And you feel that there wasn't full disclosure of the book, is that or the contents of the book, right?
Correct.
That's what that comes down to.
Deanie Mullis-Diver, thank you very much.
That's true. What?
For the super chat.
Sorry, can you repeat that question?
You're concerned that there was, in your opinion, a lack of full disclosure about the contents of that book, right?
Yes.
There's no other book she's read that you're raising today as a red flag for the court, right?
Correct.
That's the one.
That's an example, yeah.
Well, that's the only one you're aware of that's a concern, right?
The concern is about, I'm talking about that specific book, so yes.
Okay. You mentioned that in your conclusions that living in the community through conditional release, there is inherently less structure and supervision when compared to a state mental facility, meaning she theoretically has more freedom to leave if she wanted to, right?
Exactly.
And Morgan hasn't tried to escape from Winnebago that you're aware of, right?
No.
And you say that group homes are not locked, typically not staffed by individuals who understand complex mental health problems, and even with GPS, could not guarantee prevention from absconding, right?
Correct.
That's true for everybody. That's nothing unique to Morgan.
Correct.
And that somebody could form a bad relationship that would exacerbate a risk, that's not unique to Morgan. That's anybody.
True.
And that's just something we have to deal with, isn't it? That's part of the nature of somebody going into conditional release, is that it is a gradual process to give that person more freedom, and there will be potentially more things that could happen, right?
That is true. The recommendation was to monitor social contact, social relationships from one of the independent evaluators. So so we monitor different things depending on individual needs and risks.
And treatment doesn't stop for a person once they're released from the Winnebago Institute.
No, it doesn't.
In fact, it might change because that person now has a different set of challenges that they have to confront, right?
Yep.
And so part of the job of DHS is just making sure that as part of the contract, if you will, is to make sure that those treatment providers are in place and available to the released person, right?
Yes.
And treatment remains something that If there's a concern about a book, for example, a rule can be put in place that a person not read a particular type of book, right?
A rule could be put in place, that's true.
And then if a person violates that rule, then, as you know, petition to revoke gets filed with the court, right?
Yes.
So if we...
Well, possibly.
Right, it doesn't have to result in revocation. You could choose to do some alternative approach.
If we found out about it, yes.
Right. So, and so the way you work through things is to establish rules, right? Rules get established for a person when they're released.
Yes.
And in this case, no rules have even been really, other than the ones that exist at Winnebago, there's really been no set of rules that's been provided to Morgan to say, here's what you can read and here's what you can't read, right?
I don't know that.
Well,
I have no idea actually of that.
Well, you said before she's not here because she violated any rule. We've already established that, right?
Yes.
Meaning?
Because there's a standard set of rules.
Right. Meaning there's no rule that prohibits her from reading Rent Boy, for example.
Right, yes.
There's no rule that prohibits any type of reading against her.
Right, yes, correct.
She discloses what she's read as part of the release plan, and she gets served with revocation papers. Do I have that right?
Objection argumentative.
No, that's...
No, overruled. It's cross-examination.
Right, that's what happened. She has no rule prohibiting her from reading any genre at all, right?
Correct.
She then reads Rent Boy, that's what sends her, and discloses it, right?
Correct.
And then she's served with revocation paperwork and told she won't be released for 6 months. That's how
the revocation is not based on rule violation.
Based on
safety concerns.
Safety concerns over something she read that wasn't prohibited.
Yes.
Okay, that's all.
Any redirect?
You were asked a lot of questions just now about why the petition to revoke was filed. And those questions seem to suggest the only reason was because of one book that Ms. Geiser read. Is that true?
Yes.
That's the only reason that this.
Oh,
was
sorry.
filed.
Sorry, go ahead.
Is that the singular only reason that she said, I read this book, and so you said, I'm going to file this petition?
Oh, no.
Okay. Is it fair to say that it's a much more complex analysis that was done before the determination to file this was made?
Yes.
The discussion that was had regarding this Mr. Pagel person, you agreed with defense counsel that he certainly seems to have some issues, right? And that they're not Ms. Geiser's problem.
That she shouldn't be punished for, right, or responsible for dealing with his issues.
Right. But there's still a concern that the department has because this is a person that Ms. Geiser decided to have a relationship with for some period of time, right?
That's true, but I would say the crux of the concern is that her current treatment team was not aware of the extent of their relationship, the extent of the content of the post. It's that they might have been aware on some level that he exists, but they weren't aware of the detail. The same with the book. They weren't aware of the extent of the details of the book. And that without their perspective on what that looks like in terms of risk mitigation or treatment intervention, we had no choice other than to file a petition for revocation because we cannot write a treatment plan that addresses risks that we're not aware of, that we've asked about, and the treatment team said, well, we haven't addressed it because we were not made aware of this level of detail.
And when you talk about level of detail specifically with this Pagel person, did the detail include the fact that some of the content of correspondence Ms. Geiser sent to him?
Yes.
What specifically?
The postcard that indicated a desire to be intimate with him.
Okay, that's new
Was
information.
that information that the Winnebago treatment team had?
No,
Do you think that it's a distinction for the treatment team to be aware of someone's name versus to be aware of a fact like that?
Yes.
Why?
Details that around the specific details around the nature of their relationship could exacerbate risks to the community. And I think it would be important for them to have explored that in order to indicate what current interventions are in place and how we might be able to address that in the community.
If the department became aware that there was someone out there in the world who seemed to be fixated on Miss Geyser and was sending her things and wanted to come see her, but there was no evidence that she ever reciprocated any communication, would the department have filed revocation papers?
Probably not.
Again, there are some things inherent about this case that are going to be outside of Ms. Geyser's control, right?
Yes.
Are those aspects the reason that the department has filed the motion to revoke here?
This has been asked and answered numerous times about why they filed their petition.
No, overruled.
Can you repeat it? Sorry.
Sure. These aspects of things that are outside of Ms. Geyser's control, just based on the nature of this case, are those the reasons that the department has concerns about risk in this matter?
No.
Okay. Are the concerns about risk specific to Ms. Geyser's actions and behaviors?
Yes.
That's the right answer.
That's all I have. Thank you.
Why don't they say something to the effect like, we're afraid that she's trying to hide
You
her
said
behavior?
a postcard that Miss Geyser wrote Pagel.
Yeah, here's the postcard.
Where she expressed a desire to be intimate with him, right?
Yes.
One postcard. Right?
You're asking, sorry, what is your question?
You're aware of one postcard, one time.
One postcard, yes.
Where she wrote someone who had visited her and said she wanted to be intimate with him.
Yes.
She's an adult woman, right?
Yes.
Wanting to be intimate with someone is not a risk factor, ma'am.
Wanting to be intimate with someone who is sexually aroused by an index offense may be, and that is the question that I had to the treatment team.
And there's no evidence that when she wrote him that postcard saying she wanted to be intimate, that she was aware that he was aroused by the index offense. Agreed? There's no evidence of that. Agreed?
I have no idea.
Okay, thank you. And it was Miss Geyser who cut off contact with Jeffrey Pagel, not the other way around.
Objection asked and answered.
Sustained.
You can't write a treatment plan to control for risks we are unaware of. That's what you said?
Yes.
You can, if to be clear, you can put in theory, you can put any rule in place you want. If you want to prohibit Morgan from having contact with someone, that can be a specific rule that gets put into her plan, isn't it?
The treatment plan indicates treatment interventions and is distinct from the rules of supervision for conditional release.
Okay, but it's already, but
yes, we can put any rule we want, I guess.
And
it would be subject to review by the court, but yes.
Right, because she doesn't get released until the judge reviews the plan, right?
Correct.
So, okay, so when you said treatment plan, you weren't talking about a conditional release plan. That's a separate thing.
The conditional release plan does not indicate the rules of conditional release supervision, but it indicates treatment interventions and also placement, location of placement and that kind of thing.
Got it. Those are all my questions.
Any further direct?
No, thank you.
All right. Thank you, ma'am, for being here. Have a good day. Thank you.
Might have one more witness. Then we're going to try to jump back up to Thurston County.
That was what I was thinking.
fascinated with this lawyer.
Indicated
on the
Ms.
fence.
Groff was present.
She is.
And how he
here, yes.
interacts with his pen.
Any significance to her testifying?
I was not going to call Ms. Groff, no.
All right, all right. Any further witnesses at this stage?
There is, I'm just trying to find her name, I'm sorry.
You asked for someone to appear by Zoom.
Lisa Portman is on Zoom. She is appearing remotely with the permission of the court.
Are you calling her?
Yes, please.
So is Portman in the Zoom arena?
I believe she was.
Where's the screen you can see?
Ms. Portman, are you there?
You have to unmute. You're muted.
Yes, I'm here.
Okay, we've got to connect you up to Zoom so we can see you. That may be on your part to connect up the camera.
I'm pretty sure it is on her part. If you're able to do it remotely, that would be an issue.
Sorry, I'm trying to turn on the camera and I'm not quite, it's not, oh, there it is. Okay.
Oh, there we are. Okay, good afternoon.
Hello.
So I can see you and I can hear you. Can you see and hear the court?
Yes, I can.
All right. Do you, Attorney Nicolai, do you recognize Ms. Portman?
No, I
No.
don't.
All right. Well, we'll assume you are Ms. Portman then, true?
Yes.
Until further examination.
You could be
I'm
anybody.
going to ask you to stand if you can. Raise your right hand. Our clerk's going to swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you. Please be seated. And then state your full name and spell your last name.
Portman, Portmann.
And what's your first name?
Lisa,
All right, thank you. And where do you work?
I work at Winnebago Mental Health.
All right, and you're currently out of state, true?
I am.
And because you're out of state, the court authorized you could appear by Zoom today.
Thank you.
True? I mean, that's true, correct?
Yes.
All right, very good. Then I'll turn to Attorney Nicolai.
Thank you, Judge. Ms. Portman, do you work with Morgan Geyser at Winnebago?
Yes, I do.
And how, in what way?
I am assigned as an individual therapist to work with her.
Are you aware that the Department of Health Services has filed a petition to revoke conditional release in regard to Ms. Geyser?
I am.
Were you part of any of the conditional release plan meetings at all in regard to Ms. Geyser?
Just one.
Okay, would it have been the initial one with a bigger group involved?
Yes.
Okay. I have some questions specifically about pieces of information that I'm interested in knowing whether Ms. Geyser's treatment team was aware of that I would like to ask you about. The first involves a book. How much work in therapy was done regarding addressing Ms. Geyser's preferred reading material, if any?
Can I express that I have some concerns about disclosure?
Yeah, I was going to
for
raise
therapy sessions.
Yeah. Sorry, I was going to address that issue as well.
All right, so we should address it.
Right, I would think that there would have to be a release signed or some sort of waiver for, I think what she's concerned about is testifying to information in therapy that has not been subpoenaed by the state.
So she needs a release to do that.
They would need a release to have.
So what's your client's here, you're here, what's your client's position?
I need to speak with I didn't know they were calling the therapist, so I haven't even discussed that with Ms. Geyser. I would need to speak with Ms. Portman privately, and then I can come back and advise how we want to handle that.
All right, well, that's reasonable. We'll take a recess at this time for about 10 minutes. I think a recess is reasonable. and then we'll give you an opportunity to do so. Now you'll have to, what we're going to do is we're going to, we have some options available. One is we could clear the courtroom, but for the security, and allow you to confer. We can also
that's not okay.
permit you to go into one of the visiting rooms.
That's the best way.
Or we can have you stay there, take a break, stay there.
I was just gonna step out and call Miss Portman on a cell phone. If she could give the number to Jessica, I could just call her by phone.
I thought you had to confer with your client.
Well, I need to speak with Miss Portman and Miss Geiser. So I guess with respect to Miss Geiser, I would only speak with her after I've had a chance to speak with the therapist. I don't know what she's going to testify to.
She won't tell you anything.
That's reasonable. Do you, we have, that we'll have to, I assume then we're gonna have to, we'll take a break, number one. Number two, Ms. Portman's gonna have to disconnect from Zoom. I'm assuming she only has one phone with her. And,
yes.
And then that contact can occur. There's no need to broadcast your phone number over the public airways, but you could text it to someone. Have you provided your phone number to Attorney Nicolai?
No.
Have you provided it to the court?
Yeah, I can respond to the email with my phone number that I was sent the subpoena.
Okay, so that would be to Attorney Nicolai. Yeah, let's do that. We'll take it. Let's go. We'll take a break for about 10 minutes. Let's say 10 minutes, and we'll do our best.
And then, Judge, if they're going to converse it here, I'll just have everybody in the gallery go outside. And we'll
How do you want to handle then your conversation with your client?
We'll just go right in a private area and talk.
That's a jail area. There's no actual rooms. Those are just cells.
No, I thought there was a communication capability.
Yeah, she can go in that room and I can go in the other room.
Okay, yeah.
Yeah, so we'll do that.
All right, so we're going to take, let's be in recess to 4 o'clock.
All right. Put you in a room and just chat.
Yes. Okay, court's in recess.
Interesting process here. We don't see this very often because this is a release, conditional release hearing because the state is opposed to this defendant's release from a mental hospital. And the reason they're saying there's a problem is because, well, there's this guy she met with that, came and visited, and he really likes her work. I don't know, how do you say that? He really likes it. When she found out how much she liked it, she said, that's not for me. Let's have no contact, and even go so far and ask him for a no contact order against him. So the state's trying to say there's a problem because obviously this guy really liking her work and some of the topics that are raised in that Rent Boy book by Gary Indiana, which I think is a writer's name, a pen name. I don't think that's a real name. Because that's Gary, Indiana is a city. It's actually sung about in what about Music Man, I think. Anyway, they're saying because the themes are the same, she might have interest in that sort of thing, which could be a danger to society. But I think she's done from a treatment standpoint, she's done everything that she should. She wasn't not allowed to read the book. I mean, she was interested in Slender Man before. Slender Man's a little bit dark, okay, from the beginning. So if she was not told she's not supposed to read books like that, reading a book like that is not against the rules. Concerning? Maybe. Against the rules? No. So, yeah. Let's see. They just found out. Where's my lights go? Why did my lights disappear? Oh, I've got a battery right in front of me. Bingo. Lights are back. Is Slender Man like from video game or what? From the internet, from the dark corners of the internet. Is a Slender Man fictional character, which now has spawned a I don't know, book, a movie, a whole bunch of Halloween costumes, and a murder case. So there's that. This brings up an issue, right? This brings up an issue. When we have somebody who is determined to have been mentally unfit to be held accountable for a crime, we as a society, we look at them and say, because of that, you're not accountable. Because of that, we will not hold you accountable for the outcome of what occurred. Now, we will make you get treatment, and if you don't get treatment, you stay there forever. But if you do get treatment and the treatment works, you're then still not accountable. We can't turn around and say, now that you're accountable, we're going to hold you to it, because when you were mentally just not there, when you weren't accountable, when you had mental illness issues, and when you made this decision, it had outcomes, and now we're going to hold you. We can't do that. It doesn't work that way. Although I'm not a big fan of DHS and how this is going down. Oh, I think we have a prank call coming in. Hang on. No, not a prank call.
Call from Teddy Bear.
Hey, Teddy Bear.
Teddy Bear.
You need to turn your volume off. Or
Hey.
else I have to...
Yep, I just did.
Okay.
So you didn't watch the previous hearings, right, on this?
I didn't. I followed the news story when this first went down, 10 years ago or something?
Yeah. So the previous hearings were about her treatment, right? And so she, because of her treatment and her success in treatment, she was granted conditional release. And conditional release means they had to go make this plan. And so this is the people saying, like, her treatment, like, we can't make the plan. Like, and so,
we can't
Judge,
make
you
the
need
plan
to go
because
back.
we didn't know about this guy and what he was into, and that she might have something for him and all that.
Yeah, because they can't address, because what they're saying, she's been through they said 14 years in the hospital. And so the hospital, like the people essentially just said, well, she's not hallucinating. She's doing well and has freedoms within the hospital, right? So they're saying, like, medically she's good, but now it's these people are determining if she's safe to go out into the world, and, like, how, can we give her an additional level of freedom and make sure everybody else is safe? And so I think they're essentially saying, like, there were these communications with the outside world that we weren't really aware of, and now we're concerned, and they need to be addressed in treatment. So we need to go back a step.
Well, they testified that treatment doesn't stop just because you go to a group home. It would continue, although there would be more rules and some more freedom in that scenario. So
yeah, well, it's basically like probation, right? You're getting out of
it's like a halfway house.
Yeah. So, and they're just saying, like, it's kind of like a, what's it called? Like not probation. Is it? No, it's a parole hearing, right? And so they're just saying, like, maybe we should take a step back and you should apply for parole in 6 months. Because that's what they did. They did 2 here. Well, this is her third attempt at getting conditional release, and the third attempt was successful. The first one, she had to withdraw because the doctors were like, no way. The second one, they did a whole, which was a year ago, they did a whole thing in front of this judge, and the judge denied it. And then in January, which was 6 months, she's allowed to petition every 6 months. He was not really thrilled with granting conditional release, because the rules from the legal side said that in order to release her, there had to be this plan in place. But the way that the Wisconsin system works is they're not going to put the effort into creating a plan until the judge says yes. Because if the judge doesn't say yes, like, they're going to end up doing this every 6 months and then and having to go back and start from scratch.
And
this
is why we've got stuff that's coming up from 2023. They're saying this is a problem from 2 years ago.
Yeah. So they're the judge was not thrilled. So my guess is that there's no way she's not getting revoked, because the judge was not thrilled in January, but he said this seems like the only next step I can take. So I'm going to try. And and so he tried, and then within 2 months it comes back and they're like, no way. Like, I think she's getting revoked.
I hear you, but wouldn't there be a better argument to make then from the state to say we have concerns that she's feigning everything is good, that everything's fine, I'm better, when in reality she's still reading the same material that goes right along with the lines of the index offense, as they call it. She's associated with people who have a strong affinity to that same thing. Why don't they raise that instead of just saying, hey, this guy, this JP guy, he's a bad nut.
I think that's just the example, because if you go back and watch the previous hearings, there are a lot bigger issues than this. Like, she claims as of like a year ago that she's not schizophrenic. She faked it the whole time. So there are like huge issues with her case. And so then if there's this little thing that comes up, which is, I don't think it's a little thing, but it's a thing that they didn't know about, they're like, whoa, like, let's take a big step back, because like, you claim to have fake schizophrenia for your entire childhood. And then and they took her off her meds, and she appears to be okay. And so I think they all are like, we don't really know what's going on, but we kind of know what's going on. And so we're doing the best we can. But like, if somebody sees something new, people are going to freak out.
Yeah. And I don't know. A lot of people would probably say, maybe give her a chance, but not in my backyard, right?
Yeah, exactly. And I'm very apt to give. I've explained to you a couple of times, like, I have severe mental illness. I'm on disability. Like, this is something I would totally give her, be one person that would be on the side of like, give her a chance. But the fact that she's 22, she's having contact with guys and then not telling her therapist about it, it just seems like the situation's going to go bad.
Yeah. Teddy Bear, thank you very much. I've got somebody else who's dying to get some words in here before we come back from break. So I'll talk to you again soon. We'll see you.
Okay, bye.
Bye.
From Samantha.
Hey, Samantha. This is RA. What's on your mind?
I have just a concern about this. Not as much my opinion of her getting out or not. Mm-hmm. I haven't followed it close enough, but my concern is the group home situations. Having worked in mental health services my entire career, I can tell you that group homes don't require a lot from their employees. There is a high turnover because of the low pay.
Are they a contracted situation, or are they run by the state in Wisconsin?
I don't know in Wisconsin, but generally they are run by the state. I mean, as far as making sure that dietary issues are being met, nutrition, cleaning the houses, record keeping.
Not a lot of effort goes in.
Regulating the heat on the showers, etc. Usually the employees only need a high school education, and then it's up to the outside psychologists and social workers, etc., to do the actual treatment. So
a group home, the way you describe it, sounds like a terrible idea for anyone in any situation.
I agree. And I also worked in developmental disability services, and it was the same issue. The only thing the staff is taught to do is how to give medication. So it's up to the staff to give medication and document that it has been given. They, depending on the level of functioning of the population in the home, it sounds like, if she were allowed to go, she would be asked to participate in preparation of meals, et cetera, and cleaning. And
Sure, so the employees don't have to do it.
as far as treatment goes, there is no treatment from the staff that lives in the group home. It's if they go to a day program, they might get some treatment there.
So my understanding is the group home is one step towards being released, the middle step before being released to society. In society, you're basically sort of on your own with a little bit of maybe like parole type supervision, where you decide everything. You decide if you're getting up and out of bed, if you decide if you're going to make breakfast or you're going to clean the dishes, or the group home is sort of like a little bit tighter
they don't have
situation.
But nobody can make her get out of bed if she doesn't want to.
Yeah.
She can walk out the front door and say, I'm going out for a while, and nobody can stop her. It's those kinds of things.
But then she does have the
from
plan,
my experience.
right? The plan would be in place saying, hey, you can't just run away. Okay, you've got to check in. Your plan might say every time you leave somewhere, you've got to let us know. And
right.
And then if she doesn't follow the plan, then she goes
sleep
back.
at night.
And not all the patients do.
Usually the staff sleeps. They have a bedroom and bathroom separate for the staff, whoever's on, and they sleep during the night.
Yeah.
So if somebody really wanted to leave, they could, and they have. And
that's interesting.
even if the plan and the rules say you can't, it doesn't stop them from doing it.
Samantha, thank you very much for the insight there. I'm curious now.
So that would be it's in Wisconsin, so it would be depending on the state. Oh, I see they're coming back on.
Their judge isn't back yet, so any minute now it'll
Okay.
just you won't be able to hear when it happens.
That's my concern is what will happen in this group home. Everything could go in a hell in a handbasket. That's just what's going through my mind from what I've seen with my own eyes and experienced myself.
Yeah.
And it could wind her up back in either a mental health facility or jail,
I hear you. The argument is, if we don't do this and we just dump them in society saying, okay, you're cured, the shock factor of going from a regimented, someone else controlling your meals and everything from when you shower to when you read your mail, going to just complete freedom can cause a high level of recidivism.
Right.
So
and
you need to give them
the
some
system is
freedom.
the system is far from perfect. So I understand the group home piece as a step down kind of thing, but I don't know if they're allowed to lock. I've never seen a group home that was locked down. I don't think that's allowed.
Are you familiar with group homes specifically that deal with mental illness, or are these more like drug?
Both.
Both.
I'm familiar with group homes with people who have mental illnesses, and then group homes who have people with developmental disabilities.
Samantha, the judge is back. Thank you very much for the call. Appreciate it. Thank you so much.
Thank you.
We'll see you.
Okay. Bye.
I'm curious about the other defendant who was released, 4 years ago? What was her trajectory? I realize every individual is different, but what was her trajectory and what was the process like for her? Now I need to follow the case a little closer. She was on house arrest with her dad. Someone's whispering. Sorry for pushing you off, Samantha. I heard the sound come back and assumed we would be going live immediately. I think that should be a crime to treat your laptop that way and bend the screen that far open. Maybe it actually flips around and it becomes a tablet, but it's no bueno. Hey, Thomas, you're on the air. Do you want to be on or off?
On is fine. I know court's coming back. I have a PSA.
Okay.
I need a criminal defense attorney to contact me ASAP.
What did you do? What did you do?
No. Breaking news in my community on a Texas Court of Appeals overturned a capital murder conviction for a police investigation mess up that a lot of us that know the police knew was coming, but I've got a real big question for possible how they can do something for recall. So I need a criminal defense attorney.
Do they have to be licensed in Texas? I mean, you've got Kurt from Uncivil Law is down there.
He is. I don't have his info, but or even someone who is just really well versed in criminal defense here. I've got one question to ask that I need that a couple attorneys I've talked to aren't really sure, because it'll make or break a retrial on this thing. It's groundbreaking in this town. I'm talking probably a riot tonight that's going to happen because of this appellate news that just came out.
Wow.
So I'm trying to get ahead of it so I can know and understand better what's going on.
You're skipping the podcast and getting a scoop on something huge.
I know, and I need a nap like 4 hours ago, and I'm dying. But so anyone in chat, Mr. Mrs. Uptotoso, there's a few others, and I forget their names off the top of my head.
We've got a few. If there's anybody in chat who can step up and say, let me take a crack at it, who are attorneys. I know we've got a couple listening. Reach out to me on the burner phone. We'll put you in touch with Thomas directly, or put him in touch with you, one of the two, and see if we can get an answer. And then, of course, we want the scoop as soon as it's available.
Yeah, that would be perfect. So anyone that reaches out to you on the burner, you have my permission, give them my information, and we'll get in touch. And then once I have the information I'm seeking in that story, then I will definitely share with the viewers on, I'll do a call-in on a day show since they're all here on your day show and film in. But it's a really big deal, especially here in our community. So
that's awesome. I will do you one favor and screen the calls to make sure not everyone who asks for your number gets it. But other than that, sorry, I didn't mean. Okay, until then, have some honey tea or something and to get some rest. So.
Robitussin makes honey flavor now. It's been great.
Excellent. So, drink that.
I think I'll go have another shot.
All right. Thanks, Thomas. We'll see you.
Bye.
Bye. All right. Let's see. New case info. I'm trying to see what's come in on the phone.
May be seated. Thank you.
We're back.
We're back on the record in the Geyser case, same appearances and case number. We were reviewing the status of Ms. Portman's testimony. Let me ask Attorney Conton what the status of the situation is.
Yes, Judge. I don't know if you want to do a colloquy with Ms. Geyser, but she would orally give her release for Ms. Portman to speak about their therapy.
All right, Ms. Geyser, you understand that Ms. Portman, your contact with Ms. Portman is subject to rules that make it confidential.
Yes, sir.
So if she talks about it here in court, it's not only between Ms. Portman and me and you and the attorneys, but all the people in the courtroom hear it, and it's the proceedings are can be broadcast and can be outstanding.
Yes, sir.
Is Josh available?
So whatever is said will be out in the public domain, as they say. People will know about it. And sometimes confidential information you don't want out. It's between you and the doctor, you and the professional, you and Ms. Portman.
I give my permission, sir.
You do. You understand you could say no.
I do, sir.
And you talked to your attorney about that?
Yes, sir.
Satisfied with Attorney Cotton's advice?
Yes, sir.
Satisfied with him as your attorney?
Yes, sir.
All right, well, that's fine, thank you. I'll then authorize that I'm satisfied then, Ms. Portman, that Ms. Geiser has released you from any rules of confidentiality with regard to your testimony today. You can proceed. So we'll go ahead.
Thank you, Judge. Ms. Portman, I'm just going to ask a few pretty specific questions. And to clarify, you would be considered part of Ms. Geiser's treatment team with Winnebago Mental Health Institution, right?
Yeah.
Okay. As part of the treatment team, were you aware that Ms. Geiser enjoyed reading material that had themes involving sexual sadism?
No.
Is that interest something that has ever been worked on in therapy with Ms. Geiser?
Not with me.
Okay. Was the treatment team aware that Ms. Geiser's interest in reading material that had themes of murder and organ selling on the black market was something that was occurring?
I can't speak to what the treatment team knew.
Okay. Did you know these things?
No.
Okay. So that was never addressing the affinity for these types of themed literature. It was not something that you've addressed with Ms. Geiser in therapy.
No.
So if the conditional release planning team wanted to try to mitigate risk in some way and come to you, you would have no insight in terms of treatment that's been done with Ms. Geiser about those topics.
Correct.
Okay. In terms of this individual, Jeffrey Pickles, were you aware of Ms. Geiser's relationship with him?
I've heard his name mentioned before in therapy.
Okay. Was information relayed to you that Ms. Geiser wanted to be sexually intimate with this person?
No.
Was information relayed to you that this person was sexually aroused by Ms. Geiser's index offense?
No.
Were you aware that Ms. Geiser was sending this individual letters or cards?
Yeah, I want to clarify. I did find out recently since the filing of the petition.
Okay.
But prior, yeah.
Okay, so in terms of in a therapeutic clinical setting, these are not things that would have been addressed between you and Ms. Geiser?
Correct.
Okay. What about, has there been work done between you and Ms. Geiser in terms of her affinity for violent or dark artwork?
Ms. Geiser has shared her artwork with me.
Okay, and are you aware that pieces of art that Ms. Geiser drew were sent to this person, Mr. Pickles?
I've since learned that some of her art was sent out.
Were you ever shown artwork that Ms. Geiser did that depicts a decapitated type figure with blood coming out of the neck area. Does that sound like something that you've ever seen?
No.
Does that type of style or material sound consistent with artwork you've seen that Ms. Geiser has shown you?
No.
Is Ms. Geiser's interest in creating that type of artwork something that you've worked on with her in therapy?
No.
One moment. Those are all the questions I have. Thank you.
All right, thank you. Cross-examination.
Good afternoon, Ms. Portman. How long have you been Ms. Geiser's therapist?
About 1 year.
Okay, and you work inside Winnebago Mental Health Facility, right?
Yes, I do.
And you remember testifying at the conditional release hearing a couple of months ago, right?
Yes.
And as Ms. Geiser's therapist, it's your job to provide her with one-on-one and as well as group therapy. Is that correct?
Yes.
And those are two different types of therapy. Group is with other individuals, and then one-on-one is more of a private experience, right?
Yes.
And do you have any concerns as you sit here today over Morgan's behavior in therapy?
No.
Even now, as you sit here right now today, knowing everything you know, are you concerned at all about Morgan's attitude or behavior in therapy?
No.
What about just in general, speaking about Morgan as a person? Are you somehow now alarmed that there's risk factors now that you were unaware of? Is that how you feel?
No.
Okay. So as I understand it, the judge had ordered a conditional release plan to be put into place, right? You're aware of that after the last hearing?
Yes.
And isn't it true that part of the therapy that you were working on then with Morgan was working with her on that transition to the community?
Yes.
Because that's something that you wanted to have happen for her, right?
Yes.
And in fact, as you sit here today, it's something that you still want to happen for her, right?
Yes.
There's no new red flag that's so alarming to you as a therapist that you think you need more therapy with Morgan at Winnebago, right?
No.
So, and that's knowing this information. The state asked you about Morgan's reading themes. The book we're talking about, this Rent Boy book, you are now aware she read that book, right?
Yes.
Has there ever been a rule of therapy or that she can't read certain material?
No.
Are you aware of is she subject to any such rules that she can't read a particular genre or a particular type of book at Winnebago?
No.
So there's no restrictions, right?
Not that I'm aware of.
And you would agree that you and Morgan have a good relationship, at least you would see it that way, right?
Yes.
And now that is part of the therapy that every time she comes in to meet with you, Morgan talks about the last book she read in the last couple of days, or how do you guys handle her choice of reading material?
If she chooses to share what she's reading, she might share what she's interested in or what she's reading. I don't specifically ask about it.
You've gotten to know her very well over the last year, right?
Yes.
You know that Morgan is a very bright young woman, right?
Yes.
And you know that she's very well read, isn't she?
Yes.
You also know that at Winnebago, there's no internet access that she has, right?
Correct.
So she's not on the internet, on Facebook or any other site, interacting with people who are posting stuff, as far as you know, right?
Yes.
And Ms. Geiser is interested in all sorts of reading material, from historical fiction to current fiction to Catcher in the Rye and Van Gogh and all sorts of things. You're aware of that?
Yes.
Because you guys have talked about that as part of your getting to know each other. One way to get to know someone as a therapist is ask them what they're interested in, right?
Yes.
And that's a normal part of therapy, isn't it? That as a therapist, you try to develop a rapport with the person that you're treating.
Yes.
So if somebody that you're treating is really interested in movies, you might talk to them about movies or things like that, right?
Yes.
And have you ever felt like Morgan withholds information from you in this year that you've treated her? Do you feel like you have to pry information out of her in therapy, or would you describe her as somebody who discloses and reports what she does?
Yes, she discloses and reports. She comes in ready to talk regularly.
And I think it's important to cover this topic, ma'am. After reading this book, Rent Boy, that has these concerning themes, or these gory themes, did you notice a regression in Morgan such that you were alarmed that perhaps she had read something disturbing and was now experiencing trauma in therapy, or no?
I have not seen any regression from her since I've been working with her. I don't know when she read the book.
Okay, so in the year you've been working with her, you've not noticed any regression based on anything she's read. Is that what you're saying?
Yes.
Now, a person named Jeff Pagel, who you said you were aware of because his name has been mentioned in therapy before, right?
Yes.
This is not a current person that Miss Geiser is having contact with, as you understand it, right?
Yes, correct.
His name came up as somebody that she didn't want to have contact with. That's what you recall, isn't it?
Yes.
And it was her bringing up Jeffrey Pagel to you, right?
Yes.
That's how you learn about it in therapy, because Morgan, as the patient, is disclosing something that she's concerned about that she wishes to talk through with you, right?
Yes.
And then you talk through it and figure out whether it's something that requires more discussion or more treatment, right?
Correct.
And have you had ma'am, I don't know if you've had a chance, but have you had a chance to read the petition that was filed to revoke Ms. Geiser's conditional release?
No, I haven't read it.
Okay. And is there anything as you sit here now that causes you to recommend to the court that she needs more institutional therapy?
I don't believe I can make that opinion. I don't, make an opinion on whether or not she's ready to leave or should stay longer.
Okay. Is there a new treatment plan that you think needs to be developed with her because she had some historical contact with Pagel, or because she read this Rent Boy literature?
No.
Nothing.
Correct.
No
That's
further
all.
questions. Yeah. That was the mic drop moment.
Cross-examination.
Thank you, Judge.
All right, I should say this is
Redirect.
right, it's actually redirect, excuse me.
Ms. Portman, I think that you testified that really there was not a lot of discussion about Ms. Geiser's interest in terms of reading material during therapy. True?
Not a lot, just casual conversation about Van Gogh. We talked about Van Gogh quite a bit.
But Ms. Geiser never offered to you, you know, hey, I'm reading this book and right now the characters are selling human organs on the black market. That was not a casual discussion that you had, right?
Correct.
And you've now testified that that's not a concern. You don't believe that that's concerning, right?
Correct.
You're aware that historically, Ms. Geiser has been fixated on fictional characters, right?
Why does it sound like somebody's pouring water?
And the index offense was directly related to a fictional character named Slender Man. You're aware of that, right?
Yes.
And you're aware that in Ms. Geiser's history, she was also fixated on literary characters, right?
This is her
Like Harry
therapist.
Potter books.
Yes.
Fixated on Harry Potter
And
books.
you know that the index offense was, at least for a part of time, reportedly due to adherence of the wishes of those fictional people, right?
You know, I'm not real clear on that remote past. I've really worked with her in the present time. I can speak better to what work she's done in the past year and where she's been at mentally in the past year.
But don't you think that someone with that history, it would be very, very important to monitor what types of fictional characters they are relating to and interested in?
I was more attuned to her mental status, her mental health, how she was presenting, whether she was delusional or psychotic or anxious. We coped with grief and family and relationships in her present environment in the past year.
And you testified that you, for the most part, felt like Ms. Geiser was an accurate reporter with you and appeared stable, right?
Yes.
You're also aware that at a point in time, Ms. Geiser reported that all of the symptomology surrounding her schizophrenia was things she had made up.
I'm sorry, this is so far beyond the scope at this point, Your Honor.
Well, it's beyond the scope of the cross to an extent, but yet we're going into detail on therapy and on contact with Ms. Geiser. So I'll overrule the objection. I think it's necessary to go forward. I find it's within the scope of cross.
Do you need me to restate the question, Ms. Portman?
Please.
You're aware that Ms. Geiser has reported that she feigned symptoms of schizophrenia and never suffered from a mental disease or defect at the time of the index offense.
You guys, no personal attacks.
We talked about that
chat,
in
please.
therapy.
Do you think that it's possible that there's a risk underlying the stability that you see from Ms. Geiser in your therapy with her?
Do I think that there's a risk? Can you restate that?
Sure. Now knowing that Ms. Geiser has an interest in the types of artwork that we've talked about, decapitated figures, and the type of fiction we've talked about, murder and sexual sadism, do you have any concern that the presentation that you're seeing from Ms. Geiser in therapy is not accurately reflecting what's going on?
I don't. I saw somebody who was who I interpreted as being very authentic and processing authentic emotion and thoughts and relating to her environment and bringing that into the therapy session and processing it. I saw, that's what I saw.
Okay, thank you very much for your time, Ms. Portman. That's all I have.
Any recross?
Yes. briefly, is there a rule of therapy that she's supposed to bring up every one of the books that she reads and talk to you about it?
No.
Okay. And you've now had a chance to look into the book Rent Boy, and it's not something that raises any concerns to you as her treatment provider, right?
Right.
That's all.
Any further direct?
No, thank you.
Ms. Previn, what is your educational background?
I'm a licensed clinical social worker. I have a master's degree in social work.
And how long have you been working at Winnebago?
15 years or 14 years. 15 years with the state.
So have you been you said you've been a part of Ms. Geiser's treatment team for the last year?
Yes.
Before that, were you involved in other treatment teams involving other individuals at Winnebago?
Yes. Yes.
How many other individuals have you been involved in as a treatment team member with?
Oh, hundreds and hundreds for 15 years. So.
All right, I have no other questions. Any questions to the witness based upon my questions from the state?
No, thank you.
Attorney Cotton, anything from you?
No.
All right, thank you. And then Ms. Berman, thanks for being here. I appreciate your time. Have a good day.
Thank you. You too.
She gone.
How should we proceed at this point?
Judge, at this time, I don't have any other testimony or evidence on the state's burden for the petition, and I believe I've moved to the only exhibit I marked into evidence, Exhibit 1.
I think you did. We received State's Exhibit 1.
Those were court exhibits, you said, Judge.
Yeah, we have 2 courts exhibits. Are you moving those in?
I would move both reports in.
So I'll receive both. So ordered.
Yeah.
And then, do you want the exhibits, Attorney Cotton?
I was just going to grab them. Yeah.
I'll give them to you. How are you then? The state's resting. How do you wish to proceed?
Call Dr. Ken Robbins. He's waiting on Zoom right now.
All right. Do you want these exhibits?
Yeah. Thank you.
Paging Dr. Robbins. Paging Dr. Robbins.
Thanks, Judge.
Yeah. Excuse me?
I just let him in now.
All right. Dr. Robbins, you're appearing by Zoom. Can you see and hear the court? I cannot hear you, so you're muted.
You're also blurry. Please remove the tape from off your camera. Or wipe the
Can you hear me
Cheetos
now?
from
I
off
can.
off the
I
camera.
can see you and I can hear you. Can you see and
Great.
hear the court?
I can.
All right, very good. Thank you. I'm going to ask you
It's a
to
broken
stand if you
camera
can.
lens.
Raise your right hand. Our clerk will swear you in.
Okay.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And you've testified previously in these hearings concerning Ms. Geiser?
I have.
Thank you. Then Attorney Cotton.
Judge, given your familiarity with this doctor, would you take judicial notice of his qualifications?
I will. I'll take judicial notice of the qualifications for
Just saved us half an
Dr.
hour.
Robbins as well as the other 2 doctors that are to appear if they appear today. So ordered.
Dr. Robbins, good afternoon. Thank you for appearing.
My
Sort of.
pleasure.
You are in receipt of the amended or the petition for revocation of conditional release that was provided to you, right?
Correct.
After that was given to you, did you take any action or take any steps?
I did. So I'm in California, so I couldn't go to Winnebago to see Morgan directly in person, but I did have a remote interview with Morgan, and then I spoke with Dr. Kayla Pope, the medical director of Winnebago.
And what, if anything, did you talk to Kayla? You said Kayla Pope, Dr. Pope is the medical director of Winnebago?
Correct.
Why did you speak with her?
I wanted to know, because I was surprised that the report from Ms. Whitaker suggested that the staff who were working with Morgan weren't aware of what was going on with either the books or with this man who had been contacting her. And that wasn't my understanding, so I wanted to find out what the truth was. So I called Dr. Pope to get more information.
And what did you learn the truth was?
I'm sorry, that one didn't come through clearly.
What did you learn when you spoke with Dr. Pope?
Objection, hearsay.
So Dr.
Well,
Pope told me
it is, if it's offered for the truth of the matter concerned, as I understand the question, so it is hearsay.
It's to show why he did the things he did, why he took the next steps and pursued the opinion that he ended up concluding.
Well, that's true, but then we don't receive it for the truth of the matter asserted. We receive it for what he heard and what he did in response to what he heard.
Right.
All right, I'll receive it on that basis.
And so thank you, Judge. So, Dr. Robbins, you spoke with Dr. Pope, and what did you learn as you spoke with Dr. Pope?
Dr. Pope told me that the staff were well aware of the books that Morgan had read, including the specific book that Ms. Whitaker mentioned. I think it was, Rent Boy. I'm not sure I have that quite right, but something like that. And that they were well aware of this man, Mr. Pagel, who had visited Morgan. So they were aware of all of this and had discussed it, and were not uncomfortable. Did not feel like any of this put Morgan at increased risk of behaving violently.
Did you have an opportunity to speak with Morgan then?
I did.
Was it by Zoom or by phone?
It was by phone. I'm in a very rural part of California, and Zoom wasn't. I couldn't access Zoom.
And based on your discussions with Ms. Geiser, do you, in your knowledge of what she has read, do you have an opinion about her suitability for conditional release?
Yes, so I was aware of some of the books. I wasn't aware of this particular book, but after talking with Morgan and after doing some search myself about this book and speaking with Dr. Pope, it doesn't change my opinion about her suitability for conditional release.
Why not? Should the court be alarmed that she read a particularly gory book? Does that make her more susceptible to violence, for example?
So I went through, I was sent a list by Morgan and by you as well of the books that Morgan has read over the last year, and the vast majority are not violent books. She's, she reads a wide range, mostly of sort of classic literature. And when I myself looked up this book, Rent Boy, what it was described on the internet was that it was I wrote this down because I wasn't sure I'd remember it. It described it as a hysterical romp through the worlds of contemporary culture and crime. It doesn't advertise it as a particularly gory or particularly sexual. It describes it as a comic book, that it's focused on comedy. I don't mean comic book. And I guess I didn't find the description to be alarming. And when I spoke with Morgan, she was very clear that that's not what attracted her to this, not the sex, not the violence. She just found it an interesting discussion of culture and comedy. So no, I think she reads a wide range of books because she has a wide range of interests, and she has such limited access to entertainment that I can imagine she wants to experience a wide range of books and try to understand what's happening in the culture. So no, there was nothing about this that made it sound to me like Morgan is focusing on gore or violence, or that anything about what she's been doing would put her at increased risk for violence.
Thank you. When you read through the list of books that she's read over the last year, some of those books include, for example, she reads the Bible every day. Did you become aware of that?
I did.
And certainly there's violent themes even in the Bible, aren't there?
There are.
She's read the Catcher in the Rye, for example, right?
Correct.
Books about the Vietnam War and about Vincent van Gogh, memoirs about other people, right? So it's a whole wide array, as you said, of books. Isn't that true?
It is a wide array with all different topics, and certainly going through that list doesn't suggest that she's focusing on books about crime or violence.
As you used to be the medical director of the Mendota Mental Health Hospital, weren't you?
That's true.
Isn't it important that, and isn't Winnebago sort of the sister institution? We only have two institutions, Winnebago and Mendota, right?
That's correct.
And does an individual in the institution have any control over the books that people send into them? Do these institutions restrict books from coming in?
Well, to some extent they do. They look to see what the books are. They inspect what comes in to see if they believe it's suitable. So yes, they do play some role.
Okay, so it'd be fair to say anything that Morgan reads is something that came through, as far as you know, the proper channels to be sent into Winnebago, and she would read it inside the institution, right?
Objection, foundation for this witness to know that fact.
Sustained.
When you learned about the various books that she read and thought about the conclusions you had offered previously, do you have a different opinion today, or do you think that Ms. Geiser should continue to be released under conditional release?
My opinion hasn't changed. I continue to believe that Ms. Geiser should be released under conditional release.
And knowing what you know about her having contact in person in June of 2023 with Jeffrey Pagel and some of the other information that was contained about him, does that change your opinion?
So I think Morgan is going to unfortunately have to deal with people who are attracted to her because of her criminal history. And I think this is one example, but I think she became aware that that's what he was doing. And she herself recognized that she should be shielded from meeting with someone who had that motivation. And she asked that something be done to prevent him from being able to see her back in June of 2024. And that has continued.
Was that an inappropriate way for Ms. Geiser to address it?
I think that was a perfect way for her to address it.
That's all. Those are all my questions. Thank you.
All right. Thank you. Cross-examination.
Dr. Robbins, I guess I'm a little bit confused by something that you said in response to Attorney Cotton's question. Is Dr. Pope someone that would be considered to be part of Ms. Geiser's treatment team that sits in on her treatment?
So she has been. She was her psychiatrist for quite a long time, and she has continued. She oversees all the clinical care at the institution. So she apparently has sat in on some of the clinical team meetings.
And you indicated that when you spoke to her, that she indicated the information that was filed with the court was just all incorrect about what the treatment team knew.
What she told me was that so there was apparently a social worker who sat in on the interview that Ms. Whitaker had with Morgan. And Ms. Whitaker asked this particular social worker some questions about what the team knew, and that they had not anticipated that there was going to be this kind of give and take. And the social worker was a relatively new social worker and was not knowledgeable about what the team knew and didn't know. And so she had a hard time answering the questions.
And that's what you recall Dr. Pope telling you?
Yes.
Usually on Zoom, we blur our backgrounds.
Sir, Ms. Whitaker testified today, and she said that she never confirmed with anyone in Morgan's treatment team about these things. That was done by a DHS representative. Does that sound familiar at all?
Yeah, I don't know. I guess all I know is that whoever the representative spoke with, apparently, according to Dr. Pope at least, wasn't as knowledgeable as would have been ideal.
Well, the court also just heard from Ms. Geiser's therapist, who agreed with all of the lack of information that's cited in the report that was filed. She agreed that these are things that the treatment team was unaware of and that hadn't been worked on in treatment.
Yeah, I can only tell you what Dr. Pope told me.
You'd agree with me that it seems like we've got a lot of conflicting information right now for the court, though.
Yeah, that may be true. I don't know that.
Okay. You'd agree with me that historically, Ms. Geiser has had issues becoming fixated on fictional characters.
Yes, in the distant past, that was true.
And so fixated that it led to the index offense.
Yes, I believe that's true.
So don't you think it would be really, really important for someone who's trying to assess risk to the community to know all about what kind of fiction characters Ms. Geiser's interested in?
So believing that fictional characters are real is very different from wanting to know what books she's reading. Yes, I think it would be important to know if she thinks there are current fictional characters that are real, if that's true today. But I don't know that it's critical that they're aware of every book that she reads.
Do you think that the treatment team at Winnebago Mental Health should know that Ms. Geiser enjoys reading about the sale of human organs on the black market?
I'm sorry, that completely misstates the record. She read a book to say that to make it broad and to suggest to the doctor that she is interested broadly in the concept is far different than reading one book, Your Honor.
Well, this is cross-examination, so I'm going to overrule the objection.
Do you mind repeating that question?
Do you think it would be important for Ms. Geiser's treatment team at Winnebago Mental Health to know that she enjoys reading material with topics about trading human organs on the black market?
So certainly if that were true, I think it would be important for them to know. I don't see evidence that that's true.
Do you think it would be important for Ms. Geiser's treatment team at Winnebago to know that she enjoys reading materials surrounded on themes of murder?
I guess I'd say the same thing. If it were true, I would agree that that would be an important thing to be aware of, but I don't see evidence that that's true.
Have you ever seen evidence that Ms. Geiser enjoys creating artwork that is
deviant? What do you even say?
Depicting decapitated figures?
Yeah, that's rather specific.
I'm not aware that she enjoys artwork depicting decapitated figures.
Are you aware that Ms. Geiser created such artwork and sent it to someone outside of the facility?
So I am aware that she sent some gory pictures to the man that we talked about. Again, I don't know how much enjoyment she truly got from that. I think some of that was influenced by what he asked her to do.
Do you think it would be important for Ms. Geiser's treatment team to know that she's engaging in creating gory artwork?
I guess if that were a consistent thing and that's what she was focusing on, yes, I think that would be important to know about.
Are you aware that Ms. Geiser was creating dark-themed artwork around the time of the index offense?
I am aware of that.
Do the similarities in these themes not cause you any pause?
If I believed that she was in a similar emotional state, if I believed she got similar reinforcement by doing it, yes, I would be concerned. I don't believe that to be the case, however.
Thank you. That's all I have.
Any further direct?
Yes. Why don't you believe that to be the case?
Based on both talking to Dr. Pope and talking to Morgan herself, she was very clear that she doesn't take pleasure in gore or in violence, that she's trying to experience a full range of what's going on in the universe, and including what's going on in culture. And certainly there's a lot of violence in our culture, and I think that's part of what she's trying to understand and make sense of. But do I think that she takes particular pleasure in violence or in gore? No, I don't see evidence to suggest that.
And you've studied hundreds, if not thousands, of pages of historical records in this case, right?
I have.
And in fact, one thing you examined and read is Dr. Lundbaum's report that she authored in support of conditional release. Do you remember that?
I do.
And in fact, Morgan's artwork was specifically mentioned in that report, wasn't it?
It was.
The fact that Morgan even said, I used my art as a way not to self-harm. I put everything bad in me out in my art and writing so I don't do that. It's a way to cope with my trauma. You remember reading that?
I do.
That's a healthy thing, isn't that?
I think it's a healthy thing. I think Morgan has had very limited ways of expressing herself, of experiencing culture for the last 11 years while she's been institutionalized. And I guess I'm not surprised that part of what she has done is read books about crime and culture and drawn artwork involving crime, culture, and violence. I don't think that suggests that she's about to become violent.
Right. The state introduced, just so you know, Dr. Robbins, today, the state introduced one photo, one drawing that Morgan did of some sort. Can we show this exhibit to the witness, Your Honor?
Hold it up to your
Exhibit
screen.
1. Okay. She drew one drawing with what appears to be not even a person, but some sort of thing with its head cut off, okay? One drawing they've introduced.
A human ant.
Does that give you any cause for alarm that she did one drawing like that?
It does not.
And when Ms. Geiser, and this is something you've known, even before you authored your original conditional release report, you knew about her artwork, didn't you?
I did.
Because she said and Morgan has said that her artwork, sometimes it's dark, right?
She does.
And she's in trauma therapy. That's part of her therapy, isn't it?
It is, and she's around, many perpetrators, many people who've committed crimes. That's really her social group, and that's what she's hearing about.
Right. What's important is whether there's any indication. Would it be important to talk to Ms. Geiser's therapist at Winnebago and hear the therapist's opinions? Would those matter, do you believe?
Yes, I think that would matter.
And if the therapist testified that she sees no additional need to continue providing any new therapy at Winnebago as a result of this. She's not concerned about it in the least. Okay?
Okay.
Does that surprise you, or do you differ in that opinion?
I don't differ, and it's consistent with what Dr. Pope said to me.
Thank you.
Any further cross?
No, thank you.
All right. Well, doctor, thank you for being available today. You have a good day.
Thank you. You as well.
Have a good afternoon.
Thank you.
Thank you.
Further witnesses?
Defense rest.
How about Dr. Collins? Is she here?
I think you have both of the doctors available by Zoom if you care to
Okay,
hear from
but
them.
the defense rests.
Yes.
Okay. Well, I'd like to hear from the other two doctors.
Okay.
So both sides
So
rest.
I'll call
The
Dr.
judge calls a witness.
Collins as a court witness. Dr. Collins, you're appearing by Zoom?
Yes.
I can see you and hear you. Can you see and hear the court?
Yes.
All right. I'm going to ask you to stand and raise your right hand, and our clerk will swear you in.
Raise your right hand, please. Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Please be seated. State your full name and spell your last name.
Deborah Collins, DeborahCollins.
All right, thank you. Okay, who wishes to ask questions of Dr. Collins initially?
I think procedurally it should be the court. You chose to call her and the parties have rested.
Well, I'd like one of the attorneys to do it.
Judge?
Is there an objection to the court asking the questions from the state?
No.
All right. Objection from the defense?
No.
All right. Dr. Collins, you're familiar with Morgan Geyser?
Yes.
And you wrote a report previously that was dated December 9, 2024 with regard to her conditional release.
Yes.
You're aware of the petition that was filed to revoke the conditional release order of the court?
Yes.
You've been part of the court proceeding that you've heard the other witnesses who testified?
Yes.
Do you have an opinion as to the risk involved, the dangers involved with what's been disclosed in the petition for revocation of the conditional release that affects the court's decision on conditional release?
While I certainly recognize conflicting information that's been presented to the court and contained in the petition for revocation, it doesn't cause me to undo the analysis or opinion set forth in my report.
Okay, why is that?
Because in large part, the information that's been provided isn't new. It's been known. The reading material that Ms. Geyser has access to or seeks out is known at Winnebago. Now, whether or not someone reads the books that Ms. Geyser reads is unknown. But there's nothing about what I've learned since knowing that the state was attempting to revoke Ms. Geyser's petition that would suggest to me that she now suddenly poses a significant risk of bodily harm to herself, others, or serious property damage if conditionally released, with all the supports, accountability, supervision that entails.
All right, thank you. Any questions for Dr. Collins from the state?
Dr. Collins, was there information that you heard that causes you concerns today or in the report you reviewed?
Certainly at first blush, hearing that someone the accusation that someone is obsessed with gore gives one pause. When I explored that with Ms. Geyser, when I met with her for a follow-up interview virtually on Monday, when I talked to her social worker, when I look at the records that I have and hear the testimony, I don't see that to be true. I don't find it to be credible, given what others close to Ms. Geyser, who have known her best during the past year, how they describe her or characterize her in the clinical records.
Have you requested additional records from Winnebago since you last did a review of records for Ms. Geyser?
Yes, I did. My office requested earlier this week her available clinical records that have accrued since I met with her in November to the present. I've not received those records.
Okay. Have you had the opportunity to speak with Dr. Pope, for example, from Winnebago at all?
I did not speak with Dr. Pope, though I did conduct a collateral interview with Ms. Geyser's current social worker, also via video conference.
Did that interview offer any insight into kind of what has become this question of what was known and unknown to the treatment team?
What I learned is that the petition for revocation, the best I could gather, took the treatment team by surprise. That they had wished that some of the concerns that the half-hour weekly virtual meetings with Ms. Geiser in anticipation of conditional release had generated had been brought back to Ms. Geiser so that she could explain or put context on things that had come up. But I learned that it's largely a surprise to staff, as best I could tell. Ms. Geiser herself mentioned that I think she had witnessed at least 4 Winnebago Mental Health Institute staff members become tearful about learning about the revocation of her petition and the curtailing of her rights and privileges currently because of it at Winnebago.
In terms of specifically, and you testified that you have been able to hear the hearing that's been going on all afternoon, is that true?
Yes.
Okay. There seems to be some conflict between the testimony Dr. Robbins offered and the testimony that was offered by Lisa Portman in terms of the treatment team's awareness of some of these risk factors. If you'll recall, Dr. Robbins testified, well, Dr. Pope said the treatment team was aware of all of these things listed in the petition, whereas Ms. Lisa Portman testified, no, I'm her therapist. I wasn't aware of that. We didn't work on that. Did your discussion with that member of the treatment team clarify any of those issues?
No, and I frankly can't. I simply am befuddled by the apparent differences or the clear differences in the testimony offered. I just don't know the answer.
Okay. Thank you. That's all I have, Doctor.
Attorney Conton, any questions?
So you've not changed your conclusions from your report filed December 30th, right, Dr. Collins?
No, the information that I've learned has not caused me to alter either the analysis or conclusions in that report, although I would acknowledge the practical problem that the court now faces, or challenge the court now faces.
Right, the practical problem being that the treatment team, rather than go to Morgan and work on this for a bit of time and get her side of it, is immediately sought revocation, and that's what you're referring to.
In part, that's what I'm referring to. The other part is that now, at least as presently stands, pending the outcome of the court's decisions, that the treatment team moving forward, if Ms. Geiser is granted conditional release, has expressed concerns about how they would do that safely. That, however, doesn't cause me to change the data that I have, doesn't cause me to change my opinion about her amenability for conditional release, her accessibility to supervision and accountability, her expressed willingness to comply with any and all terms, albeit with some emotional upset as she learns that moving forward she'll have less liberty than she, at least initially, than she does in the institution.
And you touched on that too, Dr. Collins. She actually, Morgan, it sounds like, has suffered some consequences now at the institution for this. Is that right?
Yes.
Even though she didn't do anything wrong.
Correct.
Didn't break a rule, didn't do anything wrong, but she's now had some of her privileges rescinded because they're seeking revocation. Is that right?
I think most of them are now all on hold.
And it moved at least 4 people to tears, the idea that she wouldn't be allowed to be released potentially.
According to Ms. Geiser.
Okay, that's all.
Any further questions from the state?
Just very narrowly, Doctor, you mentioned that overall your opinion about Ms. Geiser's willingness to comply with the terms of release hasn't changed. And I just wanted to ask you about the testimony that you heard from Ms. Whitaker in terms of there seemed to be some pretty extreme pushback of the idea that the conditional release team would be monitoring Ms. Geiser's reading material. Is that something that you discussed with Ms. Geiser at all?
Yes.
And did there appear to be more willingness to comply with that rule, that reality, that is going to be part of the monitoring?
Yes, what Ms. Geiser said is that while she did express dismay, upset, was tearful when she learned that for the first time in 11 years, her access to reading material, choices about what she read could be curtailed, she said that while she was upset, she never said she wouldn't comply with that.
Okay, thank you. Those are all the questions I had.
Attorney Cotton, anything further?
No.
All right, thank you. And Dr. Collins, thank you for being available today.
Okay, Judge, are you going to call another one?
So I have no further questions for you. Thank you.
Mrs. already made biscuits, and she's supposed to be bringing me one.
Then is Dr. Lundholm still available?
She's still on.
All right.
Oh. It's beautiful.
Dr. Lundholm, are you able to see and hear the court?
I can.
Okay, well, I can see and hear you. I'm going to ask you to stand, raise your right hand, and I'll ask our clerk to swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Now, you're familiar with Morgan Geiser?
Hey, no blurry background.
Yes.
You've written other reports concerning her situation, true?
Correct.
Your most recent report is a report that was dated December 30, 2024, true?
True.
Are you aware of the petition that was filed for revocation of the conditional release order that the court granted previously?
Yes, both the amended and then the original.
All right, thank you. Now, you've been connected by Zoom to the hearing this afternoon.
Correct.
So you've heard the testimony of the various witnesses that have occurred.
I have.
Have you had contact with Ms. Geiser with regard to the issues today?
I did. I had an opportunity to speak to Ms. Geiser via Zoom Pro video conferencing that took place on, I believe it was Tuesday of this week.
All right, thank you. In the report, you recall what your conclusion was in your report from December 30 of 2024?
Did she say Zoom Pro?
I do.
Like a flex?
What was that?
I offered support for her petition for conditional release, specifically that I did not believe that she posed a significant risk of bodily harm to self, others, or to property.
Is what you've read in the petition for revocation of the conditional release and from the various witnesses who testified today, has that opinion changed?
I would say that with the conversation that I had with Ms. Geiser, in addition to the testimony here today, as well as I did have the opportunity to review her contemporary institutional records, as well as had collateral contacts with a variety of different folks, both through the Winnebago Mental Health Institute, as well as through Department of Health Services and Wisconsin Community Services. After reviewing the entirety of the available data, my opinion has not changed.
So from what you've said, then you've seen Winnebago records with regard to Ms. Geiser that were developed after your initial meetings with her in 2024 up through most recently.
Correct. I had asked for and received her institutional records that have been generated since December of 2024, which is my last contact with her.
All right. Thank you. Okay, I have no other questions. State have questions?
Dr. Lundbaum, you indicated that you were able to review the updated Winnebago mental health records. You also indicated you spoke with some staff at Winnebago. Would that be people from Ms. Geiser's treatment team?
So I had the opportunity to speak to her current social worker, as well as I had the opportunity to speak to administrative staff, both the Winnebago director
Jesse Andrews, as well as the Deputy Director, Maria Kunin.
I guess I have some similar questions for you as I did for Dr. Collins, just given that there's some disparity in the information that's been presented to the court. Do you have any clarity in terms of whether the treatment team for Ms. Geiser knew about these topics of information or was unaware about these topics of information that are listed in the petition to revoke? Because the court's heard kind of two different things today, and I'm just wondering if you have any insight into that based on your discussions with the director.
So as I understand it, the people working with Ms. Geiser on a day-to-day basis in general were aware that she has read horror theme books over time, maybe not necessarily specifically the book that has come up during the course of the conditional release planning process and the ins and outs of what that book entailed. But they have expressed some familiarity with the fact that she's read different kinds of horror theme books over the course of several years. The information that I had also suggests that they were generally aware of the relationship with that particular individual. It obviously has been discussed in my previous evaluations to the court and have raised concerns about not just him, but other people that place potentially Ms. Geiser in and of herself at a higher risk for exploitation or manipulation. And I have specifically recommended that the people working with her remain in close attention to those particular folks, and it warrants ongoing consideration and monitoring to ensure that she's essentially not preyed upon.
Is there a difference between the staff that are with, attending to Ms. Geiser on a daily or semi-daily basis versus what has been referred to today as her treatment team at Winnebago?
So there are treatment professionals that would include her psychiatrist, social worker, Ms. Portman, who we heard from here today. There's also line staff that work with her on the day-to-day that aren't necessarily a part of that treatment team, but they do work with her closely. Then there's administrative staff. And I will be honest, I did not speak to them in particular about her adjustment, but rather I had questions about essentially policies and procedures at Winnebago and wanted some clarity from some of the questions that these allegations brought forward.
Those are all the questions I have. Thank you.
All right. Thank you. Questions from Attorney Cotton? All right. Thank you. Dr. Lundbaum, I have no further questions for you.
All right.
Thank you for appearing today and being available. You have a good day.
Thank you.
All right. Thank you. Does the state have any other witnesses or evidence to offer?
No, thank you, Judge.
Does the defense have any other witnesses or evidence to offer?
No.
All right, then all evidence is closed. Then I'll hear arguments.
Thank you, Judge. The state obviously bears the burden here today. We are in support of the petition that was filed to revoke conditional release at this time, pursuant to Wisconsin statute section 971.17, subsection 3, subsection E. As we discussed at the last hearing, this court needs to consider, in this case specifically, because there's not been a plan created yet, there's no conditional release rules that Ms. Geiser could have violated already. And so when looking at the statute, sub 3, sub C, the authority under which the department has filed this petition,
this would be reversing the judge's decision.
Sorry, give me one moment.
So you've got to have enough evidence to say, yes, I'm going to overturn that previous decision. I'm not I'm not as convinced. I think he might allow it to stand.
The authority under which the department filed the petition is not specific to a rule violation. It's the other piece of the clause of that sentence. If the Department of Health Services alleges that a released person has violated any condition or rule, or that the safety of the person or others requires that conditional release be revoked, and then it continues on. They may be taken into custody, file a petition showing probable cause, and a petition to revoke. So the piece of this statute that we're operating under is that the safety of the person or others requires that conditional release be revoked. That's the basis under which the department filed the petition. That's the basis under which the state is asking you to revoke conditional release today. I'm relying primarily on the petition, but also on the testimony that was offered today. I think that there are unknown risks, as was indicated by Ms. Martinez, that cannot adequately be prepared for. And when you have the units that are tasked with supervising these individuals telling you they don't feel that they can adequately supervise this person, that must give the court pause. And then I think you need to dive into why those entities are saying these things. And frankly, Judge, the similarities between the concerning items detailed in the petition and testified about today and entered into evidence are very, very concerning to the state because of the similarities to the index offense. The issue of the fiction material that Ms. Geiser chooses to be reading on its face in some cases may not be an issue at all, but the problem the department sees with it here is that she wasn't completely forthcoming about it, and this affinity toward this type of material wasn't something that had been addressed with the treatment team in a way that they could rely on that treatment team to adequately assess the risk and create a plan that addressed it. Similarly, this artwork that I submit to the court, no one was aware that Ms. Geiser had an affinity for, that I've entered into evidence, is extremely concerning, not only given its graphic nature, but given what we know about the index offense and what was occurring around the index offense. The state has real concerns that these things are just, frankly, red flags at this point, and that more time is needed for these issues to be addressed in Winnebago with the treatment team, so that when conditional release is appropriate, the team can prepare a plan that will adequately protect the community. And so that's why I'm in support of the petition, and that's why we're asking that you grant the petition to revoke conditional release. And that's all the argument that I have. Thank you.
All right, thank you. Appreciate the statements. And I'll turn to Attorney Cotton.
You know, Judge, we were here in January 9th of 2025, and I remember it like it was yesterday because we had the same three doctors testify, Doctors Lundbaum, Collins, and Robbins, which the state, for some reason, doesn't mention whatsoever today. And all three of those doctors testified that Ms. Geiser fits the criteria for somebody as a person who should be conditionally released. And what I heard the court order was within 60 days that a conditional release plan would be presented to this court so that you could review it and make some decisions about what is or isn't appropriate in terms of a group home, electronic monitoring, no contact orders, and other such provisions. And we're almost 60 days out from that. What DHS did in response to your order was to serve the court with a petition to revoke conditional release. That's how they chose to handle it. They didn't talk to any of the three doctors who just testified today that none of this changes their analysis. They jumped the ship. They jumped the gun. They went right to revocation. Why did they do that? One can only guess. What they should have done is what you ordered. They should have given you the plan for her release, and we should be here right now talking about that. We should have been here on Monday talking about that. There's no scenario where the state has met its burden to prove that Ms. Geiser, who has violated no rule at all, or done anything other than answer the questions that are posed of her, that now she sits here today more dangerous than she was back in January when we were here, Your Honor.
Yeah, but we knew no
The reason
more
you
than we
appoint
did in
doctors,
January.
Doctors Lundbaum, and these aren't any doctors that we've chosen in this case, Your Honor. These are people with extended familiarity with Ms. Geiser, people who have worked with her, unlike the people we just heard from today who meet her now. For the Ms. Martinez, who never met her, and comes in here and says she should be revoked. These doctors have known Ms. Geiser for years. They've evaluated her, they've watched her progress, they've seen how she's progressed, they've seen the strides that she's taken. All of them, after years, support her release into the community and continue to do so even in the face of these two things, which I agree with Dr. Collins, Your Honor. On first blush, you look at it and maybe you think, well, is there something to be concerned about here? I'm glad when we were here a few days ago that you did exactly what you did and you said, I want the doctors to review the amended petition and offer their opinions. I didn't even know, frankly, what Dr. Collins or Lundbaum would say. But I wasn't particularly surprised to hear that it doesn't change their analysis, because even Ms. Geiser's therapist, who the state called, they called her therapist, Lisa Portman, even Ms. Portman doesn't see any reason here to continue keeping Morgan in custody to work through anything else. The time has passed for the plan to be brought to this court. We have a narrow a situation here where that ought to have been done already, frankly. Morgan is not more dangerous today. She has not done anything other than work with the release planning group on her release. That's the only thing that she's done, is answer every question asked of her. She didn't secretly read something she wasn't supposed to. She didn't lie about something she read. She didn't lie about contacts with people in the community. And it's almost a perverted situation where she's being punished for her answering the questions that are asked of her. Now she has less liberty. Now she's brought back for a revocation hearing. And the same arguments that are being made by the state about unknown variables. That's what they told you back in January, and you rejected that. There's always unknown variables. This was the central argument that's been made. We don't know if Morgan's released what the future will look like. You addressed that squarely back in January, and what you said, Judge, was that that's true. There's unknown variables in this world, but that's why the plan gets presented to you, and you evaluate it, and you decide whether that plan is appropriate. There is a group home, as I understand it, it's been testified to today, that is ready to accept Morgan. This is wrong, what they are doing. This is wrong, what DHS has done. It's not right. There's not anything that Morgan did. She wasn't violent. She didn't self-harm. She didn't lie about anything. And to, really rake her through the mud in these proceedings and bring up the fact that somebody who's been in for 11 years, who's never had any restriction on her reading material, that somehow because she cried when confronted with the fact that it was going to be reviewed, that's somehow a red flag. Really, all of this is just sort of a hit job against her, and an unfair one at that, Your Honor. I think you should rely on the three doctors. I think that's what this comes down to. Three clinical experts who have years of history with Morgan, who have reviewed hundreds and thousands and thousands of pages of records, that know her history, that know the offense, that understand the dynamic that happened back when Morgan was 11 and 12, that understand the trauma that she endured as a child. Those people coming here today and telling you nothing is different now. She is not, our opinions are unchanged. That's all you need. And I would hope that you order them to get the plan here. I wouldn't say within 60 days. Frankly, they've had enough time to get the plan together. It ought to be here before you leave the bench. Thank you.
All right.
Whoa, he says file it.
Then any rebuttal argument from the state?
No, thank you, Judge.
All right, thank you. Well, it's important, as Attorney Nicolai pointed out, to look to the statute to begin with. That's what sets the really the parameters and the environment of what the court's rulings are today. So in Section 971.17 addresses
rule from the bench.
The not guilty by reason of mental disease or defect pleas and how they're handled. The court initially found, based upon a stipulation of the parties to the various reports that were filed, that Ms. Geiser was not guilty by reason of mental disease or defect, and then I entered a commitment order for a long period of time. I think it's 40 years. During that period of commitment, however, Ms. Geiser and other people in her position have a right to ask for a conditional release every 6 months. It happens all of the time. She didn't ask for a conditional release for a period of time, but she's asked for several. 2 were denied, and now the court granted the third one. So that's what brings us here today. The conditional release, at least to those who are neophytes in the area and inexperienced in what all of this means, it sounds like, oh, she's out on the street and she's out on her way. That's not what it is. There's substantial supervision placed over the person on supervised release, as was testified today. Supervised release that is in many ways more strict from the rules and restrictions on the person than it would be when she was at the institution from the standpoint of freedom within the confines of the institution. So that's what we're talking about now. What happens? I'd authorize conditional release and ask the state to prepare, or the institution, the department, to prepare a plan for release, which would go in to set the stage for the parameters of rules, regulations, and where she would live and how it would be, how she should conduct herself. So what the rule says then, going to section 971.17, sub 3, sub E, in pertinent part. Now, I should also add that at the last time we were in court, the court did an analysis of the status of the case and the procedural status of the case. And that was on February 28th. So at that point, I determined, from my view of the statutes, is that the classic petition for release, or rather the classic petition to revoke a conditional release order, is done after the person's been on conditional release and the plan is in place. And we've talked about that for rule violations. In this case, the statute also provides for the state to bring, or the institution to bring, a claim for revocation of conditional release based upon safety issues. So what the statute says in the sub E, in pertinent part, if the Department of Health Services alleges that a released person has violated any condition or rule, or that the safety of the person or others requires a conditional release to be revoked, he or she may be taken into custody under the rules of the department. The department shall submit a statement showing probable cause of the detention and a petition to revoke the order for a conditional release to the committing court. That's where we are today. Now, what's important to note yet, that the final conditional release document hasn't been signed or approved. That's the plan. Right before the plan, I ruled, and at the February 28th hearing, that although it doesn't quite fit with the classic position, it's something that the court should consider. The safety issue is so important to the court and to the community that the court decided to hear the case and hear the petition. Attorney Cotton alleged that because the very technical routing of the case had not occurred, that the court shouldn't even consider the petition. So then the statute goes on. The court shall hear the petition within 30 days unless the hearing or timeline is waived by the detained person. The state has the burden of proving by clear and convincing evidence that any rule or condition of release has been violated, or that the safety of the person or others requires that conditional release be revoked. So we're really at that safety provision, that last clause, that the state proved by clear and convincing evidence that the safety of the person or others requires the conditional release then be revoked. That's where we are today. Now, today, I heard testimony from a number of individuals, from the individuals who were involved in submitting the petition to the court with regard to the various allegations. court heard from the therapist that has dealt with Miss Geiser for last year, but herself has had worked at Winnebago for 15 years, and I think she said she's had hundreds of people that she's been a therapist for. So she's experienced. What's important, and when any of these individuals testify, is that they not do it out of they testify not out of a book or some formula that they read, but they actually have experience in addressing these particular issues and how the court should address it and how society should look at what's happening. So I'm satisfied that with Ms. Portman's testimony, that she testified as an experienced therapist addressing the needs of the public and the needs of certainly of Ms. Geiser, and what the institution's reaction to the allegations in the petition were. I'm satisfied from what Ms. Portman testified to that there was no reason to stop the process on conditional release and to go forward with the conditional release program and to have the plan developed. What I looked for in the testimony was, did Ms. Geiser lie? Was there subterfuge? Was there manipulation? Was there game playing? People we're always told that Ms. Geiser is smart and intelligent. Intelligent people have the ability to game play, to play the system, if you will. Even in tense situations, they understand how to proceed. And they know they have developed techniques and strategies to manipulate those people that supervise them and watch them. Now, none of that came out today, that any of those circumstances exist. So I'm satisfied Ms. Geiser's communication with people in the institution and who she talked to about the conditional release team to was truthful and accurate. She reacted to questions that she was asked. I saw no hidden agenda on her part, no lying, no misrepresentation. That's important from the court standpoint. With regard to much has been said about books, the nature of the book, no one testified about what the book was really like except for Dr. Robbins. I was somewhat taken aback when he said it was a humorous book. I don't know whether it is or not. I'm assuming people on the supervised release team had looked at it and knew what it was. But he basically put the book in context. Nobody challenged that context. With regard to the contact with Mr. Pagel, which is a matter to be concerned with, first and foremost, nobody disagrees that based upon the nature of the case, the nature of Ms. Geiser's involvement in the case, that she's going to be subject to, if you will, public scrutiny, the public notoriety, public curiosity. And there are people out there who obsess over cases such as this. I don't know whether Mr. Pagel necessarily is that, but there are people out there that will take advantage of the system for their own purposes. There is nothing in the information that we have brought forward that when Ms. Geiser developed a sense of what the person was really about, she stopped contact. There's nothing in the record that shows that she did anything to encourage the person beyond sending him some pictures and doing things like that, which she probably shouldn't have done. But I don't see that in and of itself as a reason to find that she's at risk for herself or at risk to harm the community in a conditional release plan. We can't stop other people from contacting her, from doing things that they shouldn't do. But what we can do is regulate and monitor Ms. Geiser so she doesn't encourage that. Now, there's nobody testified today that she encouraged any of this stuff. Now, she was participating, she communicated with him, she saw him, but that doesn't mean that she encouraged it or did anything to place her in an unsafe position. Now, I have to rely upon what's testified to. I don't have other information. I can make assumptions and draw inferences, but I need a basis to draw inferences. I don't see anything out there to draw any inferences that other than what's been presented. The picture is clear, it's transparent. I don't see the risk to the public. I don't see the risk to her in what other people do.
Here it is.
Now, there's another twist to that, of course. If there was evidence that she called Mr. Pagel or communicated with him and said, come on, sneak in, get this stuff in, and we're going to get together. That's a different story. The postcard that talked about the intimate contact was, I can't comment on it other than the court recognizes, as one of the witnesses talked about, that what happens when somebody's in their 20s and they have sexual interests. But I don't see that the sexual interest went beyond just that, and it was stopped by Ms. Geiser. What do I do with that? I'm reminded of a TV commercial years ago that had a little lady going up to a hamburger counter and saying, "Where's the beef?"
No, that's
you know, we can laugh and smile about that, but that there has to be substance to it. Supposition, accusation has to be followed by proof that convinces the court, according to the statute, by clear and convincing evidence that she's a safety risk, a risk to herself or the risk to the public or to property. I don't see that in any of the testimony that's been offered in support of the petition to revoke. I'm satisfied that, as terrible as the facts of this case are that brought Ms. Geiser in the court, I'm satisfied that under the statutes, she's followed the statutes. People may not like the fact that the conditional release is available, but it's there. And if somebody meets the statutory criteria, then conditional release is appropriate. The court followed the statute. Did it initially on January 9th. It does so again today. I look for the proof. Proof is in the pudding, and these other little cliches one can talk about. But that's what the court has to look to. I see no lying, no subterfuge. I see no risks brought forward. Everything seems to be in order. Ms. Geiser appears to be rule-abiding. If somebody tells her not to do something, it appears from the testimony throughout the entire case, including at the hearing in January, that she follows the rules. Now, that's good. That's what we want people to do. People don't always like the rules that they are told to follow. Sometimes people get upset and they yell about it and they scream. They may cry, but they still follow the rules. It's when people don't follow the rules and they lie about it and then they go and sneak behind your back and do something different. That's where the concern is. I don't see that in this case. It hasn't been established. So I'm satisfied that the state has not met its burden by clear and convincing evidence to show that Ms. Geiser is a risk of safety to herself, danger to herself, or danger to others, or danger to property. On that basis, I'll deny the petition to revoke the conditional release. I will dismiss it so ordered. Now, I'm going to order that the conditional release plan be filed. The question is, when can it be filed?
They should have it.
Now,
there's certain.
I should be the judge that hears it because of all the anecdotal knowledge that I have about the case. But I have certain limits involved. So my limits are to do it. I have two limits. One is to do it before March 21st. The other limit is there have to be a waiver of time limits, and I do it on either April 25th or April 28th. So I need to know what the time frame is for the department.
We'll defer to whatever I don't have an answer. I think the state is trying to figure that out right now.
The state just walked out. Where's the state going? Yeah, the judge wants to keep hold of this. He's had this all the way through, and he says, I don't want to surrender this to another judge. I want to see this through. I want to see that's the condition, the rules of her release that can make sure that she is safe and the community is safe. Bring him to me. Crazy stuff happening. I'm reading through some of the Brian Koberger previously redacted documents, some of the text messages from the surviving roommates from Dylan and Bethany. Oh my goodness. The judge in that case has basically said, I'm sick of everything being filed under seal.
I had
Public
an
has a
opportunity
right to
to
see
speak
this.
with the members of the team that are here, and they would certainly try to have it prepared before the 21st. They're just not sure if that would be possible. Would it be possible to perhaps schedule 2 dates, and then as soon as the plan was ready, they would certainly file it, but I could let the court know whether we could have the review hearing on that March 21st date or not.
Well, to have it on March 21st, which is 2 weeks from tomorrow, we'd have to have the conditional release plan filed probably by the 18th or 19th. There'd have to be time for the court to read it and digest it, as well as for the parties to do so.
I mean, the team's committed to trying to accomplish that.
Well, what we'll do is we'll set it for the hearing in the morning of the 21st. We'll have to move some cases, other files that I have, but we'll set it at 9 o'clock on the 21st. We'll schedule it for an hour at that time. I'll anticipate on that basis that the report would be filed by the close of business on Tuesday, March 18th. So it's a Tuesday. There'd be Wednesday and Thursday for everyone to read and digest the conditional release plan, and then to go forward with the hearing. If that doesn't work, the court will schedule the matter for 9 o'clock on April 28th.
Could we schedule it on the 21st for 9:30 instead of 9?
Yes, make it 9:30 on the 21st of March. So ordered. If I'm told the report, and we want the conditional release plan to be from a procedural substance standpoint, to be a good plan. If there's people are rushing it, that's not a good idea. And I want it to be done well. And so if it can't be done, I acknowledge the time frame. And so then if there's no objection from Ms. Geiser, we'd go to the April 28th date.
Well, we'll see what the report looks like.
Well, we'll see if it's here.
Right.
I agree. If it's filed on the 8th by the close of business on the 18th, we'll go forward on the 21st.
Okay.
I trust they'll get it done.
Then that's the order. The court so ordered. I did one aspect that I didn't mention in ruling with regard to the petition was it was significant that the 3 doctors who testified in the case and had recommended or had not objected to the conditional release going forward testified again today that what they saw in the petition for revocation didn't change their view. The court can listen to experts. The court doesn't have to rely on any experts. But in this situation, each of those doctors have participated in this case from almost the beginning and gave opinions when the court made its first rulings with regard to the case and found the Ms. Geiser not guilty by reason of mental disease or defect, and then went and used them, and they've testified in they've presented reports in all the other petitions for release. So they're knowledgeable, they're credible, they understand, from my point of view, they understand Ms. Geiser's psyche and background, and in particular on the issue of subterfuge and manipulation. I'm relying upon them, and I'm satisfied it's good reliance that they did not detect subterfuge and manipulation, which is important. And that certainly weighed in my decision-making process. So ordered. With that, then we've set the pattern and set the schedule. Thanks everybody for being here. I appreciate the short notice involved in this hearing. Appreciate everybody being here, and thank you all.
And I would just ask, Judge, that you order her to be returned forthwith.
Yeah, I'll order that she be forthwith returned to Winnebago. So ordered.
All right. I'll be in touch right more.
Court's in recess to tomorrow morning at 8:30.
There we go. There we go. That was it. Now I know we have to go to Thurston. Here's the thing. I've got so much stuff to do. Okay, somebody was asking about the Brian Koberger docs. I'm putting a link in chat right now if you want to read them yourself. This is everything. This is the state's website with every filing on the Brian Koberger case. You can also find them all over on Discord with lots of explanations and documents pre-downloaded and everything else. So that is also a great place to go. Deep dive on BK would be epic. That would be a lot of fun. We have to do that before it starts in August for sure. Let's see. So docs are out. 3 minutes, and Thurston's all we need. Okay, let's go to Thurston then quickly. We didn't hear the closings. We're just going to go straight to the verdict. Is that okay? If it's still there. Oops. Let me see. Thurston County Courts. Okay, 13 minutes ago. Here we go. I guess we need to do this. In a little case out of Thurston County, Washington, which is the perfect example of why you should never be a landlord, we have a homeowner charged with assault and criminal mischief of some variety against a renter, a tenant, an individual he took in he allowed to stay in his home for years without charging him rent. Things went south when the girlfriend moved in. And it ended on camera in a short altercation that included a body slam, a note that was not meant to be read or grabbed, a struggle, possible choking, and both people called the police. The jury went out. The jury came back. We're going to watch now as we jump to Thurston County, Washington. We missed a little bit of this, probably because of the court, but the jury's coming in now. So let's listen.
We will bring them in and go forward. Go ahead, go get them.
Go get the jury. We can't go without them. Yes, there was some eyeglass bending. Girlfriend did testify, but the court forgot to go live during that portion.
Yeah, go ahead. Actually do.
Or just let them say what.
Yeah, grab the form. Tell them to take the verdict form. Hold it against themselves.
Yeah.
Against itself. And the verdict.
Bring the form. Make sure it's unanimous this time. Last time we were here in this courtroom, the jury came back and returned a verdict that was not unanimous. The first person was asked, is this your verdict? And they're like, my verdict? No, no, but this is our verdict. Not mine. Mine was different. Yeah, that happened right here in this courtroom. Okay, jury's walking in. Defendant is on the far left. He showed up in court wearing sweats and a hoodie. He's the homeowner. The victim in this case, about a 70-year-old man who lived in the house and maintained it for about 3 years. The original plan was to use the house for housing of people who were homeless. The plan changed when the homeowner got a girlfriend and she moved in and said, let's live here.
You have a jury. A verdict. Hand it to me. In the case of State of Washington versus James Turner, verdict form reads as follows. In the case of with regard to count number 1, did we, the jury, find the defendant James Taylor Turner guilty of the crime of malicious mischief in the 3rd degree as charged in count 2? We, the jury, answer the question submitted by the court as follows. Were James Taylor and Calvin Malone members of the same family or household? Answer, yes. Verdict form, we, the jury, find the defendant James Taylor Turner guilty of the crime of assault in the 4th degree as charged in count 1. And according to special verdict form, that said question, were the James Taylor Turner and Calvin Malone members of the same family or household? Answer, yes. I'm going to start with each one of you, starting with you, sir, on the end. I'm going to ask you 2 questions. Are these your verdicts?
Yes.
These are the verdicts of the jury?
Yes.
These your verdicts, ma'am? These are the verdicts of the jury? Were these your verdicts? Were these the verdicts of the jury? These your verdicts? Were these the verdicts of the jury? These your verdicts, ma'am?
Yes.
And these are the verdicts of the jury?
Yes.
And then finally, are these your verdicts, sir? And these are the verdicts of the jury?
Yeah.
So I now lift all my previous instructions. You can speak with whoever you want to about this case now. Same time, you don't have to speak if you don't want to. Give this to you. You're going to go back to the jury room one last time. I'm going to ask you to wait for just a few moments. There is a reason why they call this the practice of law, in that attorneys do like to speak with jurors following the verdict. If you just wait back for just a few minutes, once they come back there, if you don't want to stay, you don't have to, but I'm going to wait and have you hold there for just a few minutes. So we're going to do a few things here in court, and then you go ahead and take them back for right now.
Okay.
Go ahead.
Wow, found guilty. He did rush at the tenant as the tenant came in the door. The tenant was mad because his girlfriend had slammed the door after the tenant went out the front door. Long story, tenant was not supposed to go out the front door because he leaves the front door unlocked. He went out the front door, left it unlocked, open even.
Folks prepared to proceed to sentencing at the moment, or are we going to reset that?
Your Honor, the state at this time would ask for sentencing to be set out to the 14th or within the next 2 weeks. The reason, Your Honor, is that this is a crime of domestic violence assault. So it's a violent crime. So my understanding of the law is that victims have the right to address the court. I specifically asked Mr. Malone if he wished to address the court, and he did express to me that he would like the opportunity to address the court at sentencing.
All right. So we'll set sentencing for a period of time.
All right. There's basically nothing else to do here.
Yes, I believe that may also be the case where there's sentencing on another case. So that was the logic behind me asking for that date. But
hang on, he's got another case?
I'm not particularly strong as to that date.
Right.
They all lived in the same house.
Give me just a second. I'm going to look at the calendar.
Domestic violence.
I believe that's the date of the
Roswell.
Yes.
What courtroom's that in? Do you know?
I do not. I can look it up.
That's all right. I got it right here.
Okay.
I'm guessing the guy's evicted now. I'm thinking he should probably be kicked out. Some would say it was wise of the victim to move from where the altercation first began into the room where the camera was located. So there was video evidence. That video was played multiple times in court, although it was not extremely useful for us because it was off the screen and we could not see what happened. Yes, he has other charges pending. Can I drop now, or do we need to stick with this?
You know what time it's scheduled to be?
Let me look at it.
I'm not seeing it. We can still set it on the. I just wanted to set it in the same courtroom, but we can still.
All right. We're going to go ahead and drop since we've got everything we need from this one. If you would look at that, the time says 6:50 on my clock, or well, actually it says 18:50, but it translates to 6:50.
So according to my records on.
I left, but I did not leave completely. We have to go eat, meaning I have to get some food. And then we have the podcast tonight at 7 o'clock. We might have a couple people on there. I've twisted Mrs. R.A.'s arm, so she's going to be here a little bit. We've had one of our mods, Josh, volunteer to be here. We might have some more. We might put out the link to those who want to jump in and say hi and just have a little fun, where there's no pressure, where it's it's a smaller audience than what's watching during the day during court. So please do know, if you want to receive a gifted membership, it helps to be here. We are going to give away some memberships. Some have already been given away. We're going to give away more, and be there tonight. It's going to be a lot of fun. I think that's it. I guess the jury saw more in the video. They must have. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tonight in 1 hour and 9 minutes. Tom Water Troy says, I'll even give a membership. Be there for that. Weatherwatch might make a cameo appearance on his own show. He's a little under the weather. But we'll give him the day off so he doesn't just completely ruin his voice. Hopefully, he can get all rested up. In time for pickleball on the weekend. So, you guys have yourselves a great evening. Thank you very much for being here. Thanks for clicking the like button. If you haven't already, you can click it on the way out, and that still gets you a pass. If you don't click it at all, you're in trouble. Just kidding. You can do what you want. Adam can show off his succulents. He can do that. Red Pen can call in. Greeners can call in. It's going to be great. Guys, I've got homemade chicken pot pie and biscuits waiting for me, so I'm going to catch you later. Have a good one. Bye-bye.